Well, hello, everybody, and welcome back to Raw Law Unfiltered with your host, the DUI Guy Plus. Today, we are going to be having a very, very special episode. Megan Fox, the writer, not the actress, is going to be joining us today as we are going to be reading together and going through the latest motion, which is the third motion to disqualify Judge DeThomasis in Levy County on the case of Lynette Preston versus Jeremy Hales. Now, for those of you who are not familiar, George and Jeremy, just the short, and not long 20-second version. They moved to Levy County. They're treasure hunters. They have stalkers who have followed them. When Jeremy said he does not like what she's doing and decided to threaten suit, she ran to the court first and said, no, 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 no. I file suit on you. You know, file suit on me. You're the stalker. I'm not the stalker, even though she's the one that moved X number of thousands of miles and followed him to Levy County, Florida. Now, since May of 2022, there's been a lot of development. She went in September. She went to file an injunction, which we will be covering on this channel as well, probably tomorrow or Tuesday. I have my hands on it as well. It is long, you guys. It is very, very, very long because I guess there's like a supplemental to it as well. I mean, it's collectively, it's almost 500 pages. So we're probably going to be skimming through a lot of it. I imagine I already got a glimpse of it. There's a lot of screenshots to social media pages and stuff like that. And here's the most beautiful thing, by the way. I want to say this. Usually this stuff is publicly available. I can, as a non-attorney, you can go to the Levy County Courthouse website and pull this information and simply use it and read it with no problems whatsoever. However, in this case, Judge DeThomasis, who is the protagonist, by the way, for this video as well, has decided to seal all of the motions and pleadings and filings. He's basically trying to turn this into a FISA court. Do you guys know what a FISA court is? I forget what it stands for exactly, but FISA court, FISA courts were created, Foreign Intelligence Surveillance Act, 1978. FISA courts is what we learned about them when Edward Snowden came out about the National Securities Agency, the NSA, and leaked that information. The problem with FISA courts is they're done in secret. You don't know that a warrant is out for your arrest. You have no idea that there is an investigation pending. Why? Because national security. Now, it sounds good, right? Because we do want national security interests to be protected and terroristic acts and all of that good stuff to be, controlled and caught before things go down. But here's the problem. When you give courts a little bit of power, there's a tendency to take more and more and more and more and more and more. And so eventually they turn into this bastardized version of just like, we want to search his computer. So just get a FISA order, FISA warrant. You don't need a prosecutor. You don't need judges literally would just blind sign them, one after another. Why am I talking about FISA courts? Judge DeThomasis is trying to turn his courtroom into a FISA-like courtroom lookalike. And this is unacceptable. This is an open court. There are video cameras in the courtroom, for God's sake. And he's trying to hide information. He doesn't like eyeballs on this case because he wants to be in a bubble in his little box that he lives in with his few hundred, supporters. And that's it. He does not like the millions and millions and millions of detractors that are coming forward. So that's basically where we're at. Without further ado, I would like to introduce my guest, Megan Fox. Hey, Megan.
Hey, Larry, how are you?
I'm doing good. How are you?
I'm good. This is such a crazy case.
What do you think about it?
Well, from what I've seen so far, I think maybe the most egregious is that he hasn't had a hearing on the merits yet in all this time. And because of the temporary injunction, he can't use his private road. And Instead, he's forced to use a road that has a really high accident rate. And I'm shocked by this. It's like, what happens if he gets in a wreck? He's filmed several wrecks on this road. It's like a high speed, dangerous intersection road, and people are always wrecking there. And the judge just doesn't care. Just doesn't care
No,
at all. And so the merits of the case, to my knowledge, they haven't had a hearing on the merits yet, right?
that is correct. Each time, I mean, I remember the fourth time she hired a lawyer just for the purpose of a continuance because she wasn't ready. The third time, I'm going backwards in time because I think it's going to be easier. There was a bomb threat. Somebody called in a bomb threat in the middle
Of
of the
course.
hearing.
Sure.
The second hearing, I think there was a lot of this judge loves the sound of his own voice.
Totally. Oh my God. I fall asleep and have to rewind and be like, is he even saying anything? And he's not. He's not saying anything.
The only time he said something of substance, I found like 4 minutes in one hearing, which was like 2+ hours. There were 4 minutes of actual content that I found that was usable, and that's why I was like, I can do a TLDR version. But we are going to go through the videos with you on your channel. What is your channel name?
It is Megan Fox Writer, I think, on YouTube. I think it is. I don't know. I'm terrible at
I
this.
tagged you. I think it's Megan Fox Writer. I'm pretty sure you're correct. And that's also your hashtag, or not hashtag, your at
my Twitter.
on X.
Yeah.
Yeah, on Twitter. Exactly.
Yeah.
So go subscribe, like her channel, subscribe to her channel, watch her videos, go on X and become a follower. Megan is a real one, you guys. She is a real G. So I'm serious.
This case is right on, like, in my wheelhouse too. These judges who get out of control and have this black robitis and like just love to curtail the First Amendment. I keep on bringing up examples of good judges to show you the difference. And like Judge Carroll in the Kowalski case is the one I keep going to. Here's this case, the Maya Kowalski case in Florida, same state, that had all this attention, and so many of us on YouTube were streaming it every day, making videos about it every day, mocking people in the trial every day, witnesses, lawyers, even the judge himself. We mocked him mercilessly, okay, for his little tuft of hair. Even so, this man never tried to silence anyone. And in fact, he even like signaled that he got the joke, that he heard the joke, he got the joke, and he's okay with the joke. That's great. That's what judges are supposed to do. You're not supposed to get freaked out because this case that is in front of you suddenly gets public attention. Okay,
Yes.
This is our judicial process in America. I know other countries don't understand it because they're very closed off. We aren't. We function under transparency.
Yes.
And so when a judge gets freaked out by public attention, that's your first indication that he's a bad judge. And someone needs to teach him a lesson. And the lesson is this. Holy shit. Now you've messed with a bunch of people who have big audiences on YouTube, and it's going to get much bigger than he even imagined. And that's what he deserves. He deserves ridicule and mockery, and you can absolutely ridicule and mock a judge. There's nothing wrong with that. Now, if you're a lawyer, you probably can't, but I can, and the rest of the...
Excuse me? Excuse me? Oh, well, hell yes, I can. Within reason, of course.
If you're in his state, you probably can't. But I mean, outside of his state, because doesn't the bar get freaked out if you're, doesn't the bar tend to...
Well, here's what I'll say on this, Megan, because I see what you're saying, and I think we agree, but we're on two different, like, maybe levels of understanding, because you're absolutely right. If you're practicing in front of this judge, let's say on a daily basis, you definitely don't want to call them out unless you're me and you think you are right and you're not afraid of confrontation, because I think at the end of the day, I'm not lying, it was a net positive for my firm. The judge that I went head to toe with, head to head with in 2020, which I finally released the video in 2022 and it became a short in 2023. I shared it recently, actually, when I had What the Hell's on my channel. If you haven't seen that, go check it out. We had a 90-minute interview. After we're done with this, go check it out. I interviewed the What the Hell's and their story, and I gave a TLDR version. Too long didn't read, too long didn't watch.
That was so good.
Oh, thank you. I still feel like I missed so much. Yeah. But anyway, so the point is, judges need to be held accountable. I'm not afraid. If I think I am right, this is my policy, Megan. If I think I am right, if the law is on my side, and if the judge is acting a fool and not following the law, I will call you out 100 times out of 100. The consequences be damned. And you want to come at me? Let's go. That's my policy.
I agree with you that I think that that's the way to do it. It's just that a lot of lawyers feel like they can't because they could be held in contempt. If a judge is really out of control, he can throw you in jail and tell you to bring your toothbrush with you to the courthouse. It's happened before.
I can't. I wish that happens to me one day, knowing that I'm right, knowing that that's going to be the best content I've ever created in my entire career.
True.
Just for the record. So.
True. One thing I would like to know about this case, and I'm actually considering putting in a public records request because I think the information that I want should be publicly available. The judge claimed, Judge DeThomasis claimed, that because of Jeremy's YouTube coverage, the court was getting hate mail. Now, this is something that they always say. Now, I noticed he didn't say death threats. He said hate mail. First of all, who cares? This is America, sir. People can email you. I don't recommend it because when you email a judge, you're pretty much just emailing the judge's assistant. So this poor girl or man has to go through all this stuff. However, he's an elected official. If you want to even send him an email and say, you're a fucking scumbag, you literally can do that. That's protected. Now, I don't recommend it.
No,
because
please
these people, no, don't. Because these people will use this and say, we're getting threats and hate mail, and they won't recognize it as free speech. So you have to be really careful when you try to reach out to someone like that and only use, terms that Mark Twain would use or Jane Austen to insult. You can still insult people without using swear words, right?
Absolutely.
But it's funny how brittle they are. And so when he said that he got hate mail, I really want to send a FOIA request to that court to ask for the hate mail. I want the hate mail because I really want to see what it is that people are saying that he considers hate speech, because there really is no such thing in the United States of America. So, and by the way, people, if you do want to reach out to somebody about this judge, the person to reach out to, the people to reach out to are the Florida legislature, because they are the ones who have the ability to impeach a judge. So they're the ones who should be getting the mail saying, why are you letting this guy run these courtrooms?
Right here. Say that one more time for the people in the back, Megan.
The legislature has the ability and the power and the right, because they are the check to the judicial system, to impeach a judge. We hear a lot about impeaching a president. 2 presidents have been impeached, 1 even twice, which is incredible. But you can impeach a judge. The thing is, our legislature hardly ever does it. In fact, I would like to look into how many times judges have been impeached by the legislature. And I bet you I could count them on like 2 hands, which is really unfortunate. But this is a power that the legislature has. So, those people are trained to take your hate mail. So send your hate mail to the legislature, okay?
Yes, and not necessarily hate. I wouldn't even, call it hate mail. I would
It's
call
not.
it.
I'm joking.
Yes, but because they're going to take our words and twist them out of proportion. What we're trying to say and what Megan is saying, and is 100% correct. If you want action to be done, you need to reach out to the people in power. And who is in power? The legislature. The legislature has the power to remove Judge DeThomasis. If you, because I have to share this real quick. This is the video I posted yesterday. So my source, which is, I don't want to reveal my source because I'm afraid that, people will get in trouble, and I don't want people to get in trouble.
This is unbelievable.
This is a 42-second video. I'm just going to play it for you all. I posted this yesterday. It's on my channel. This is what we suspect. If you listen to the language, this is why we suspect. I say we because I did not just create this theory. It's a few lawyers involved in this. We listened to this, and these are people familiar with the territory, and they suspect that this is a former judge who shall not be named because, again, I don't want to slander. I don't want to, this is not really libel, but it could be a person's name, especially if it's not them. Some people suspect it's Lynette's lawyer. Now, I've heard this a couple of times, but the certainty is not as high as I would like. So we suspect it's a judge, and a former judge, not a current sitting judge, because the key term, this is why we suspect it, just real quick before I play it. Oops, here we go. The reason we suspect it's a former judge is because he uses the magical language of call flooding. Now, Megan, this may be a theme in this case as we move forward, as more and more publicity, as more and more eyeballs get on this insane First Amendment violation type judge, the tyrannical, I want to take away your voice judge is the only way I can describe him.
Yeah.
The language that he uses is called call flooding. And you will hear in this video in just a second, like I said, it's 30 seconds, literally. Is this Mr. Foreman's strategy to call flood the system and basically collapse so we can't do our work? Oh, you know what? I'm going to file a bar complaint against Mr. Foreman. And listen to this. Listen to this. This is I never in my life. Listen. It's my answering service picking up the call.
Thanks for calling Foreman and Associates. How may I help you?
I'm watching Larry on YouTube right now, and I know his buddy Jeremy Hales loves people to phone flood. So is that what Larry?
Sorry,
also...
I had closed captioning turned off. Let me do it again.
Thanks for calling Foreman and Associates. How may I help you?
I'm watching Larry on YouTube right now, and I know his buddy Jeremy Hales loves people to phone flood. So is that what Larry also? Is that how he thinks our justice system works? Mm-hmm. Should we just phone flood the courts until they can't do business anymore? Is that his legal strategy? I'm asking for a friend.
Mm-hmm. Okay. I'm not certain about that. Are you calling on behalf of someone who's needing legal assistance?
No, I'm going to be filing a bar complaint against Larry. So tell him to buckle up. Bye.
Uh-huh. The whole thing is very, very threatening, by the way. The whole language. I'm watching Larry right now on YouTube. By the way, the phone flooding. What's weird about that accusation is that I've watched so many of Jeremy's videos, and all of them, he's like, do not call these people. Do not pick up the phone. I'm telling you about my life. I'm telling you what I'm doing. You do nothing. Don't do anything. You're not telling anybody to call anybody. When I tell people to call people, I tell them to call the legislature. And we absolutely do phone flood the legislature because that's what they're there for. That's why they're there. They're there to take your phone calls. Court systems, not so much. You don't call judges. Like that's not how it works. Judges don't react to constituents who are upset, really. They react more to media coverage than they do to constituents calling. So you don't call a judge. But you do call the legislature. But this idea of phone flooding, I've never heard you say that. I've never heard Jeremy say that. What is he? He's just making, this is a thing that they do too. They make allegations and accusations that are not true. They're not true. They're not happening. But they say them enough times that then people begin to believe that this is happening.
Yeah. Sorry, I didn't mean to talk over you, but that is the straw man argument. Let me create this called it's a fallacy in logic, right? If you ever taken logic before, you know what I'm talking about in my audience. You take this, you create a straw man. It's literally, it's a figurative and literal straw man. And you say, you are telling people to phone flood. And I'm like, no, I'm not. And let me tell you why phone flooding is wrong and why you should not be doing it, but I'm not doing it. I'm going to disbar you for phone flooding. You need to stop phone. I'm like, dude, I haven't done it. I didn't do anything. Well, I'm going to file a bar complaint for your phone flooding efforts, sir. And it's like, you're sitting there literally just like deflated. Like we haven't had a conversation. It's you talking to a wall and me talking to you.
Yeah, that doesn't make any sense. And of course, immediately threatening you with a bar complaint for speaking out about this case. Now, I'm sure that Larry and I would both agree, we don't know every detail of this case. We're just starting to get into it. But there's nothing wrong with us talking about it. There's nothing wrong with us starting to investigate. And if some information comes up along this investigation and we find that, oh my gosh, Judge DeThomasis is well within the law. And oh my gosh, Jeremy Hales is out of his mind. We're going to be like, well, looks like Judge DeThomasis is making the right calls, right, Larry? I mean, it's
absolutely
not like, so far though, from what I've seen here, I'm not seeing that. I'm not seeing why
Me
the
neither.
judge is so upset about Jeremy's coverage. I'm listening to Jeremy, who seems very upset with what's happening to him, telling people what's happening to him, showing footage from court hearings, and we can see what's happening to him.
And we're going to do that when, Megan?
Tuesday at, what did we say, 4 p.m. Eastern time?
4 p.m. 4 p.m. Eastern time.
Yeah, we're gonna watch one of these hearings with the Hales and Larry on my channel to just get a sense of what is going on here. I personally think hearing footage is one of the greatest, sources of truth, which is why it's unbelievable. I think they're still withholding one of the hearings from him. They won't release it to him.
Oh, really?
At least that's what I'm trying to catch up on his videos, and I've seen a couple now where he's saying they still won't release hearing number, I think it was possibly 3. So there must be something that happened in that hearing that the judge really doesn't want people to know about. And this is not a family court case. This is not like there's no children involved.
Nope.
There's no reason for this to be sealed. It's in the Constitution that you have a right to face your accuser in public.
Yes.
This is actually a criminal hearing for a criminal harassment thing.
Yes.
This should in no way be sealed from the public. It should in no way be secret at all. You're
Nope.
right that the judge had maybe a little bit of leeway with the deposition, although
I want to swallow those words because apparently
you?
Jeremy paid. So I want to make a
I was just going to
correction.
say, Jeremy paid for the deposition. Nobody told him he couldn't put it online.
Correct.
So sorry, like
Yes.
what?
Yeah,
If you
he owns
didn't
100% of the rights to it. Now,
right.
is it going to affect the case in any way? Absolutely not. That's really the only question you have to ask. And he probably ran it by his lawyer because that is the only way he can get a copy of the deposition. He paid for it. He said, lawyer, get me a copy and I'm going to post it on social media. And his lawyer, if his lawyer would have said, I think this is what I think, Jeremy, this is not a good idea. Don't post this one. You can post all the other stuff, but don't post this one. And Jeremy went against his advice. So be it. So what? You are not following your lawyer's advice, or maybe the lawyer was like, "Oh, post it. Everything's gonna be fine. Who cares? Don't worry about it."
It's not against the law to not follow your lawyer's advice either.
Exactly. Yeah, clients don't follow my advice all the time.
Client control is a real problem sometimes.
Yes, it can be.
Yeah. No, and so the deposition, if he paid for it and there wasn't an order in place to withhold that information until after the trial, because it's going to be made public after the trial for sure, because that's how it goes. I have a friend who's an attorney in California. That's all, his entire channel is posting his old depositions. That's his entire channel, and it's so great. And he does these, he's like teaching people why he asked the questions that he asks and how he catches these CPS liars lying. And it's the greatest thing ever. And nobody can stop him. He owns the rights to those depositions. He paid for the camera footage for those depositions. And that is family. Like it's regarding children and stuff. All he does is redact their names and it's good to go.
Yep. Exactly. But a lot of times I will say this, like mental inquest court, sometimes probate, very rarely, but sometimes juvenile court, those are all confidential and sealed and for good reason. This is not one of those instances.
Sometimes for good reason, but sometimes not at all.
Touche. You know more about it. Even I, as an attorney, I don't really venture into that
probate
arena
ones.
Too much.
For sure should never be sealed. Those cases with the senior citizens who's, their lives have been taken over by the state. My God, there's so much corruption there. There's an entire movie done by one of my friends called The Guardians on Amazon. You guys have to watch. It's unbelievable. And you'll never think that probate court should be sealed ever again.
Okay, fair enough.
People actually went to jail because of this documentary. Went to jail. So, yeah, The Guardians, go watch it.
I can't wait. Go watch it. And don't forget to subscribe, like this video. Don't forget on your way in, we have 7,500 people watching, Megan.
Are you serious? That's so exciting.
This is insane. This story is going to sweep the nation. I'm telling you, because we have a rogue First Amendment tyrannical judge. So don't forget to like this video on your way in. If you already liked it, thank you so much. comment below once this live is over. Subscribe to the DUI guy. Subscribe to Megan Fox Writer. The links are in the description. So What the Hales is in the description. You subscribe to their channel. I have my subscribe to Megan Fox Writer. It's on the bottom. I have my Tugs mug on a mug. It's like my favorite.
I love
crazy
that.
word. Tug on a mug.
Tug on a mug.
I'm giving an homage to him because he is in on this, you guys.
Yeah.
Tug has taken this and he's running with it. We're going to be live probably tomorrow, and we're going to have the Hales on there, and it's going to be fantastic. So without further ado, let's dive right in to the meat of the motion. So this is a long one, so we can break this up. I can start it off, and then at some point we will switch. How do you want to do this, Megan?
Yeah, whenever you get tired reading, just let me know, and I'll jump in.
Rock and roll. Okay. So today is what? Today is Sunday, February the 25th. So this was e-filed on February the 21st, meaning Wednesday. So this is fresh off the stove, you guys. This is absolutely fresh off the stove. Filing made on February 21st at 11:10 a.m. in the Circuit Court of the 8th Judicial District in Levy County, Florida. Lynette Preston, the petitioner, because remember, she's the one that has filed this, and Jeremy Hales, the respondent. He's the one answering to it, and he's paying lawyer fees out of pocket. I think somebody said that he's somewhere between $60,000 and $70,000 in lawyer fees already.
Oh,
it's insane because he has to defend himself.
thank God this happened to somebody that has the budget he has, because he can afford to keep doing this, and because he has said, I won't pay them a dime. You know, he's not paying his accuser a dime, so he's willing to outspend her. And thank God, because if this had happened to somebody like me, you know, I wouldn't be able to put up this kind of a fight.
I agree completely. So this is the motion that Jeremy Hales' lawyers filed. I believe his name is Randy. Respondent's third sworn motion to disqualify Circuit Court Judge George DeThomasis. Remember, they made two previous filings, you guys. Both were denied. So the way to recuse, I use the term recuse. The technical term is recuse or disqualify. You're basically asking the judge that's on the case. This is a really weird one, right? You're coming to the judge, him or herself, and you're saying, Judge, you are not fit to sit on the case because XYZ. In this case, it's bias, prejudice, and it's going to affect the judicial process for Mr. Hales. And you're literally coming to the judge and saying, pointing the finger at them and going, you, judge, are unfit for business. Please go away. And the judge has to go, I agree. I will go away. And you understand how difficult that is and why. By the way, Megan, do you want to tell our viewers about your wall?
Yeah, I have a wall of recusals. And because when I have covered court cases for a long time, especially family court, when I come across a judge like this or a guardian ad litem like this, or somebody who just a lawyer who really needs to get off the case, one of the things that they really don't like is public knowledge of that. So when I start writing, I write at pjmedia.com. In almost every case that I've started writing about, one article is all that has done it. I write one article, tell people what they've done, and the next day or two, they jump off the case. They're gone. And so this happened so many times that I started a wall of recusals, and I have an entire wall of, and I want to add Judge DeThomasis to that wall. I've decided that he belongs on that wall, and I'm going to put him there. So we'll see. We'll see what happens. But he really, here's the thing about recusing judges. If you file a motion in front of a good judge, even if that judge feels that they are not conflicted, a good judge is going to step off the case and say, yes, let's let another judge do this, because the appearance of bias is not good for justice.
Yes.
A judge who does not care about justice will dig in his heels and refuse to move because he has an ego problem, because he's very used to people standing up when he enters the room, and he likes that a lot. And he cannot admit that he has made some mistake here, whether it's because he doesn't like Jeremy, or it doesn't matter what it is. He has the appearance now, even if he isn't. He has the appearance of impropriety, and he needs to step off this case.
Exactly, says Hey Joe. Exactly. You took the words out of my mouth. Like I couldn't have said it better. Do you have a photo, by the way? I'm curious. Is it an actual wall? Do you have like a
Yeah,
photo of it? Because I want to see it. I
I
want the
do.
viewers to see it because this is real. I told you Megan is a real one.
I do. I'll have to pull it up. Let's see. It is in my bookmarks. It is the what do I call it? The wall of recusals.
The
Here it
wall of
is.
recusals. That more apt name could not be made.
Yes. And I once had the entire 21st Circuit Court in St. Louis step off of a case. The entire court, Larry.
What
In
the
fact,
hell?
it was 31 judges. That story should have been picked up by the national press, and it wasn't. Everyone ignored it. And I don't even think that a recusal that large has ever happened before. But I caught the chief judge, who actually resigned in disgrace. I caught him basically case fixing in an email.
Oh
Um,
shit.
yeah, he was promising guardians ad litem that he would help them in a lawsuit against them. Yeah, one swing, 31 judges. And if I can pull it up, I found one of my cork boards, but I'm trying to find the actual wall of recusals. I got my St. Louis one up, but I don't have the full one. I'll find it. When I find it, we'll put it up.
Find it. We'll pull it up. I want to see, by the way, how is our poll doing for you guys? Actually, before I do that, go check out the poll. It's at the top left. I'm sorry, right-hand corner of your screen. Should be right here where my finger is pointing on the screen right now. There's a poll. Go vote. It's essentially, I'm simply asking the obvious question. Do you think Judge DeThomasis is going to recuse himself? Yes, I think he will, or no way in hell. And so far, it looks like we have 3,200 votes, give or take. And as they keep coming in, so just over 3,200, 84%, Megan, of the public that has voted so far believe that he will not recuse himself and he will not disqualify himself.
Oh, I beg to differ.
And Megan is on a mission now. That's it.
I
Megan
beg
is on
to
a mission.
differ. If he
it.
doesn't, it's fine. If he will really enjoy the ridicule and the memes. Then he's going to be somebody who enjoys being ridiculed, because that's how you do it. These brittle people like this, they really hate being ridiculed.
But
And
just to be careful, we're not ridiculing for the sake of like making fun and flooding the court system.
Not the court system.
For the sake of BS. We are doing it because we want justice to be done. And we want judges to follow the law. That is not a lot to ask.
Right.
That's all we're asking for.
And if he steps off now, he can save himself the embarrassment probably of having an investigation into whether or not he should be impeached.
Is this the wall of recusals?
It is.
Oh my God, there it is. You guys check this out. Tell us about it.
This is a guardian ad litem in Washington State who removed herself from the Burkhart v. Adkins case. Or no, I'm sorry, a judge actually removed her after I reported on her behavior.
I love the name.
Sarah Royster, we couldn't find a picture of her, so we just put a rat on there. She stepped down. That was, she was a guardian ad litem at Children's Law Center in Central North Carolina who wasn't doing her job. Then we have a guardian ad litem over here. She dropped off. This is the chief judge who had to resign in disgrace, Michael Burton. He was the 21st Circuit Court presiding judge. Here are all the judges. There were 31 of them. I couldn't even fit their pictures. I couldn't even fit their pictures. They all had to step off a case. Haynes, it was Evita Tolu versus Elaine Pudlowski.
Laura Lee says, by the way, sorry to interrupt, but
no, go ahead.
Laura Lee does make a great point. It is possible. Some of these judges are so narcissistic and sociopathic, and they live in their own little bubble and world that they're not aware of the outside world and how it actually interacts with their system, because they're so used to this tiny little, like, if for those of you who have seen Bubble Boy, imagine being Bubble Boy. You know, you're raised in an environment where all you know are the four walls of your room. And the first time you get to experience life is when you put on this suit. And now he is walking around in this suit going, what is this? Like, this is what the outside looks like. And he might be like, oh my God, this is really stroking my ego. I'm loving this publicity. Because, you know, it's an election coming up in a month and a half. Did you know this?
Oh, no, I didn't know that.
He's up for re-election in April.
I did not know that. Well, that's great, because the people there, those judges' elections, by the way, can be won or lost by 1 or 2 votes.
Yep.
Because almost everybody always votes to retain instead of not. I always say no. If I don't know who the judges are, I always say no. Get them out just in case, But
Yeah.
now that people know that like this guy is ego tripping for sure, Kat, that he's somebody to vote against for sure. Get him off the bench. This is
Yes.
not somebody he doesn't have a very good judicial temperament, in my
No.
opinion.
And
Definitely not.
my sources are telling me there's a lot more to the story, and we will be okay. So coming up, let's just do this real quick. Coming up, what do we have coming up? So today we are going to be reading, and we already started. We're so distracted because there's just so much to talk about. and I want to introduce you all to Megan. I think I was on Megan's channel a couple of times. She was on my channel a couple of times. So we know of each other. We just haven't had, the opportunity to do something like this in a while. So we're doing this today. Then tomorrow, What the Hales are going to be joining us with that umbrella guy on his channel. So we're going to be on Tug's channel. Then on Tuesday, Megan and I at 4 p.m. Eastern are going to be watching the court hearings, at least a couple of them. I'm sure we won't be able to get through all, but at least one or two, and we will analyze them. Megan will provide her point of view. I will provide my lawyer point of view, etc. And then somewhere in the middle there, depending when I have the energy and the time, because you can see I also have 2 jury trials, one happening on Thursday and one happening on Friday this week. I'm trying the one on Friday. My associate is trying the one on Thursday, but I'm second sharing it with him, so I'm going to be there. So my week is very packed. So I only have Monday, Tuesday, Wednesday to work with next week. And I'm also, by the way, you guys, we got our hands on the original filing and the supplemental filing of Lynette Preston's injunction that she filed against Jeremy Hale, that the judge wrongfully sealed and said, no, you don't get to see this. And we said, oh yeah, watch us. And not only do we get our hands on it, every single one of you watching, tell your friends, share the crap out of this, because we are going to be reading this on either my channel or somewhere else. I don't know yet. That one is still yet to be determined. But it is madness. It is, like I said, collectively, it's almost, I think it's over 500 pages of the injunction. Basically, Lynette asking the court, I am being stalked by Jeremy Hale. Talk about a case of pot calling the kettle black.
And she only filed it after he filed one against her.
Precisely. It's called a petition for injunction for protection against stalking, originally filed September 7th, 2023, and the supplemental filed October 23rd. No, I'm sorry, October 30th, 2023. So I have both of those, and I'm going to be sharing the crap out of them with permission, because this one I do have to run by my source, but I do have a copy, and I have permission to do it on my channel. So that is in the future. So we have at least, including this video. Oh, and I have one more video that I'm going to be making. Almost forgot. I want to do a video specifically on Judge DeThomasis and his misconduct. So we have literally like 5 videos coming in the next 3 days on 3 different channels. That umbrella guy, Megan Fox Writer, and the DUI Guy Plus. So go subscribe to all those channels, and let's
also
read. Yes.
If any of you, sorry, one more thing, but if
Please,
any
please.
of you out there have had a bad experience with Judge DeThomasis, please reach out, because this does not happen in a vacuum.
How do they reach out to you, Megan?
meganfox.writer@protonmail.com. I will protect your identity.
Fox Writer.
meganfox.writer
Writer.
protonmail.com. You can reach out to me there. I'll protect my sources. You don't have to be public about it, but if you've had a case with Judge DeThomasis and you feel like something similar has happened to you, I would like to know about it.
Did I get the spelling correctly?
You did.
Okay, so there it is. I'm going to leave it on the screen just for a little bit if people need to write this down. But let's go. So, respondents third, remember this is number 3. They filed 1, judge disqualify yourself, please. No. Number 2, judge, seriously, please disqualify yourself. No. This is number 3. This is going to be heard on Friday. Judge DeThomasis, this is your 3rd strike request. Please remove yourself. We'll see what he says on Friday. So, For the third time, it literally leads with it. For the third time, the respondent, Jeremy Hales, moves to disqualify Circuit Court Judge Craig DeThomasis for bias. You're being biased in this case, Judge, and we're about to talk about why. Pursuant to section such and such of the Florida statute, Florida rules of general practice, and judicial administration, and other authorities cited herein, and as grounds therefore state as follows. So the general standards and principles, this is where they outline the law. Florida Rule of General Practice and Judicial Administration 2.330D1 requires that a circuit judge, to disqualify himself if a party, in this case, Jeremy Hales, fears that he or she, in this case, he, will not receive a fair trial or hearing because of specifically described prejudice or bias of the judge. So prejudice or bias, this is what they're moving for. And the same rule on section F says that only the legal sufficiency of the motion shall be determined by the judge against whom the motion to disqualify is directed. If it is legally sufficient on its face, the judge must.
Oh no. Is it just me or is Larry frozen?
The legal system works in this particular arena. The next step would be to ask the Supreme Court of Florida to remove him if he continues to say no, and the Supreme Court may agree or deny the request. When determining the legal sufficiency of a motion to disqualify a judge pursuant to section such and such, the allegations must be taken as true. So you cannot question the veracity, the validity, the truthfulness of the allegations. The standards for disqualification do not turn on a demonstration of actual bias or partiality on the part of the judge or the judge's own perception of his or her impartiality. So they don't get to decide the standard.
You know what's funny about this, Larry?
Yes.
Is that the judge is telling his excuse for dragging this out as long as he has and for putting the injunction on Jeremy, the temporary injunction. His excuse is that he has to take Lynette's story as true. And so he's taking it very seriously. And yet at the same time, though he is required by law to take this complaint as true, that he is biased, he's not doing that at all, is he?
Not at all. Not at all. And we will see that. We will see that as we continue reading the motion. So I'll keep my lips sealed because this is your foreshadowing for the day. We're going to Tarantino it. Rather, disqualification is required where the facts alleged and established, which must be taken as true, would place a reasonably prudent person in fear. This is what Jeremy is saying. I am in fear that I'm not going to receive a fair and impartial proceeding in front of you, Judge DeThomasis, and they cite a case of Klein versus JRD Management from 2015 in Florida. It is irrelevant whether the judge agrees with the facts on which the fear is based. So the Judge DeThomasis would be like, I don't agree with this. It's not enough.
Oh, well, it's irrelevant. Right.
Too bad, so sad, sucker. You know, he still has to take him at face value. It is, unless he can call out that something is I guess a blatant lie, and he can show proof in the record where this is not true. That's the only way, but they must be taken as true. It's kind of like a twisted morality in a way. So I may have even misspoke there just for a second. I don't know this because Florida rules are a little bit different than Kentucky rules. But essentially, it is irrelevant whether the judge agrees. That's a fact. It's in the motion. This is Florida law. I trust Jeremy's lawyers with the facts on which the fear is based. It is reasonableness. It is the reasonableness of the party's belief, not the court's perception of its ability to act fairly that matters. So even if the judge says, no, I think I've been acting fairly, but the party says, no, you have not, the judge has to take it at face value. The proper consideration is not whether a lawyer would question a judge's impartiality, but whether an ordinary litigant would reasonably question the judge's impartiality. The cumulative effect of events occurring within a short space of time can cause a party to have a well-founded fear that he will not receive a fair and impartial handling of the case. And this is exactly what is happening in this case over the last, 5, almost 6 months. It is not an isolated incident that warranted disqualification in this case. Rather, it was a combination of two events that lead us to conclude that the trial court erred in denying the motion for disqualification. The trial court, meaning you, Judge DeThomasis, this is reading it in layman's terms. This leads us to conclude that Judge DeThomasis made an error when he denied taking himself off the case and disqualifying himself. This is literally plain language reading of legal mumbo jumbo. All right, Megan, take it away.
All right. This motion, wait, are we on number one?
Basis of the third motion.
Third
Sorry.
motion.
Yep.
This motion is based, from the respondent's point of view, on the order entered February 14th, 2024 by the Honorable Craig DeThomasis, styled as Order on Respondent's Second Sworn Motion to Disqualify, hereinafter order, a copy being attached hereto as Exhibit 1. In the order, Judge DeThomasis denied Hales' second disqualification motion, a copy being attached hereto as Exhibit 2, consisting of 5-page, single-spaced pages. Wow, he gave a 5-page response.
Yep.
He didn't need to do that. He could have done it in one. Single-spaced pages, which took issue, single-spaced, 5 pages of single-space, wow, which took issue with the merits of the motion.
Talk
That's
about a
gotta be
big
hilarious.
FU in writing, right?
Yeah. Refuted the allegations contained therein and commented inter alia on the validity of certain allegations. In accordance with the controlling legal authority of the state in the state of Florida and this district, the 2,549 word order, this guy, has now become an independent basis for disqualification of Judge DeThomasis. If you make an order as a judge and you use a bunch of emotional garbage to write it, you are proving the point.
Yep. Exactly.
An immediate entry of an order of disqualification is required. See Bundy v. Rudd and Blaylock v. State, State v. Charlotte. Oh, there's a lot of them. And
There's a few
Wagner
of
v.
them.
State. Wow. Respondent learned of the order the day after it was issued. This is when all of the facts constituting the grounds for this third motion were discovered by him and caused him to fear that he will not receive a fair and impartial trial in this matter, as they show display of a deep-seated favoritism. Can you scroll down a little? Let's see.
Yeah.
Towards petitioner and antagonism towards respondent and respondent's counsel that makes a fair judgment impossible. And then we have a footnote. I usually like reading footnotes. Do you want to?
Yes, absolutely.
Let's read the footnote.
right
My
here.
sister puts all the good stuff in the footnotes. As stated by the Florida Supreme Court in Livingston v. State, the Code of Judicial Conduct sets forth basic principles of how judges should conduct themselves in carrying out their judicial duties. Preach. Canon 3C states that a judge should disqualify himself in a proceeding in which his impartiality might reasonably be questioned. This is totally consistent with the case law of this court, which holds that a party seeking to disqualify a judge need only show a well-grounded fear that he will not receive a fair trial at the hands of the judge. It is not a question of how the judge feels. It is a question of what feeling resides in the affiant's mind and
the petitioner of the motion's mind. Yep.
And I can't read.
I'm sorry. And the basis for such a feeling, I can't go further because, okay, a little bit maybe. Sorry. Because I know
it'll go to the
watching
next
it.
page. It's just, I can't see. There we go. And the basis for such feeling. That's
Yes.
a great quote, though. That's a great
amazing.
quote.
It's Livingston v. State. You can literally look this case up. This is what we like to call in the legal world stare decisis or stare decisis, depending on what part of the country you're from. This is basically precedent. These are previous cases with also litigants asking judges to recuse themselves. And they're citing it because it's happened in Florida before. Obviously, Judge DeThomasis is not the first nor the last judge that will ever be asked to recuse. So
I'm interested now to know if in the judge's order, if he cited any case law to back him up.
Ooh, that's a great question.
Because this is really good citation, by the way. It's a well-written motion. They're backing up every claim they're making with law. And that's important.
Paula with Common Sense says, Larry, don't forget Preston's attorney, which is Lynette Preston, is DeThomas's best buddy.
That should be enough right there to disqualify him because the lawyer on the case has a personal relationship with the judge.
Agreed. And he's there on the limited basis, if I remember correctly. He stated on the record, I'm here for the sole purpose of, the sole purpose of assisting with a continuance, and then he's going to withdraw. And I believe he already filed a motion to withdraw, or maybe it was Feather. I can't remember. But anyway, please continue.
All right, let's see. You have to scroll up a little. I think we were
Apart.
on. Oh, that's where we're starting at 4. Okay.
Uh-huh.
Apart from the order's volume and word density, that's a good one. The order provides numerous other grounds set forth herein, including those belied by the record, which warrant disqualification of Judge DeThomasis. For the reasons set forth herein, Judge DeThomasis's excessive self-indulgent order, nice, tell him, entered in contravention of the prescriptions contained in Rule 2.330, has exacerbated Respondent Hales's well-founded fear that he will absolutely not receive a fair trial before Judge DeThomasis, and a successor judge must be assigned to my case. Although this is Hales's 3rd disqualification motion, the prior 2 were denied, and no judge has been disqualified in this case. Judge DeThomasis's refutation of the merits of the motion is an independent basis for disqualification. Yeah, that's true too. Like they just his emotional refutation alone should be enough.
Yep.
You can keep going.
Okay. I will continue from here if you don't mind. Or no, actually, you keep going. Keep going. It's continuing. Go ahead.
All right, so keep going down. Okay, there we go. When a trial court looks beyond the legal sufficiency of a motion for disqualification and attempts to refute the allegations, it exceeds the proper scope of inquiry, and disqualification is required on that basis alone. So, like, if you feel the need to defend yourself, you're biased. Goodbye.
Yep.
Goodbye. Regardless of the correctness of the denial of the motion as legally insufficient. Bundy v. Rudd, Blaylock v. State v. Charlotte, Department of Children, and JR v. Department of Children and Families, State v. Wagner. Most recently in Manuel versus Estate of Manuel 367, the court The court dispositively held, you can go a little more, there we go. When a judge has looked beyond the mere legal sufficiency of a suggestion of prejudice and attempted to refute the charges of partiality, he has then exceeded the proper scope of his inquiry, and on that basis alone established grounds for his disqualification. Our disqualification rule, which limits the trial judge to a bare determination of legal sufficiency, was expressly designed to prevent what occurred in this case, the creation of an intolerable adversarial atmosphere between the trial judge and the litigant.
Oh, that language. Intolerable, adversarial atmosphere between the trial judge and the litigant. And we will see exactly how it plays out on Tuesday on Megan's channel at 4 p.m. Eastern.
In this case, Judge DeThomasis' 5-page, single-spaced, I like how he keeps repeating single-spaced, order denying Hales' second motion to disqualify far exceeded the scope of proper inquiry and is in direct contravention of Rule 2.330, which states, if any motion is legally insufficient, an order denying the motion shall immediately be entered. No other reason for denial shall be stated, and an order of denial shall not take issue with the motion. Wow. They got him on this one. The allegations in Hales' second disqualification motion, which resulted in his well-founded, objectively reasonable fear of not receiving a fair trial by Judge DeThomasis, were based on the judge's prejudicial conduct and gratuitous derogatory comments directed to both Hales and his counsel at the hearing on January 23rd, 2024, and were indeed legally sufficient. Nonetheless, instead of entering a 4-word order stating denied as legally insufficient, in conformity with Rule 2.330, Judge DeThomasis crafted a 2,549-word order in which he took the opportunity to attack all 3 of Hales' attorneys. Wow. As discussed infra, the context of those comments in this record demonstrate confirmation bias, which is the well-documented tendency once one has made up one's mind to search harder for evidence that confirms rather than contradicts one's initial judgment. See Yerkes v. something
School
of
Board
Broward
of
County.
Broward
School
County.
Board. Okay. I'm like not used to that.
So this is literally, I just had the thought and I lost it. The harder evidence, confirmation bias. This is literally the point number 10 is it's a case law talking about confirmation bias. Once I believe something is true, I'm just going to find ways to reiterate why it's true.
Right. Right. Despite the judge's bare contention that he was not passing judgment on the truth of the facts alleged, he did so. For example, Judge DeThomasis took issue with the Hales' very assertion that, as a result of what occurred during the course of a non-evidentiary hearing on January 23rd, Hales had a well-founded, objectively reasonable fear of not receiving a fair trial before Judge DeThomasis. Paragraph 9 of his order, oh my God, 9 paragraphs, however, directly disputes, at least, directly disputes Hales's fear, stating any objective review of the proceedings held on 1/23/24 would not cause a reasonably prudent person to fear not receiving a fair trial. Oh, I disagree, Judge. I object. I watched some of these hearings and I watched you interrupt his lawyer, interrupt him, and let that woman say whatever she wanted to without interruption. Garbage. This is garbage that he's saying an objective view of these proceedings would not cause a reasonably prudent person. I think I'm reasonably prudent. Are you reasonably prudent, Larry?
I mean, only on Wednesdays.
This is silly. The remainder of the paragraph then attempts to justify the court's conduct toward Hales' attorneys with vague accusations of their unacceptable behavior contrary to law, and which includes a pejorative reference to a collateral matter concerning Attorney Feather that was dealt with by the chief judge and intended to be outside the purview of issues for consideration by Judge DeThomasis. Wow. So he actually pulled in a situation he knew about that he shouldn't have brought into the case to insult the attorney.
There's a lot more to unpack there. I don't want to spend too much time on it, but essentially there's a judge, Judge Mosley, I believe, Judge Mosley, who has a phenomenal video on YouTube on their channel. It's like the 8th Circuit, Judicial Circuit of Florida YouTube channel. They only have like 200 subscribers, but he created a video during the pandemic about Zooming, and it's the parody of the Hallelujah, and instead of Hallelujah, it's I will Zoom, yeah, I will Zoom, yeah, and like he changed all the lyrics to make it. It's hilarious. The dude is also a real one. But somebody, and he has to do his job, somebody tips Mosley off. We don't know who. Nobody knows who tips him off. That you need to take action because Feather got a copy of a redacted and an unredacted. He got 2 copies of the same hearings, and they're exactly the same. So the redacted versions cost a little bit more because the clerk has to sit there and watch and redact any portions of the video. So we know they're exactly the same because the length to the second is unchanged in both videos, both the redacted and the unredacted. Well, if I understand correctly, and I may be misspeaking here because it does get a little complicated, and even for my taste, the Judge Mosley is tipped off that Mr. Feather, who is Jeremy Hales' former attorney, has posted an unredacted version of the video on Hales' YouTube channel. And now he's in trouble. He gets sanctioned and he is fined $500 orally for doing this. Now,
the attorney?
Attorney, Mr. Feather. Mr. Hales' former attorney, the one that withdrew on Wednesday.
Well, who gave him the unredacted copy?
The clerk of court.
So that's the court's fault.
But there are rules. There are rules in Florida that if you publish, but here's where it gets twisted. If you publish phone number, it's designed to protect what? Phone numbers, social security numbers, addresses, workplace addresses, that sort of thing. You can look it up. If you post that sort of stuff, that's what it means, the unredacted version, then you're in trouble. Then you really are in trouble because you are now making public very, very personal and private information. And that was Mosley's order. But then he was like, all right, in a written order, he said, you know what? I'm waiving the $500 fine. So just don't do it again. And we're watching you for 1 year. So now he's on probation. Mr. Feather, Mr. Hales' former attorney, is on probation for 365 days. Anytime he requests a tape, they're watching him like a hawk. and he has to go through like several hoops. Like, I promise not to do
What
this.
was the actual thing that wasn't redacted that was so
One of the hearings
upsetting?
that they got that
No, but I
posted
mean,
on
what was
Jeremy's
the
channel.
information they didn't that wasn't?
That's the thing. That's the thing. Now you're on the money. So Judge DeThomasis takes this rule and bastardizes it. He bastardizes Mosley's order and says, and now he takes it out on Randy, excuse me. He takes it out on Randy, which is Jeremy's current lawyer. And you can hear it. We'll hear it on Tuesday on your channel. He goes, wait a minute. You are responsible for Feather's misconduct. And he's like, wait, whoa, what the hell? I'm not even, what are you doing? He's attacking current lawyer based on past lawyer's misconduct, allegedly.
Oh my
which
goodness.
wasn't even misconduct. It was just
a mistake.
It was a mistake. But no, it wasn't even a mistake. That's the thing. It wasn't even a mistake. The Judge Mosley, I think he made, I don't know if it's an error or a misunderstanding, but the redacted version and the unredacted version are exactly the same. Again,
they're exactly the same. Then you can't say that one is redacted and one is unredacted.
Exactly. And
what?
that's why
So
Feather
wait, are you telling
only got a slap on the wrist.
This is just sinking in. Are you telling me that the unredacted copy had no extra information in it than the redacted copy?
Correct. It's the same to the
That's
second.
ridiculous. That's ridiculous. That's absurd. They can't actually. You can't hold someone sanction someone for that.
And that's why his sanction is slap on the wrist and we're watching you for a year. And
that's
the $500 fine, he withdrew and changed his mind and said, okay, you owe us $0 fine. Yep, when in the written order.
Who made that decision? Mosley? The chief judge.
Judge Mosley.
I'm looking at his picture right now. I just pulled up all the circuit judges there to see, like, look, there's all these judges in this district who could take this case. There's all these judges. I bet they're not all busy. Somebody else needs to take this case and prove to us that this circuit is not totally corrupt. Because this is crazy. But I'm not liking what I'm hearing about Mosley so far, and he's the chief judge.
Well, he's a good one. From what I hear,
is he?
My sources tell me he's a real G. I don't have a single bad thing to say about him.
Well, then why would he slap sanctions on a lawyer?
He was in a bind. And again, I don't even know if I would call them sanctions. They were almost sanctions. And it's like a reprimand.
Or probation anyway. If
it's
you're
a probation.
Saying we're watching you for a year for sharing an exact same
Anytime
copy.
He goes to the clerk of court in Florida and says, I would like a tape. So when Feather is like, Ms. Clerk, I want a copy of my last hearing, he has to jump through extra hoops that other lawyers don't have to. That's his punishment.
I wish that Judge Carroll was as sensitive to lawyer misconduct as this guy seems to be, because Judge Carroll sure let those J-Hatch lawyers get away with lying to him in court and not producing things in discovery that they should have. If you want to talk about lawyers who deserve sanctions, it's those J-Hatch mother effers, and nobody ever did anything to them. Isn't it weird how judges are just different from
Humans?
Circuit to circuit, you know,
and circuit to circuit. Yes.
Yeah. I mean, it's strange what some judges determine is sanctionable or enough to put somebody on probation for. This just seems like a miscommunication. Anyway, sorry. Where were we?
Number 13.
Another obvious example of the court impermissibly challenging the allegations in a disqualification motion is found in paragraph 9A of the order, which directly addresses and refutes paragraphs 11 and 12. Oh, we've got now a minimum of 12 paragraphs of Hales' second disqualification motion. That the averments, what is that word? That the averments
contained therein are illogical. Averments is like a negative term to like allegations, I believe.
Okay. That the averments contained therein are illogical, irrelevant, and inconsequential. Yeah, those are
averments are positive statements of fact. I'm sorry, positive statements of fact, especially in the legal pleading. Yeah, there you go.
Okay. Constituted impermissible commentary on the validity of the allegations in the motion. It further shows that the judge misconstrued the nature of an argument advanced in the alternative as being competing hypotheses. As stated in Manuel and equally applicable here, the trial court's impermissible rebuttal of each allegation of the motion to disqualify was not cured by a threadbare qualifier, that it was not passing on the truth of the statements contained in the motion. Additionally, in confronting the allegations of Hales' motion, Judge DeThomasis's order broadened the scope of consideration to previous court events and filings in what appears to be an attempt to validate his disparaging and accusatory comments directed toward Hales's attorneys at the January 23rd hearing. And then we've got a
Let's
footnote.
read the footnote.
Hopefully it has the disparaging comments. That would be great. There it is. This audio video recording referenced by incorporation herein and is made available by the court by the 8th Judicial Circuit. Oh, so it must be on tape. So
Yeah.
they attached it or whatever.
Well, they're referencing it, and I think that's the one we're going to watch on Tuesday. That's part of it.
Cool.
And this is, I believe, this is the statements that Judge DeThomasis, when he starts going off and saying, basically, you are responsible for Feather's misconduct, the previous lawyer. That's what I think this is. So you see, 12 and 15 are very tied in together.
Okay. Are we at 15 now?
These apparent root causes of the judges.
You got to scroll up, back up.
Scroll up.
I mean, or down, up. Go back to 14. Or I think I'm on 14.
No. We're reading. So you said towards Hale's attorney at the January 23rd hearing, these apparent root causes of the judge's bias.
Sorry.
Yeah.
These apparent root causes of the judge's bias against Hales's counsel permeate virtually every single paragraph of the order.
Permeate every single. Listen to this language. The judge's bias is literally shining through in every word he writes of every paragraph of the 5-page, single-spaced, nearly 2,600 word order. Doesn't get much better than this, folks.
No, it does not. I can't wait to read his order, to tell you the truth. Do we get to read that? Is it?
I can ask for it.
Judge DeThomasis, I think it's attached to this. It said they attached it. Judge DeThomasis's order does not consist of mere reports of perceived unprofessionalism, but instead summarily, repeatedly, and inappropriately condemns all 3 of Hales's attorneys, including 1, Attorney Feather is not worthy of belief because of what the court perceives as a misrepresentation made by Feather on 11/29/23 as to why Hales was unavailable on November 30th, 2023 to conclude his hearing that did not finish the day before. 2, Attorney Feather's violations of certain administrative orders addressing video recordings of court proceedings promulgated by the Florida Supreme Court and the 8th Judicial Circuit justified Judge DeThomasis's repeated and hostile open court accusations of misconduct, notwithstanding.
There it is.
That Chief Judge Mosley was in charge of handling this matter. 3, Attorney Inkles? Inkles?
Maybe.
Attorney Inkles misrepresented to the court's judicial assistant the nature of her submission of a memorandum of law containing case law analysis as being nothing more than electronic copies of cases. And 4, Attorney Shockett conducted a video deposition of the petitioner without complying with Florida Rules of Civil Procedure 12.310 and in contravention of the applicable rule because he failed to include the actual name of the videographer. Oh, come on.
It's a technicality that doesn't even matter.
We
and
call
he's
that
like jumping on it like a hawk on a rabbit, just like,
That's a Scrivener's error. You don't get held accountable for a Scrivener's error. My God. In his notice of taking video deposition pursuant to subpoena duces tecum, as such, the court deemed itself justified in denying Shockett the ability to play portions of petitioner's video deposition to demonstrate that it was petitioner's erratic, dilatory, and evasive conduct which necessitated more time being required for Shockett to question her, which the court denied outright, even though petitioner impermissibly used this is my favorite part, used the Fifth Amendment to avoid answering questions, which you don't do in civil court unless you want the judge to just go, okay, you're guilty. Right?
Yes.
You can only use the Fifth Amendment in a criminal case
and
because
not only
your liberty is at stake.
Megan, it's beyond that. That's the first layer. You know what the second layer is? She's the petitioner. She is not the respondent. She's the one filing the damn thing saying he did this and this and this. Okay, tell us what it is. No, I'm not telling you. I'm not telling you nothing. I don't tell you nothing. No, tell us what he did. I don't tell you nothing.
I plead the fifth. What kind of attorney allows his client to do that? That's insane. It's insane. This is not how court works. This is not how any of this works. I'm seeing that Facebook video or that commercial of that grandma with I'm putting my things on my wall, and her grandchildren are like, this is not how any of this works. this is exactly how I'm feeling about this right now. It's like, oh, ma'am. No, accusations concerning abuse of discovery, however, are not a proper basis for a decision as to the rights of parties. Rothschild v. de Gasperi. It
What
is
the
noteworthy.
hell's going on here? I love this comment. Thank you, Butch and Lucy. Go ahead, Megan. Sorry, I had to
It
highlight
is
that one.
noteworthy that the majority opinion in Manuel v. Estate of Manuel Supra was authored by Judge Sicklin, who expressed the very same concerns in what had been a dissenting opinion just 2 years ago in M.D. Parker Associates v. Connor. A trial judge should resist all temptation to become indignant
Ooh.
and should promptly and succinctly rule on the motion in a few words or less, communicate nothing further, and move on. I
Whoa,
love
whoa, whoa.
these citations.
Read that again. Read that again.
A trial judge should
Mhm.
resist all temptation to become indignant and should promptly and succinctly rule on the motion in a few words or less, communicate nothing further, and move on.
That is a case from Florida 4th Judicial District from 2022 that basically is literally saying, Megan, if I can read it in context of what's happening here, which we're about to read anyway, but I can already see the future as my lawyer brain kicked in. It's basically literally saying, Judge DeThomasis, your 2,600 word, 5-page single-spaced order should have been 5 words
5 words.
on one page.
One sentence on one page.
Sentence, single-spaced. And by virtue of you not doing that, you're already in violation of the law of Florida.
And also, can I got to point out, again, I have to bring up Judge Carroll.
Please.
If you speak about a judge with a good judicial temperament, you could not find a better example than Judge Hunter Carroll. This man took so much crap from these attorneys in front of him, and you could tell he would get up, he was about to get angry, and he would go, I need a 5-minute break. And then he would get up and leave the room. And he never once lost his temper in that courtroom, not
Wow.
once. And there was so much stuff going on where he really could have blown up, including attorneys on the defense staring him down like with murder eyes, where he even pointed it out and said, do not look at me like that. Like, do not look at me with that tone of voice. This judge was under a lot of stress, and he never cracked. He kept his composure. He took a break instead of like losing it on some attorneys and like, embarrassing the judicial system. He would just get up and walk away. That is a really good example. It's a really good example of, who else did that was the judge in the Darrell Brooks case. She was under an intense amount. Case. That man could try the patience of Job, and she never lost it either. She would just get up and say, I need a break. And she would leave the room. And that's what you're supposed to do as a judge, right? And your same thing with your orders. Yes. You're not supposed to show an ill temperament in your orders either. Absolutely, because that's bias. That's bias.
Yes, that by itself, his order. I mean, the lawyer already mentioned it in this motion. The fact that the judge went out of his way to write this insane motion is in and of itself showing how biased he is, because he's clearly already in violation of the law.
What's funny is that with the time it must have taken him to write that order, he probably could have just had the evidentiary hearing already, to find out like what's going on here.
Real quick. Oh my goodness. We have so many super chats. I will come back to the motion in just a moment, because if I don't do this now, we will never be able to. So, okay. The Fluffy Cat. Thank you for joining on as a member. Welcome to the channel, the DUI Guy channel. Lori Monroe, thank you so much for your donation. Jay Selman Jays. To date, he says all court dates been posted added on What the Hales. So I think he's trying to say that they have information on What the Hales channel, which is what we're talking about right here. So they have all this information as well. Juliet Morgan says, what time will the live be tomorrow? We don't know yet, but it'll probably be in the afternoon. I would say sometime after 4, 5, or 6 p.m. Eastern, give or take. So be on the lookout for that. And then Tuesday, 4 p.m. Eastern, Megan and I are going to be on her channel, not here. We're going to be on her channel, okay? And we're going to watch the court hearings together and comment on them live. Tony 2A, also welcome to the channel. Thank you for becoming a member. Suzanne Parrish, oh my goodness, coming in hot. You are the real deal. I'm assuming she's talking about Larry and Megan. Thank you for fighting for all of us. JNG, Jeremy and George, are such good people. That seems to be the theme of this case. Good people fighting evil, and that's what we're all about. That's what we're here for, fighting for the little guy. If nothing else, to at least create content and put the word out there and maybe something more in the future. Frankie H, thank you as well. I have been a fan of What the Hales for many, many years. What these people are doing to him is downright dirty. There it is, literally bouncing off the previous comment. Exactly. Linda Milborn, thank you as well. Jeremy and George deserve justice and will never have it as long as DeThomasis is on the bench. I couldn't agree more. Brian Watkins says, Larry, are you worried? Oh my God.
No, I can answer this.
Worried about the ethics complaint? The judge said he was going to file on you when he called your office. First of all,
Larry is praying for this ethics complaint to be filed. This is content, folks. Content. Larry's going to monetize the shit out of it. Okay.
Number one. Number two. Okay. There are threats. There are actions. And there are actions with consequences, okay? So threats and actions, what do I mean by that? Threats of filing a bar complaint and filing a bar complaint don't scare me at all. You know what scares me? When I actually feel that I may have made a mistake and I did something wrong and somebody comes after me for it. Then I would be shaking in my boots. If you see me smiling and laughing and Megan laughing at your comment, you can tell I have zero fear.
Do you know what I did when I saw that? I started laughing out loud. I was like, oh, he has no idea what he's just done. Hashtag buckle up.
I forgot to oh my God, I'm such an idiot. I forgot when I posted on hashtag buckle up. This is our motto here. Let's
get it trending, folks. Hashtag buckle up.
Hashtag buckle up. Is that because it was in the voicemail? No, I'm going to be filing a bar complaint. Buckle up. Hashtag buckle up. There it is. Hashtag buckle up. If we get this trending on X, I swear to God, people are going to be like, what is this? Hashtag buckle up is the new hashtag because they're now. Here's why, for those of you who may be lost. I talked about this on my channel. Megan talked about this on her channel. There are going to be more lawyers doing this. Maybe Danny on Direct. Yeah. Maybe Law Talk with Mike. I'm hearing things on the grapevine. The civil rights lawyer.
Legal Vices just saw it on Twitter and he was like, "What?"
and then what's Tug, that umbrella guy? He's going to be doing a video with me tomorrow, and then he's going to do What the Hales is, and he's going to do his own video, I'm sure, at some point. So everybody's jumping in on this. Because this is what you don't do. This is what you don't do. When a lawyer, when an outside force is using his First Amendment right to talk about a subject, which we are it's in the Bill of Rights, 1779, right? When the original Bill of Rights was signed.
Look at you pulling out the dates. You're absolutely right. You're absolutely right.
Freaking lawyer over here. Like you sound like a lawyer.
Fantastic.
And somebody, while you are live, first of all, I think the attempt was to interrupt and scare the shit out of me because I was live from 2 p.m., Megan, from 2 p.m. to 2:19 and 57 seconds p.m. That's the exact time frame I was live. You know when the call came in? 2:16 and like 30 some odd seconds. In this period while I was live, right short before it was over. And again, we suspect, based on the sources that I have who know these people, who have listened to that voice at least 10 times before they rendered their opinion, because I don't know these people. And they said, we suspect it's a former judge. And we went back and forth and they're like, I think it's him. And I think it's him. And I was like, okay, well, how certain are you? And they're like, very, 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 very certain. Why? Because the keywords that they used in that voicemail is, or the message to my answering service is call flooding.
That's
and
actually
is,
a phrase I've never really heard before.
That's
Where
DeThomas's
does
phrase. It's a DeThomas's key phrase.
Oh, he uses that.
And he said, I'm asking for a friend.
Okay.
I'm asking for a friend.
Interesting.
So it's like a judge, I'm asking for a friend, and my friend is Judge DeThomas's call flooding. That's how the lawyer and myself and other lawyers who have looked into this have concluded it's got to be a former judge who's a buddy of Judge DeThomas's. It just made sense. And so, and then at the end, when he's like, you know, I'm actually kind of saddened he didn't use the words "buckle up, Buttercup," but that would have been the next level.
That would have been funny. Was there a
Buckle up.
Did your answering service record the incoming number?
It was an
Oh shoot, we're losing Larry.
unknown blocked. Oh, did I freeze?
Yeah, I think you just said unknown blocked number.
Unknown blocked number. We don't know who it is. I don't know how to trace it back. Please don't ask me. I don't know. I wish I could get it. If I can still find out somehow, I will. But let's keep going through these. I can't move fast enough. Brian Watkins.
I'm gonna run get coffee. I'll be right back.
Please do your thing. I'm gonna. Yep, there we go. Okay. I'm gonna mute you. Okay, Larry, are you worried about the ethics complaint? So we just covered that question. No, I'm not. Absolutely not. Don't care. Please bring it. Lady Tammy, thank you as well. Larry, get that contact information to Jeremy so he can give it out on his live tonight. Get that contact information. Oh, you mean Megan's email. So if somebody can forward it to him, that would be great. I will do it if I don't forget after this live, because we're going to be here a while, folks. This is only the beginning. Carolyn Williams, thank you for joining on as a member. Welcome to the channel. Fighting for First Amendment rights here, folks. I have a feeling I may not be the DUI guy for very long. And I mean, like doing DUI work. I may traverse into the realm of First Amendment law, because I'm really passionate about it. I love it. It's really fun stuff. I have saved YouTube channels, you know, like some of you who may know Mandu, if you know Mandu is the real deal. He got like 63, I think it was, or like, let's just call it 69 because it's a sexy number. You got 69. All right. Giggity goo. You got 69 copyright strikes on his channel because he was streaming hearings from a Louisiana parole board. And they were like, this is our content and you're stealing it. And he was like, but I'm modifying it and I'm commenting on it. And he said, I don't care. We will shut you down. We will kill your channel and you will die the painful death of 1,000 razors. And he called me and I charged him like $200 or something, just as I should have done it for free in hindsight. But I was like, I can't justify, you know, my time. I got to get something for it. So he paid me like $200. And I saved this channel. We won every single one of the six. Actually, I think it was 72 because they had it like 9 more. They added like 9 more. And I successfully saved the channel. I will take the credit because that was my doing. I told him what to write, how to write it. And now sometimes he consults me. He's like, the other day, he was like, Larry, somebody's using my content. Should I try to like copyright strike them? And I was like, fuck it. You're getting free advice, free publicity, man. Leave it alone. Leave it alone. Let them have it. They're getting crumbs. You're making the real money. They're getting the crumbs. Let them get the crumbs. Don't be a copyright cuck. You know what I'm saying? Don't be a copyright cuck. And I'm guilty of this myself in the past. I will freely admit, and I will never, I will own my shit 100 times out of 100. Back in like 3, 4, 5 years ago, when I was just learning the game, somebody would like steal my content and copyright, steal my channel. And I would be like, you know, a copyright strike. And they would be like, no, please don't do this. No, I don't know. And I was like, fuck you. You know, you're stealing my stuff. I learned better. I understood that is the wrong way to approach the situation. And actually, all you're doing is giving more publicity. Think of Russell Peters, the comedian. Somebody was like streaming his stuff on YouTube, you know, and he exploded because of YouTube. And he didn't realize it. He like attacked the person and he suffered for it. All he had to do was just own it. And sometimes we don't know what we're doing until we realize. And once you learn, there's no looking back and you follow through. So James Fender, thank you for your generous donation. Michelle Natal, Lynette's depot. My mother died. My mom didn't die. Yeah, she lied. I've heard about this. So she contradicted herself literally within the same depot. her mother passed away. No, she didn't pass away. Subi Sue, welcome back to the channel. Thanks for all you do, DUI guy. Much love to you as well, Megan. I will tell, if I don't forget, to mention it to her when she gets back, unless she's hearing this. Subi Sue, again, member for 14 months. Wow. That is a long time. You got some love from Subi Sue, Megan. She said, much love to you, Larry and Megan.
Good to see you, Subi Sue.
She's a staple of the channel. She's been with us for over a year, like since the Johnny Depp trial.
Awesome. I love those loyal fans.
Oh, love them. Love them. And now we have like half of this audience is like from What the Hales and the internet. It's glorious. The way that this is, there was another gentleman I saw yesterday. His name is Ray. He goes by Ray Bone Crusher on YouTube. He's got like 5,000 subscribers. You guys, every single one of you watching right now, you know how insane it would be if every single one of the 10,000, we have 10,000 people in here, Megan. If every single one of the 10,000 of you quietly goes, I want to share his channel. Don't tell him I'm doing this, okay? To all 10,000 of you, don't tell him I'm doing this.
That'd be so fantastic.
Rain Bone Crusher. I don't know who he is. I've never heard of him. I never met him. He is a real G. He's a real homie. He made a video and he posted it yesterday. He got 10,000 views. He's got 5,000 subscribers. How insane would it be if you guys go on his channel and subscribe to him? I'm going to share. Right now. This is the video. This is his channel, Ray Bone Crusher. I don't know if you can see it on your screen. Ray Bone Crusher. He was like, look at this guy. Look at what he said. And he literally shouts me out. I'm just going to play like 30 seconds of it.
All of you that have followed me lately know that I've been posting opinions on what's going on.
Let's get him to 15,000 subscribers.
Foreman just got through putting something on there, and you're going to be interested. And I really hope you
He's so cute.
Isn't he
please
the best?
Go look at his channel. Larry Foreman, the DUI guy.
Look at this.
Make it capital D, capital U, capital I guy. He's gonna bring up, he is a lawyer. I think he lives in Kentucky. You're gonna be interested in what he has to say. One of Judge DeThomas's video, he went over it and curtailed it. This is gonna light a fire, people. If this don't go across the United States, nothing will.
I love him. He's like everybody's grandpa. I just subscribed.
Look
at him in his garage. I just love him. I love him already. I just subscribed.
Me too. Here, I'm going to do it right now, live on my channel. Subscribe. Let's get him to he's at 5,000. Let's get him to 15,000. Just secretly, he's gonna like check his subscribers and he'd be like, what the hell happened here? He deserves it. He's a real G. And I swear to you, the only reason I found out about this is because I have notifications like on Google turned on. So anytime I have like somebody saying the word DUI guy anywhere on the internet, there we go. See, he wrote the DUI guy.
He wrote it, so it popped up. And look how cute he is in his little garage. I love it. I love it so much. This reminds me of my grandpa. It's so cute. I love him.
He's the best. He's the best. Go subscribe to him. This is incredible. If he gets to 15,000.
Oh my gosh, he's already up. He already went just now from 5.6 to 5.75.
5.79 already.
No, 5.81.
5.81.
5.83. Come on, guys. Keep going. Keep going.
God.
Keep going. This is awesome.
Let's do this.
5.86. 5.86. 5.88. Oh, this is fun.
This is incredible.
I love this. 5.9. Let's get him over. Look, we're headed to 6. Do I hear 6? Can I hear 6?
This is the sexiest thing I've ever seen in my life.
No, 5.97. We're almost at 6. 5.99. Oh my God.
He's at 6,000. He's got to 6,000. Ray Bone Crusher 4516 on YouTube. That's his @ If you just search for Ray Bone Crusher, go subscribe to him. I literally found him on complete accident last night before I went to bed when I got that notification. Let's get him to 10,000 before this video is over. 6.16 already. You guys keep going. We're going to get back to the video of the reading of the complaint to disqualify Judge DeThomasis, because I know that's what you guys are here
We'll check back
for.
in with Ray Bone Crusher in a little bit. I'm dying to see how fast that goes up. You know what's great?
100%.
You know what's great, Larry, about all of
Yes.
this? Like, this is the second time now in a very short period of time where LawTube has come in crashing together with another like community on YouTube and has made a big difference. And the last one was the case that I picked up, the Bachelor case, former Bachelor accused by a false accuser. So Bachelor Nation was like all talking about this, but that's like a closed kind of community. But then
Yeah.
Law Talk with Mike got a handle of like got a hold of one of the hearings, and then I found it, and then then Tug found it, then Legal Vices got it, and like it blew up, and now it's actually national news. And it became
Wow.
national news because LawTube got on it. And like this is going to happen in here too. And I really love to see this because it actually shows that we are doing what we're doing actually makes a difference in some of these cases of injustice. And
Yes.
I'm so excited about it.
Yes, me too. Me too. I forgot that I was doing super chats. They're coming in faster than I can read them. So I'm going to try and zoom through as many as I can, and then we'll come back. So Gina Hampton Dukes, because I don't want to leave you guys hanging. Is Hale's previous lawyer Feather accused of Lynette by bribery, the same who tried to defend Boone? I don't know the answer to that, but Feather is the previous lawyer. That's his name. That's his last name. Kate says, please see today's post on Jeremy's community page. I think it was like a text message from allegedly Lynette. Go check it out. Lily's, because I looked at it while Megan was reading. Lily Smith, Megan, you need to give us contact info and total background information you have like you did last time, which we will do again. We did it previously. We'll do it again. I think this comment came in before that. Debbie Childers, thank you for the super sticker. Very generous of you. Thank you so much. Stephen Dobrin, Megan, what is the name of your California lawyer friend's YouTube channel for depositions?
Sure, it's Caps and Stems Law, Caps and Stems Law, and that's Sean McMillan. He is a superhero lawyer. He is, and don't take offense, Larry, but he is my favorite lawyer because
that's it. You're gone. You're done. We're done with the stream. Megan, goodbye.
It's because he does these cases where CPS corruption is just so bad, and he sues the state and wins millions from them, and he's on a mission, and I just adore him and I adore his work. So go check him out, subscribe to him too. Caps and Stems Law. Caps and Stems Law. How do you spell that? CAPSNSTEMS. Wait. Yeah. Law. Thank you for that, Megan. And thank you for your generous donation. Fatboy TW78 says, this feels like the court wants to create precedent with which to attack new avenues of free speech afforded to us by the internet, since they cannot control speech directly in America. 100% agree. This basically seems to be like the only motivation we can think of as to why Judge DeThomasis is acting the way he is. 10,000 people watching the GOAT of law. Where? Who is that? Where are they? I don't know who they are, but I'll take the comment. Boyan. Oh, this is my shorts maker. Boyan is all the shorts you see on my channel, by the way, from like March of last year to today. So 11 months worth, or soon to be a full year. We got to celebrate. We have to do like a 1 year celebration of short content making. This is the guy. This is literally the guy. This is he just discounted his own fee by $10. This is incredible. I love this man. I love you, bro. Leroy Truth Investigations doing his own plug for his channel. Go check him out. I had Jeremy Hales on my live stream YouTube channel, Leroy Truth Investigations, last Sunday. He was awesome, and it is an extremely important story. And we also did an interview on my channel. So hey, you plug yours, I plug mine, bro. This is how it works. Absolutely go check it out, and go check out the live. It was 90 minutes, and I have a TLDR, too long didn't read version. We have 5, including this one, 5 more videos coming on 3 different channels about the Hales. So this stuff is just, it's writing itself, folks. It's literally writing itself. This judge is out of control. Larry, make me a mod on your channel so I can post links in the chat.
Yes, ma'am. I need you to, for me to do that, here's what I need you to do. In about 2 seconds, when I tell you to,
my camera,
I need you to make a comment so I catch it, because this chat is absolutely,
I know it's flying. Okay, you tell me when.
I will. Give me 2 seconds. Let me open it up on here. Here we go. And go.
There you go.
I'm watching. There we go. There you are. Here I am. Add as moderator, managing, save. Megan Fox is now a managing moderator for your
All
channel.
right, cool. Yay.
Yay.
All right.
Awesome.
Thank you.
Bone Crusher is at 6.9K, by the way.
What? 6.9? That's awesome. He's gonna let's get him to 10,000. It's gonna be amazing.
Let's get him to 10. Let's get him to 15.
We can do it. We can do it.
Absolutely. Absolutely. Okay. All right. So where were we? Yes, here we go. Espresso, thank you for the please keep this going. Jeremy and George are such great people. Yes, absolutely agree. Sandy Mosley says Preston, that's Lynette Preston, the one who filed the injunction. We're reading to disqualify the judge on that injunction, which we will be reading the injunction itself, the petition that she filed tomorrow. Preston had no attorney at the time of the deposition. That's fine. Sally 68 says Lynette did not have a lawyer. There it is, same comment at the time of the deposition. I believe the judge does state in hearing for that she did not know what pleading the fifth meant, even though Hale's attorney explained it to her. But she kept doing it even after they explained it to her. So that's no excuse. I agree. I agree that when you don't have a lawyer, it's a little bit harder. And again, here's another one. Debbie Childers, Preston did not have an attorney when she took the fifth. Again, but once somebody explains it to you, own it. You know,
don't be a moron.
And
Hire
don't
a
represent
lawyer.
yourself. Yeah.
Don't represent yourself.
He or she who represents him or herself has a fool for a client. Everybody knows this.
Yep.
Jax R, thank you for the New Zealand. Watching from New Zealand and am a longtime Hales watcher and supporter. This has a detrimental impact on my view of the legal system in the USA. The world is what, Megan, it's not the US anymore. The world is watching.
This is great. This is what makes a big difference. Look, we just had a case that I was covering on my channel about a medical kidnapping in Georgia. And it was clearly a case of doctors being mistaken about abuse versus, an underlying condition. And we did a calling campaign to the legislators and DCF in Georgia, and they got on the stand at the hearing that they were having and said, we got over 500 emails from people all over the world.
Wow.
And they were terrified by it. And the judge in the case got the clue that everyone was watching. And guess what? She found there was no evidence that those parents had done anything to that child. And they are now on the path back to reunification. Thank God.
Thank God. That's a great result.
It is a great result. But really, it makes a big difference when people start watching from all over. People who do bad things, they don't like sunlight.
You know what this reminds me of, Megan? Have you seen the movie? It's called The Trial of the Chicago 7.
Oh God, that sounds familiar.
It's about the Chicago riots during the Vietnam War in the 1960s. And it's a phenomenal flick. If you have not seen it, you guys.
I don't think I have, but I may have heard about the story.
It's a very familiar story. In the very beginning, this donation right here from Jax R was literally just reminded me of that moment when Abby Hoffman, who's played by Sacha Baron Cohen, and another guy, I forget his name. Chad will probably be able to help me out. They're walking to the courthouse for the first day of the trial, and somebody throws an egg at Abby Hoffman's friend, and he catches the egg, and you can hear the people screaming, and he's like, are you okay? Like, somebody threw an egg at me, man. And he's like, you don't know what to do with the egg right now, do? And he's like, no. But he's like, why are you so frazzled? He's like, did you hear what they said back there? He's like, what? He said, they said, the whole world is watching. And you can hear them chanting, the whole world is watching. The whole world is watching. And that's kind of like, it sets the stage for the movie because the trial begins. And the judge in that case was a complete and utter, unforgivable tyrant.
Mm.
And later, it was actually I remember at the end of the movie where they show the real clips, what happened to them after the case and whatnot. It was actually Judge Hoffman, and he made a point that the defendant Abby Hoffman and Your Honor Judge Hoffman are not related. I just want to make it clear for the record. And everybody just kind of ran with it and made fun of him for the longest time because he's like, and to make sure that we are not related, Your Honor, because Abby Hoffman is a huge proponent of free speech, and May he rest in peace. I mean, poor guy, but that's another story. The point I'm trying to make here is there's a survey, and like 85% of lawyers who surveyed Judge Hoffman in that case, in that county, were like, he is unfit to judge and preside over cases. Unfit.
And some judges are. And
it's just the way it is.
Not all judges, but some judges are. And when you identify them, it is important to
weed them out.
To weed them out, because we want our we love the judicial system. Larry and I both do. I love the law, and I love good judges, and I love good lawyers, and I hate bad judges, and I hate bad lawyers. And when it's just like, everybody talks about bad cops. Well, there's not all cops are bad. Well, when you find one, you better weed them out, because they don't deserve to be there. These people are in charge of our very freedom in our lives. They are in charge of obeying and upholding the constitutional rights of Americans. And if they are not doing that, if they are actually going against the Constitution, they need another job. They need somewhere else where they cannot violate people's rights. They need, go work in a marketing firm, go do some consulting somewhere, but get the hell off the bench, because you don't belong there.
Yes. And I'm trying to find, oh my God, I may have lost it. I believe What the Hales is in. Yes, there they are. Found them. Yay. What the Hales are in the chat. Is this the live stream we're supposed to be on, or later this week? Oh shit, Megan, I knew we forgot something.
Don't make them feel anxiety, Larry.
No. I'm sorry. No, you guys, that's tomorrow with that umbrella guy. He should be getting in touch if he's not already. And then Tuesday with me. And Tuesday I will be on Megan's channel, not here. Megan's channel, go subscribe. It's in the description. What the Hale's in the house? And also, speak of the devil, Mandu, the man himself, he will shout it out in the chat. I'm not going to say anything other than, Mandu, what did the DUI guy do for you? That's all I'm going to say, and he will fill you guys in the chat. He has his own YouTube channel. Okay. Graham Ellis, why do I keep hearing the song, Send in the Clowns? I think the thumbnail is tipping you off because Judge DeThomasis is acting like a clown in a kangaroo court. Hello? Yes, absolutely. I'm with you. Donald Morrison, welcome to the channel. Thank you for joining on as a member. Big Dog 0149. Why do you suppose that the state is not stepping in on this kangaroo court? The state? You mean like a prosecutor? Like what state are we talking?
No,
the mayor, the governor?
That's not how it works. Like, that's not how it works. So the state can't. The only thing that can be done is the legislature could start an impeachment process against him. That's the only thing that can be done to a judge. Judges, because the judicial branch is a third branch of government, right? There's the executive, the legislative, and the judicial. They operate independently. The only check and balance on the judiciary is the legislative branch. So you have to get them involved if you want a judge removed. Now, sometimes though, the media acts as a fourth branch, a fourth check and balance on some of these institutions. That's their real job. The real job of the media is to act as a check and balance on all three branches of government. They generally are just trying to shut down YouTubers these days that don't go along with their narrative. So they're falling down on their job. But that's what I do. I will write articles, and sometimes the media attention will cause a judge like this to recuse. See my wall of recusals. It does happen. The media can be a check and balance against this kind of misbehavior, but it's
Absolutely.
very hard to get a judge removed by the legislature because they pretend, they forget that that's part of their job.
Hashtag buckle up.
Hashtag buckle up, sir. Buckle up.
Next, T. Ann, a huge fan of What the Hales. Thank you very much for your donation and joining us. Oh my goodness.
Wow.
God.
So nice.
Muck Duck Incorporated. Do you have your own channel? By God, go subscribe to him if you do. It seems like you do. Gifted 20 memberships to you all. So shout out if you got a membership from this man or woman or corporation. I mean, it's incorporated, but corporations are people according to American law. So whatever. Thank you again. Thank you. Thank you so much.
Ray Bone Crusher is here.
No way.
Yeah,
no
he
way.
is. He's here. He just showed up. Ray, how many subscribers are you?
Oh my God, the man, the myth, the legend. Let's go check in on him.
Let's check in on his channel. How are we doing over there?
We are, I think, at 7.2
Ah, look at this.
7.2 thousand subscribers for Ray Bone Crusher.
That's awesome.
My man, look at
That's
this.
awesome.
Go subscribe, like his videos, watch his videos. He shouted out, he said, I sub to you and I'm listening to you live. Ray, you are my spirit animal. When I am 97 like you, and I'm totally kidding. You look not a day over 55. When I am your age, I swear to God, I hope to be like you because you are a legend, sir. And I look up to people like you, and I hope more people look up to you. And I have no doubt that your subscription base and your following is going to skyrocket because you are a real homie and you are the real deal. So go subscribe to his channel if you haven't already. And welcome to the channel. Welcome to the chat. He said he subscribed and listen. We got the whole mishpucha here. The whole, for those who don't speak Yiddish, it's the whole family. Hashtag buckle up. Is it trending on X yet? I wonder.
Oh, it needs to be. It needs to, because man, this guy, he needs to be given a reality check, and that reality check is incoming. Judges work for the people. The people deserve their rights, and judges are supposed to protect those rights, not look for ways to infringe upon them.
Yes.
I am so this filing, by the way, we got to get back to it because
Yes.
I'm dying to know how it ends. It's so good. Let's see. I'm looking at Twitter. I can't call it X. I just can't.
I'm with you. I'm going to tweet this. What the Hales deserve justice? Buckle up, Judge DeThomasis. With the hashtag buckle up and then Judge DeThomasis. I think this, go to my Twitter. If you don't know what my Twitter is, let me show you. This, first of all, let's refresh real quick, see where Ray Bone Crusher is. He's already 7.29. You guys, 2.7 until he gets to 10,000. Let's at least get him there. At least. I hope to get him to 15,000. If all of you just go, it's free. Just click the subscribe button on his channel. That's all it takes. So here's my Twitter, my X, whatever you want to call it. Share this tab instead. Here we go. So this is mine. Feel free to retweet, reshare, whatever this is called these days. What the Hales deserve justice? Buckle up, Judge DeThomasis. Comment, share, like, reshare, quote, tweet, everything. We need to get this trending. This goes trending. I'm telling you, you heard what Ray Bone Crusher said. This is not my words. These are his words. If this doesn't sweep the nation, I don't know what will.
It really should. It really should, especially because, people lose faith in the judicial system when they see, injustices happening. And I would like to, see some of that faith restored in just that the people have power. People have felt very out of power for a long time, especially with, what happened with the pandemic and lockdowns, and people really have been feeling put upon, trod upon. Remember, that my favorite flag is the "Don't Tread on Me" flag. America at its heart says, "Don't tread on me. Step off. Do not do it." And it's great to see people being able to stand up and take back some of their power. And when we watch, and I have a lot of faith that Judge DeThomasis will not be on this case for much longer. Same. I have a lot of faith that he will not. And when you see that happen, I hope that you get a big rush of vindication that this system can still work. It does still work. And we will move towards a better system for everybody.
100%. I have full faith, and one way or another, it will happen. Even if on Friday, Judge DeThomasis says, I will deny thank you for your motion, counselor, and I will deny it. It is still not the end. Oh my God, Megan.
Oh my God.
Look who we have in the house. Do you know Delete Laws?
I do not, but that's a huge super chat.
That is Chile de Castro. Chile de Castro. He's Delete Laws on YouTube. What are you at now, Chile? He's at like 500,000 or
505,000 subscribers. Wow.
He's huge. He is actually, so real quick side story. He he just crossed 500,000. Congratulations, bud. You need to do a celebration stream if you haven't already. He sponsored a fundraiser for one of my clients, and this is not attorney-client confidentiality because I'm not breaching it because the client already breached it intentionally. This was all planned. It's not like a violation of anything. Again, not listening to your lawyer, we said, is not against the law. Your lawyer saying, you know what? I'm going to say I represent John Smith. And John Smith's like, what the fuck? I didn't tell you you can do that. That's breaking the law. That's breaking ethics rules. But Craig, what's his name? I'm blanking on his name right now. For the love of Benji, Larry, come on, get your shit together. Because my brain is somewhere else. Craig Hendry. So I represent Craig Hendry. And the reason I represent Craig Hendry is because of this guy. Because this guy made a fundraiser. My fee was $6,000, is $6,000. Megan, try to guess how long it took Chile de Castro to raise $6,000 through a fundraiser.
Oh, geez. With that many subscribers, probably an hour.
90 minutes. You're close. 90
minutes.
Close. He raised the fee and he's still going. I mean, this man is an unstoppable force. And again, thank you for your generous donation. This is incredible. This is just, everybody is in the chat. I'm trying to just, there's so many super chats. We have to get back to the motion. I have to get back to the motion. I just want to make sure there isn't anything glaring that I'm missing. I'm skimming through real quick because I think I saw Mandu. There we go. Mandu. Larry. Who's Larry? Larry saved my channel. I owe him so much. Side note, I heard Larry's Lambo new eyed tidies as a Prius. Is this true?
What?
I don't know what this means, but I think he's trying to make fun of my Lamborghini because I have one. I'm not trying to toot my horn. He did it, not me. I'm not guilty, Your Honor. My Lambo doubles. I think it was trying to say it doubles. It's a Lambo, but like on the weekends and then during the weekdays, it's a Prius. Is this true? Absolutely. It converts. It's like an Optimus Prime. It converts into a Prius, so it's undetectable.
That's funny.
Oh my God, Phyllis, Drew and Larry, can you please help first responder get his channel back? Maybe tell him to reach out to me. He does the border. He got his channel yanked for filming Truth at the Border. Interesting. That might be, again, my lawyer sense is tingling. Tell him to contact me. Tell him to contact me. I already see the legal. This is how fast my brain works. Like you give me, it's called issue spotting. They teach you how to do that in law school. And I've been doing this stuff for 11 years, Megan, and audience. So when I see stuff like this, it's like immediately, it's like, oh, I see the legal issues that could potentially be here and why they may have struck him. I could be, sometimes I'm 100% off the mark, but sometimes I'm right. So whatever. Tell him to contact me. I would love to look into it. Bone Crusher, where are you at? You are at 7,500. I was about to say 7,500. It is 7,500. Oh, my brain.
Almost
I'm too excited.
7,500. Yep.
I'm too excited, you guys. Oh my freaking Lord. Oh my God. Oh my
God. Wow. Yeah. This comment right here. It's so great. YouTube law is becoming the most powerful group of individuals the legal system needs to be put on notice that there are many people with many skills from many backgrounds, all in the legal profession or around it, like me, that are going to hold their colleagues, judges, and the law to account. Absolutely. You know why? Because we love the law. Because we want the law to be fair. We want it to be what it is supposed to be. And we just cannot allow this to go on where people's rights are being violated and children being taken illegally from parents. And there's a lot going on that is not okay. And it needs to stop. And it's great that the audiences, and it's not just us, it's great that the audience out there cares about this too. Yes. I feel so good that audiences are tuning in for this. Because I feel like I've been preaching to nobody for 20 years, like, guys, help, this is a bad situation. And now it's like people are really interested in it. So thank God for that.
And it's all that true crime stuff that people, it's like the new addiction. It's like the new soap opera, only now it affects real people with real lives. And it doesn't get much better than this.
Yeah.
Thank you, Muck Duck Inc. I swear. Let me just pull up your channel, Muck Duck Inc. YouTube, because this if this deserves at least this deserves its own video. That's not you. Muck. Let me try this again. Muck Duck Incorporated. It's a different logo. I don't know if you have a channel, bro. If you do, please like email it to me or something so I can share the crap out of it. But I can't find you. I am so sorry. If you do, I mean, you may not have a YouTube channel, and my efforts are in vain. But I'm just trying to be a homie. Oh my God, look at this. What the Hales deserve justice. Buckle up, Judge DeThomasis. Already has 145 shares. It's insane. Look at that. 145 shares. Let's get this trending, you guys. Let's get this trending. Let me refresh, see if yep, there it is. 145. So we're going to come back to that. We got Bone Crusher is at 7.53. So slowing down a little bit. Go to his channel. It's free, you guys. It's free. Just subscribe to his channel because he deserves all the love. He deserves all the love. All of it. And thank you again, Muck Duck. Let's get back to the main event because I have a lot to cover in this motion. So let's go. Present, share screen. Boom. Let's get back to it. So Megan, I think I remember I asked you to like.
We were right there. I read that twice.
Holding. Yes.
Yeah. That holding has always been the position of the First District Court of Appeal, whose authority is controlling in the 8th Judicial Circuit, Levy County, Florida. Is it Levy or Levy? Levy?
I
Levy
pronounce
County?
it both ways, so I don't know.
Okay. See, Blaylock, Supra, DHV, Department of Children and Families, Supra. Judge DeThomasis' single-spaced order. I keep saying single-spaced.
It's very important to point that out because remember what the law is. Yeah.
Denying Hales' second disqualification motion went well beyond simply finding Hales' motion to be legally insufficient. It addressed and challenged the merits of the motion, exceeded the proper scope of inquiry for ruling on a motion to disqualify, and wholly disregarded Florida law requiring a trial court to view a motion to disqualify through the lens of the litigant. And
sorry,
not on how a judge grades him. Sorry, Levy. It's Levy.
Levy.
Okay.
Yeah, I just wanted to Levy County. Levy.
Okay.
Not Levi. Not Levy. Levy. Like
Got it.
Levy. Got it.
The lens of the litigant, not how a judge grades him or herself as to the ability to act fairly and impartially. See Livingston v. State. The order, with its repeated accusations of ethical misconduct on the part of Hales' attorneys, exacerbates, underlined, the intolerable and adversary atmosphere between the trial judge and the litigant that the disqualification rule was designed to prevent. Department of Revenue v. Golder. In conformity with the legal authority already cited herein, the 5-page single-spaced order denying Hales' second disqualification motion is an independent basis to disqualify Judge DeThomasis. The actual content, language, and tone of the order further provide additional basis to disqualify this judge as set forth below, and further establish that Hales' fear of not receiving a fair trial before this judge is indeed well-founded. Judge DeThomasis' pejorative commentary, pejorative is a good word, on counsel's ethics, their unacceptable behaviors and actions contrary to law, as well as what appear to be veiled threats to report all 3 attorneys to the Florida bar. So now
this is starting to ring a bell. My ears are tingling.
He likes to do this, Larry. Maybe your threat came from DeThomasis himself through a third party.
Oh, that would be something else.
Wouldn't it, though? Veiled threats to report all 3 attorneys to the Florida bar requires his disqualification from this case. To be sure, a judge who questions the veracity or ethics of a party or counsel may be subject to disqualification depending on the unique facts of the case. Klein v. JRD Management Co. In his order, Judge DeThomasis states 4 different times that he admonished counsel at the hearing on 1/23/24 for certain perceived transgressions dating back to November of 2023. Attorney Shockett was the only attorney who appeared with Hales in court on 1/23/24, yet he was not the attorney responsible for any of these perceived transgressions, and the court would have known that.
This is the homage
my
that we talked
God.
about previously, that the judge is like, you, Mr. Excuse me, Shachet. I'm again, chat, help me out. How do you pronounce Randy's last name? Sachet, Shachet, Shoke. I want to know.
Yeah,
Please,
I've
please
been
help
saying
me out.
shock it because I can't imagine it's
Shocket. You're probably
shot
right.
it. Shot it would be so hard to say.
Shocket.
That's got to be a hard K sound.
He
Like shock. Yeah, shock it. It's
shock.
shock it.
Shock it.
It's a
Shock
good,
it.
that's a great last name. Shock it.
I'm trying to like make him into more. He's a Mr. Shochet, you know. I think like names are very important. So Judge DeThomasis is literally pointing the finger at Mr. Shockett, who is Jeremy's current lawyer, and he's saying you are responsible for the transgressions, which is a fancy word for misdeeds, misconduct, or whatever you want to call it, of the previous lawyer. Like, you can't do
That's
that.
insane. That's insane. That just shows that he's holding a grudge.
Yes.
And you can't hold a grudge as a judge. I'm sorry, but you're not allowed to do that.
We can hashtag don't hold a grudge as a judge. No, please don't. Buckle up. Hashtag buckle up is better.
Hashtag grudge judge.
Hashtag grudge judge.
Grudge judge.
Oh, that is, Megan, you are on the money. But let's think. We can do two. I guess we can do two.
We can do two. Grudge
But
judge. Buckle up, grudge judge.
Buckle up,
grudge judge.
Buckle up, grudge judge.
The video record of the January 23rd hearing portrays what those admonishments look like, including a resemblance to portions of paragraphs 8 and 9 of DeThomas's order. To wit, it is the court's responsibility to assure counsel's adherence to regulations of the bar, as well as a code of professional conduct in their dealings with the court personnel, and opposing counsel. It is necessarily an obligation of the court to question counsel regarding behaviors affecting the administration of justice, and he loves that phrase too, the administration of justice, and to place on the record the specific critical concerns of the court, as was done in each of the prior hearings, and to allow response of counsel, if any, concerning any and all transgressions and or violations of the law and or standards of conduct that directly affect the legal process of the case to be adjudicated by the court. Paragraph 9 of the order states in relevant part to grant disqualification on the basis of the matters averred in the motion under review, which consists of confronting counsel with their unacceptable behaviors and actions contrary to law, would be tantamount to allowing attorneys and or litigants to violate rules promulgated by the Florida Supreme Court, orders issued by the Chief Justice of the Florida Supreme Court, orders issued by the Chief Judge of this 8th Judicial Circuit, and to surrender and abandon all precepts of the regulated practice of law. And if they are then called upon to account for such behaviors and or to answer or explain such behaviors and or are admonished for doing so, they should be allowed a fresh start with a successor judge. Oh my God, this guy. Larry, you know what's funny about this?
What's up?
Is that, well, for one, all the and ors, that's funny, and the S's in parentheses, because kill me with the legal writing.
Enhanced font intentional. This is basically them calling him out. Like, this is how unruly he has become. They're emphasizing it for emotion. It is very rare. I have filed probably more than 10,000 motions in my career, if I were to just venture a guess, because 11 years of practice, my associates, we filed countless motions, including just the basic, entry of appearances and stuff like that, all count as motions. It is so, I can't think of a single instance in my career where I had to increase the font because this is how important this is. I mean, I've bolded, I've italicized, I have underlined. I have never, within the context of the text, had to make it bigger.
What's funny about this, though, is the way he's writing this. It makes you, if you didn't have context, you would think that these attorneys did something really terrible. Keep in mind that one of the things he accuses one of the attorneys of is of accidentally leaving out the name of the videographer of the deposition. Just keep that in mind when you're reading this, because that's how ridiculous it is.
Yep. Oh my God. I'll share it later. I'll show you guys this later, because this is just wild. I'll show you guys later. This is. I'm sorry. I'm sorry. I'm sorry. Okay. I'm just gonna show you now, because you're gonna be wondering, like, what the hell is going on here? Because I need to shift gears. So memes are being made about this already, Megan. Memes are
Great.
being shared. Look at this stuff. There it is. Look at this. The buckle up is trending.
I saw that.
It's trending. It's trending. Buckle up, Buttercup. They use the words I use on the thing.
That's awesome.
Oh my God. Buckle up. It's going to be a wild ride to the finish line. Watching Judge DeThomasis in Levy County on YouTube illegally take away the rights of YouTubers. Buckle up. And this is Larry, Curly, and Mo just slapping each other. Oh my God, this is you. Like, oh,
it's funny.
Unbelievable. This is a judge this is what happens, okay? Because I cannot take the credit. I take the credit for sharing this, but at the end of the day, I will say that the real credit goes out to you all, every single one of you, as a United States citizen, as an American who believes in the First Amendment right, in our Bill of Rights, in our liberties. This is it. This is a judge who's trying to take those away and set a bad precedent for our children, your grandchildren may, thanks to this judge, potentially grow up in a country where they don't have a right to free speech on the internet, because that's what he's trying to take away. He's trying to say, yeah, you can have free speech, but on the internet, you don't, kind of thing. That's basically literally a one-sentence summary of what he's trying to do, because he's holding other people responsible. Excuse me. He's trying to hold Jeremy responsible for what other people are saying on the internet. And that's not okay.
Well, and he's also claiming that somehow Jeremy speaking online about this process somehow interrupts the adjudication process, that it deters the administration of justice, he says. How, Judge? For one, there's no jury in this case. It's literally just you. So you can either choose to ignore it, because you have that power to ignore speech you don't like, or, actually, that's really all he should do. That's his only option. Ignore it, Judge. I can't even think of another option. Ignore it. This is
Exactly.
America.
Yes.
This is America. So and our free speech laws are very specific. The only thing that is not protected are actual threats of violence, like that are real threats of violence. And very small, narrow window of things and defamation. But even that, you can defame anybody you want until you get sued.
Yes.
That's not like a judge can't preemptively stop someone from saying something untrue. You actually have to go through a court process to have that, adjudicated. So our laws are very wide open as far as what can be said. And it's not this judge's job to decide what Jeremy can put on his channel, even about this process, especially about this process. We're talking about a government process here. Jeremy's life is being impacted by the government, and he has a right to talk about it. Period.
Yes, absolutely. 100%. That's a very, very apt summary, Megan. Thank you so much for that. Honestly. Ninja Puppy, thank you for the super sticker. I was trying to highlight this, but since I already, Muck Duck is literally like, he's showing so much love. This can be seen as a viral entertainment if you watch all the transgressions that have taken place in the court by the judge. Absolutely. It stands out. Seems to be the judge likes to hear himself speak. I think we talked about it in the beginning. But even though the case is bogus and no proof has been from the get-go, and no proof has been provided. 100%. And by the way, to go off on that, Mark Jackson says, I'm not a lawyer, but this is an amazing motion. And I echo that. And I am a lawyer. So absolutely. Justice for the Hales, says C. Douglas. Thank you so much. All right. Back to the motion. So share screen, boom, boom. All right, Megan, let's continue. We're on page 12.
All right,
24.
Judge DeThomas's words are chilling, including for Hales, who is now necessarily concerned that each foray into Judge DeThomas's courtroom will involve 15 minutes of preliminary attorney inquisition on collateral matters, not to mention at his expense,
Yep.
before the merits of his case are addressed. Indeed.
Oh, wait, sorry. Oh my God, you know what just hit me?
What?
The fact that Judge DeThomasis continues to waste time rather than listening to the merits and consistently addressing the BS that he is not liking, that does not have anything to do with the case. You know what's happening? He's hoping secretly, we don't have proof other than what we have, that Jeremy has to pay for his lawyer every time the lawyer comes to court. He's hoping maybe Jeremy will eventually run out of money and he won't be able to litigate the case anymore.
Yeah, probably. That's why he did all the. That's why he's been dragging it out so long. What possible purpose? When was the? When did she file the claim for the protective order? When did she file the protective order?
September 7th, 2023.
And it is now February. Okay. There is no reason why a protective order hearing should not have happened already. The evidentiary hearing, other than it's being intentionally dragged out.
Over 80,000 in
This
court
is punishment.
so
The
far.
process is the punishment. And so we have a judge who is participating in punishing a litigant in his courtroom, a defendant in his, right? That like she's the petitioner, he's the respondent. He is giving criminal penalties away in a civil case by just dragging this out. Really, if you think about it, it's basically like imposing fines without imposing fines. By saying you have to show up here a million times before we even get to the evidentiary part of your case. You know, child services does this too. Like family courts, they do this. They drag it out for parents. They don't give their emergency hearings. They don't do them within 72 hours. And parents are going like 60 days without their children before they get an evidentiary hearing, which is totally illegal, but they're getting away with it because who's to stop them? Like I said, you cannot stop a judge unless the legislature steps in.
Wow. I'm sorry. My heart skipped a beat, but let's get back into it. That's insane.
Indeed, the record already reflects his intention to indulge in this exercise regarding a sequestration issue, which the judge appears to be applying in an overly broad fashion to Hales and his witnesses who have not yet begun testifying, nor were even sworn. Specifically, Judge DeThomasis stated that when the parties return for trial on March 1st, the court will start with conducting inquiry as to who spoke to who. Oh my God. And will issue sanctions, including the exclusion of testimony. Larry, is this normal for a hearing on a protective order? Sequestration?
Let me read this again, because this is again one of those things where you read it and I listen to you read it and I'm reading it myself and I'm going to read it again because my brain can't fully comprehend what the judge is so outside the bounds of the law. I have no experience with something like this. I need to understand what he's trying to do.
I've never heard of this either. I've never heard of this.
Okay, I think we hit like a crux here. So let's dissect. Indeed, the record already reflects his intention. So Judge DeThomas's intention to indulge in this exercise of wasting time, delay, regarding waste Jeremy's money, regarding a sequestration issue. So sequestration meaning anybody who's kind of related to this case are going to be sequestered, put on the stand individually so they don't hear the other person's testimony. I mean, that's standard in like jury trials and most hearings, but okay.
But it looks like he's applying it, though, just to Hales and his witnesses.
Yes. And that's
weird.
That is bias at its purest. So if Lynette has any witnesses, they can sit in the courtroom and listen. But if Hale has any witnesses, they have to sit outside and come in one at a time. Yeah,
that's great. And he's going to inquire of them if they have talked to each other before the March hearing. Look at that. He's going to start with conducting inquiry as to who spoke to who and will issue sanctions, including the exclusion of testimony.
Oh
depending on the answers.
my
I don't even think you
God.
can do that. This is not
No,
legal. This is
you
not a
can't.
criminal case.
No.
It isn't. They have to be given notice anyway. And
Yes.
I've never heard of this in a protection order case. Never. I've never heard of anything like this.
Me
Never.
neither. This
Of
is
sequestration
insanity.
of
How do you,
witnesses.
well, no, how do you sequester for one party but not the other? How do you pick and choose which party to sequester? It's literally, here's what I like about the law, so I'm going to take that. Here's what I don't like so about the law, and I'm just going to put it to the side. That's what he's doing.
This is
He's
a
cherry
much-
picking the law.
He's treating this case like it is a murder trial.
Yeah,
Instead of
literally.
No, really, like what is he getting ready for? He's like, he should have already had the evidentiary hearing and called it a day a long time ago. But he is setting this up to be the trial of the century.
Yeah, he's
And-
Johnny Depp 2.0.
Yeah, it's really strange, right? It's really strange.
Because he's trying to change the law. I think he's trying to change 300 years of precedent, Megan. That's what he's really going for.
We just watched a protective order hearing in the Owens v. Eckerd case, the former bachelor with his false accuser. We just watched 2 of those, and they were less than, I don't know, maybe they were an hour long, and the judge comes to a decision.
Mhm.
Like they hear the case, they hear the evidence, and then they go, it's either denied or granted, period. This is a lot of rigmarole about nothing.
The gitologist is in the house, by the way. He's a homie and a friend. I just wanted to shout you out. Go subscribe to him as well. He's a good man. I'm a guitar guy with 145K subs. Michelle, I don't know who Michelle
Who's
is. Maybe
Michelle?
in the chat, has no clout at all. Y'all are getting biased information from her neighbor. So what's the difference? Don't you want to hear her side?
Whose side?
Interesting. Okay, so I think he's on the other side of things. So very interesting. Because obviously we have Lynette supporters in the chat right now. By the way, we just crossed 10,000, Megan. We have 10,000
wow.
people watching right
Yeah,
now.
I got a couple of messages like this myself on Twitter with people saying, "Oh, he is
Michelle
definitely
is Lynette. Oh, I
Okay.
see. Why don't you have her on and let her tell her story? You know what? At this point, I am game. I absolutely will have her
sure.
on and listen to her. I have no qualms about it. I just, for now, I want to cover the Haleses because this is the information that I have. If she wants to come on, I would love
And also,
to hear her side.
regardless of who's telling the truth here in this hearing, the way the judge has run this courtroom is totally wrong. It's totally wrong. No matter who's telling the truth on either side, what the judge is doing is totally wrong here. He should have already recused himself.
You guys are mean. You guys are mean.
Yeah, regardless, this judge is not doing things right, guys. Whether or not, because we haven't even gotten the evidentiary hearing yet. Let's just have that and see what her side is. Okay, fine.
Yeah.
Let's hear it. Let's hear what evidence she has that she needs a protective order from this man after purposefully moving in across the street from him and trying to get money from him. Let's see what is. Fine. Let's hear it.
Exactly. And don't forget to like this video, comment below, subscribe to my channel, The DUI Guy Plus. Join on as a member if you're so inclined. It supports us and what we do. Absolutely. Also, don't forget to like and subscribe to Megan Fox, the writer, not the actress, because fuck her. Because this Megan Fox is awesome. The other one,
Blood drinking weirdo.
Yeah. So Megan Fox writer on YouTube. It's in the description below. And also That Umbrella Guy. Ray Bone Crusher. Where's you at? Where is he at? Where are you at? 7.79. We're so close. We're going to keep going. Megan, 25. In light of the demonstrable in the middle there.
In light of the demonstrable history of this judge's disparate treatment of the parties, including selective interpretation and application of administrative and procedural rules as between the parties in this case, and his hostility and express condemnation of Hales's counsel, Hales' fear of not receiving a fair trial is both well-founded and reasonable. The doctrine of judicial independence does not afford judges the power to do as they please. Well, that's awfully nice of you. Right? Yes,
I agree with it 100%.
We know that's a lie, but thank you anyway. Well, at least now, anyway, I guess it's kind of true. She got too much plastic surgery.
Saying. It's accurate now. Like
accurate
I don't know what happened 10 years ago. Who gives a shit? Take it. Own it, Megan. Own it.
Okay. Judge DeThomasis's professed justification of his order that it is the court's responsibility to assure the orderly administration of justice does not justify retaliatory conduct against the attorneys or the parties, nor does alleged misconduct or the good motives of a judge excuse departure from the guidelines established in the Code of Judicial Conduct. That Code of Judicial Conduct, by the way, very hard to hold them accountable to that. No one does. See also inquiry of a judge, Shea. All right, we can scooch
Sorry.
down.
Yeah. Okay, here we go. 27, and I'll take it from there. After
Yeah,
that.
go ahead. Yeah, okay.
No, after 27.
As the Florida Supreme Court stated in Erickson Supra, Judge Erickson essentially believes that if a judge believes a defendant who exercises a legal right is attempting to interfere with the orderly administration of justice, this is good. The judge has the right to react to the defendant by inflicting punishment upon him or her.
There it is.
However, even if a defendant knows that the exercise of a legal right may interfere with the orderly administration of justice, a judge cannot punish the defendant solely for exercising that legal right. Damn straight. To
Exactly.
approve that approach would have a chilling effect on the defendants who legitimately seek to exercise their legal rights and is contrary to the fundamental principles of due process. And that's all he's doing is
Yep.
asking to disqualify a judge is his legal right to do. The judge cannot then throw a shit fit like a toddler because he's asking to exercise his legal right.
Yep. Exactly. Now, number 3, Judge DeThomas's hostility. Ooh, I like where this is going. Hostility and animosity towards Hales's counsel is a basis for his disqualification. That's another argument. This is argument number 3 now. References to the record are taken from the official redacted video. This is important. Remember, we talked about why Feather has been slapped on the wrist.
Right.
References to the record are taken from the official redacted video, which is exactly the same as the unredacted video, just for the record, recording of the January 23rd, 2024 hearing. The bracketed timestamps next to the quoted excerpts of the proceeding are as close as possible to the time increment of the recording. Now, here's the judge's bias against Feather, the previous attorney. Paragraph 7A through C of the order addresses court hearings that occurred early on in the case, November 29th through December 6th, before Shockett ever came to become his attorney. Attorney Feather represented Hales at the November 29th proceedings. Attorney Shockett and the Shockett Law Group entered an appearance shortly before the December 6th hearings. What Judge DeThomasis has apparently perceived as egregious misconduct during and surrounding these early hearings quickly became a running polemic that continues to this day, and it is being used to justify denial of due process to the Hales. So basically, the judges, they're saying, is bending over backwards to attack the lawyers rather than address the merits of Lynette Preston's motion. So he is doing everything in his power to just keep this going as long as he possibly can, so where maybe Jeremy will run out of money or get frustrated or what have you, maybe have an outburst in court, which God forbid, don't do it, Jeremy. I know it's going to make great content, but don't do it. It's going to shoot you in the face and your defense. So, and he's just using it to delay, and he's denying the respondent, Jeremy, his due process right to confront his accuser, which is Lynette, in her motion alleging that he is stalking her, which again, pot calling the kettle black. According to them, Lynette moved X number thousands of miles and bought a property directly across from them, continually begging for money, continually wanting
trying to insert herself into their lives. Like that's what, and I still haven't heard any of this. Like, what is this alleged thing he did to stalk and harass her? From what I can hear, he wants nothing to do with her. So where is it? Where's the evidence? And
show me the money. Exactly. Show me the money. Paragraph 7A references a statement. So this is in Judge DeThomas's order. A statement made by Attorney Feather to the court at the end of the day on November 29th, 2023. That's a typo. Regarding the possibility of concluding the hearing that had not finished the next morning at 9 a.m. Mr. Feather's words were, quote, "No, Your Honor. Okay. No, Your Honor. Mr. Hale is having. Megan will be right back with us. She's having some computer issues. No, Your Honor. Mr. Hales is having to address matters in Ohio court related to this situation. He has to be there tomorrow morning. The court thus scheduled conclusion of the hearing for December 6th, 2023. Okay, so no, Your Honor, he's having to address a matter, and that is a reference by the judge. Now, from Feather's statement, the judge made an assumption. He assumed that Hales had to be present at the court proceeding the next morning in Ohio court. And Megan and I are going to watch this on Tuesday at 4 p.m. By the way, for the record, I just want to tell you guys, I have confirmed with that umbrella guy, okay? It is now officially confirmed. That umbrella guy and I are going to be live tomorrow at 7 p.m. Eastern time on his channel. And What the Hales are going to be there. If you guys are watching, I just want to make sure that you all know this. What the Hales, Jeremy and George. Tomorrow, 6 p.m. Central, 7 p.m. Eastern, 5 p.m. Mountain, 4 p.m. Pacific. And of course, if you're in Europe, it's going to be very, very late, like 1 o'clock, 2 o'clock in the morning. So that's when we're going to be live talking about that, okay? With Tug. And the What the Hales are going to be there on Tug's channel, that umbrella guy. So from Feather's statement, the judge assumed that Hales had to be present at a court proceeding the next morning in Ohio court, rather than consider the possibility that Feather simply misspoke or failed to phrase his response more accurately. The judge immediately reached the adverse conclusion, and there it is again, the bias. He doesn't even take time to listen. He immediately reaches an adverse conclusion that Feather intentionally, he did this on purpose, right? Displayed a lack of candor with this tribunal, and that we're going to hear this on Tuesday with Megan, and obtained a longer continuance for his client based on misrepresentation. And there is a site here, number 3, at the top of page 3 of the order in the context of addressing Feather. Judge DeThomasis uncharacteristically uses the word representation, whereas up until now he had repeatedly denounced it as misrepresentation. Just fascinating. So he changes the language on us, literally changes the language. Welcome back, Megan.
Sorry, computer fail.
No worries. Welcome back. Ironically, number 32, paragraph 32, ironically, on the electronic recording of the January 23rd hearing, the court, speaking rapidly, stated, anyone after this judge has spent 40 years almost on a daily basis in the courtroom. Although that statement gives the impression that Judge DeThomasis has been serving as a judge on the bench for 40 years, which I do not believe. When I heard that statement, I was like, wait a minute, 40 years. Maybe you've been going to court for 40 years, but I don't think you were a judge. I mean, he is of age, but I don't think he's going to be, he's
like the Joe Biden of the courtroom. Been there for, almost half a century. Wow.
We know that not to be the case. So this is literally the lawyer calling out the judge for lying, or at least misleading. At the very least, it's misleading. At worst, it's lying about how long he's been a judge. Immediately assuming that the judge lied, there literally took the words out of my mouth, in making that statement when he merely did not articulate his words carefully would be absurd, of course. Nonetheless, in his order, Judge DeThomasis continues to impugn Feather with his statement months later, after having reached a negative conclusion without ever having affording Feather an opportunity to be heard. Such conduct is the antithesis of impartiality, the opposite of impartiality, meaning partiality. It is apparent that the court's bias against Feather manifested itself at that point early on, when the judge assumed without more that Feather lied to the court. It quickly intensified when the court also learned soon thereafter that Feather requested and obtained an unredacted versions of video recordings of the 11/29 and 12/6 hearings, which he provided to Hales, who broadcast them in conjunction with his YouTube program, What the Hales. And by the way, a very interesting point I want to make here. that the problem is, and this is coming from my source, by the way, you guys, this is not my opinion, and it is my opinion now as well. But it basically, Judge DeThomas's biggest issue with this whole thing is he's saying Jeremy is What the Hales' channel. Like they're the same entity to Judge DeThomas's. So if something happens on What the Hales channel, it is impugned. It is Jeremy by association. It is Jeremy doing it, basically, which is not the case. It's absolutely not the case. Jeremy is not his channel as much as this channel is not Jeremy. It is a collective. It is a, he can have guests. He can have people on there that have absolutely no relation to him as the person. And Judge DeThomasis, to make his rulings easier, is basically saying, oh, Jeremy is What the Hales. What the Hales is Jeremy. Everything that happens in What the Hales, Jeremy is going to be punished for, which is insanity. It is uprooting 300 years of American jurisprudence, literally.
I read the cyberstalking law too in Florida, and I think he's misinterpreting it drastically, because all interpretations I've seen of it, it is all directed at the perpetrator of the cyberstalking. There is no language that says a third party can be held responsible for cyberstalking. It is all directed at the perpetrator. So I really want to see that injunction. Because I want to know where he is getting this idea that the legislature meant for this to be interpreted as you can hold somebody else responsible. I don't think you can.
Yeah, we're going to have to wait and see. Once bias becomes manifest, confirmation bias followed, what we talked about earlier. Florida Supreme Court Administrative Order AOSC 11-22, which was designed to further standardize court operations and minimize unnecessary workload for the trial courts while continuing to protect from inappropriate release any confidential information. That was the only purpose of that order. This is very, very important. Listen up, folks. Confidential information that may be captured on electronic recordings when electronic recording equipment is used in the courtroom, and the local administrative order of the judicial circuit contain procedures for obtaining copies of electronically recorded court proceedings. And Section 5 of that same order, entitled Safeguarding Confidential Communications when Electronic Recording Equipment is Used in the Courtroom, states, quote, pursuant to Florida Court Administrative Order, the one that we just read, as amended, before any CD is released to any party in any case, it shall be redacted of any confidential material found therein. And this is what Judge DeThomasis is bastardizing and creating a mountain out of a molehill, saying, essentially, if there was like a social security number or a birth date or an address, or, well, I think even date of birth doesn't apply, to be completely honest.
No,
But,
and even really address doesn't really apply either, because it's
but
not
Florida is weird.
technically
It's Florida,
private.
Megan.
If they want to
Florida has
include
its
it, they
own,
can.
like,
But I feel like maybe I'm too old. None of you youngins remember a phone book. The phone book was a real thing. You could find anybody's address you wanted to, and to be clear, you can still do that because addresses are all.
You mean that thing that I used to kill bears with in our neighborhood? Phone book? That's the only use I have for it.
I mean, they don't have them anymore, but I mean, you can find people's addresses are really not private. They are used on all sorts of public documents that are everywhere. But the young generation thinks that, oh my God, an address, that's private information. It's not really. But
well,
I get
in the modern day, what's scary and why I agree, and I think it should be private information, is because people dox people and call SWAT teams to people's homes. That's the only reason why I would want to add it to the protected list, Megan. Because 20 years ago, that wasn't a thing.
If a judge wants to do that, but then I think it becomes like the clerk's responsibility to then go in and redact that stuff before releasing it on the docket. And if it's released on the docket and that stuff is not redacted, that is not the fault of any party who gets it off a public docket and puts it anywhere else. That's the fault of the court.
There it is. This is what we talked about.
So
the
weird.
Redacted and unredacted versions are not 99, not 98, not 97. There they are. What the Hales. By the way, since I have you guys here just real quick, don't forget, tomorrow on Dead Umbrella Guys channel, 7 p.m. Eastern, 6 p.m. Central. We're going to, because he's on Tennessee time, 6 p.m. Central, 7 p.m. We're going to be on his channel, That Umbrella Guy. And then, of course, on a Tuesday, you already know, Megan's channel at 4 p.m. So buckle up, folks.
Buckle up.
This is great. They're 100% the same. Not 98, not 99, 100% the same. Okay. So shall be redacted for any confidential material. And Judge DeThomasis takes it a step further. Let's read on. So the one of the rules provides that an unredacted copies of audio and video recordings when electronic recording equipment is used in the courtroom may be made available to attorneys of record, parties to a case, and self-represented litigants upon request from the clerk, so long as an acknowledgement is provided with the copy that states that confidential information may be contained in these recordings. So be careful, right? Further dissemination of confidential information contained on the recordings is prohibited, and a violation of the prohibition against the dissemination may subject the requester to an action for contempt of court, which is basically what Feather suffered as a result of the.
So they are putting the onus on the person who gets the recording. I think that's nuts. It should be on the court, because if the court doesn't want certain information out there, it's on them to redact it before they release it, period. It's not on the person you send it to. I've never heard of that. I have never heard of a court holding people responsible for redacting stuff that they released.
Yep.
Don't release it then until it's redacted.
I agree. And that would solve all the problems, but it's a lot easier to sanction people and collect money from them when we think you did something wrong, even though they did absolutely nothing wrong. It's another way for the system to extract money out of people, Megan. That's the way I read it.
Yep. And it's like there's no written, like, did they give an exhaustive list of things that are supposed to be redacted? Because if they didn't,
confidential information, I think, is what they said, and I don't know. It may
what
list
is
it.
that? How do they define that? That better be defined, and
it's not narrowly tailored.
Yeah.
Yep. Agree. 100%. We're on the same page. Redacted copies of audio video recordings when electronic recording equipment is used are made available to the public at large upon request. Bingo. Like literally anybody can come in and request it. It's so backwards. As Attorney Feather signed the required acknowledgement when he requested the 2 unredacted recordings and unwittingly furnished them to Hales, who published them on his YouTube channel, Feather received an order. There it is. Okay, so this is what I alluded to in the beginning. Feather received an order to show cause issued by Chief Judge Mosley on January 17th. And again, we don't know who tipped him off. On January 17th, requiring him to appear before the Chief Judge and show cause why he should not be held in contempt for purportedly violating the Supreme Court and local administrative rules as to the unredacted recordings. Nonsense. Complete nonsense. Feather appeared with counsel. He had to hire his own lawyer. Feather, the lawyer for Hales, had to hire his own lawyer.
We should get that hearing. We should get that.
I would love
that would
to
be
see
a great hearing to watch. I bet you that the whole argument is, Judge, they're the same recording. It's like that meme from The Office. They're the same picture.
They're the same picture.
That's
yes.
the entire defense. They're the same picture.
Exactly. Feather appeared with counsel before Chief Judge on February 7th, so just a couple of weeks ago, and received a sanction. There it is. A sanction commensurate with the offense, the monetary portion of which was vacated sua sponte. That's the $500. This administrative matter involving Feather was collateral to the instant court proceeding, but Judge DeThomasis made it the centerpiece. See, he takes a little molehill that has absolutely nothing to do with the case and turns it into the most epic thing. And I cannot administer justice in my courtroom because, like, Judge, can we address the merits of the... No, we may not address the merits of the motion. I have to say my piece for the next 3.5 hours. That the Chief Judge of the 8th Judicial Circuit took charge of Feather's matter and not Judge DeThomasis indicates that keeping the matter separate was intentional and important so as to avoid even the appearance of prejudice to Hales arising from his own attorney being sanctioned by the judge deciding the merits of Hales's case. That objective was not and could not be accomplished because, as shown by Judge DeThomas's comments and demeanor in the video recording of the January 23rd proceeding, he could not even keep his antipathy. That's a word I've not read in a very long time. I love the colorful language that they're using here.
Agreed.
Toward Feather from impacting his judgment on substantive issues in Hales's case. He just can't help himself. He just wants to word vomit on things he finds meritorious and which have nothing to do with the case. Now, the confirmation bias extends to attorney Shockett. In the order denying disqualification, so this is either number 1 or number 2. This is the one that's at the bottom of this motion. Judge DeThomasis makes it appear that he was the trier of fact for Feather's contempt matter. So he literally placed himself. He said, "I am Mosley. Mosley is me." He really likes to do that. So Hales is what the Jeremy Hales is what the Hales channel. What the Hales channel is Jeremy Hales. Judge DeThomas is Judge Mosley. Judge Mosley is Judge DeThomas. We see a pattern here. Makes it appear that he was the trier of fact, made adverse findings against him, and admonished him, which is not the case, when it was not the case at all. Specifically, paragraph 7 of the order states, and there's an asterisk, let's go, the bolding in the paragraph was done by Judge DeThomasis. So all the bold that you see, this is from the order by Judge DeThomasis.
Oh
This is in the original.
That's funny.
There was undisputed evidence that confirmed attorney for the respondent, Mark Feather, despite having previously signed an attestation that he was aware of the admonition regarding the prohibition against dissemination of unredacted copies of court proceedings, did disseminate an unredacted copy of the 1129 court proceedings, as he was the only person who have requested an unredacted copy, and a redacted copy, by the way, which he leaves out. And his client, the respondent, did then broadcast the unredacted copy. Again, how do you know? Because he requested both, and they're exactly the same. Copy on a social media platform. Again, things he does not mention. So conveniently leaving out facts that hurt him and only including facts that help the judge make his point. Very convenient. It is true, as alleged in the motion under review, that counsel was admonished. The underlying was done by the writer for clarity. Okay, so that's the only edit. Counsel was admonished on 123 a month ago, 24 for such behavior as it was contrary to the dictates of the Florida Supreme Court and the Chief Judge of the 8th Judicial Circuit of Florida. This is Judge Mosley. Paragraph 7D states, it is true that on 123-24, the court did express dissatisfaction. Oh, there it is. This court expressed dissatisfaction and admonished counsel and the respondent for broadcasting. Again, he's saying, I am Judge Mosley, Chief Judge of the 8th Judicial Circuit, and I am Chief DeThomasis.
Well, or is he saying he also admonished them for it in the 123 hearing? I think he might be saying he did that during the hearing that had nothing to do with it. Because wasn't it the 123 hearing?
Well, it's ambiguous. He's saying
that
both
Hales
things
was
at the
in
same
court.
time.
Maybe
Unredacted audio video recordings of the court proceedings, despite. Okay, and it's cut off. You're right. It could be. I mean, it's too ambiguous, and it makes me fearful for Hales and his attorney now, Randy Shockett, because if you have a judge who may. Okay, I'm just going to go out and say it because this needs to be said. I don't have proof yet. We're just getting into this case. But I am fearful. You know, judges, humans, as they age, sometimes their mental faculties are not always fully intact as they age. And sometimes we lose. And that's okay. That's part of aging. That's part of life. I know one day I may not have full capacity of my mental faculties, and it scares the shit out of me. You know, that I will not be in control. I will not be cognizant of what's going around me. You know, there's diseases like dementia, Parkinson's,
Right.
other types of. What is it possible? Is there a realm of possibility that maybe Judge DeThomasis, and again, I'm not making any accusations. I'm merely positing a hypothesis that he may not be in touch with reality in some shape or form, and that. I mean, that would be a great explanation for his behavior, because his behavior is not congruent with American jurisprudence. He's going so far above and beyond anything that we have ever seen in American jurisprudence. Because I like to joke in my previous short video that it feels like we're in Venezuela, Megan, like the complete anarchy.
I hate to break it to you, Larry, but I don't think that he has any mental faculty issues. I have
Okay.
seen this type of thing over and over again. This is much more common, though, in family courts with judges who are dealing with custody disputes. But I have seen this a lot. This is very typical of someone who has black robitis. It is a condition, and it's brought on by too much power. Too much power and nobody looking over your shoulder.
I'm just
I
positing a
agree with Just a
hypothesis.
Hippie. It's arrogance. And arrogance may be a disease, but it isn't one that we can qualify with a mental diagnosis, I don't think. But yeah, arrogance
Not
is
yet.
what I see.
God
God
complex.
complex.
Yep. Okay. Fair enough.
But I mean, I hear what you're saying. The man is of a certain age, but I really don't think that's what this is about.
I don't want to point any fingers. I'm trying to like bend over backwards to try and find a justification for him. And again, the movie, The Trial of the Chicago 7 comes to mind, where the judge just completely went out of his way to be. But anyway, I'm literally trying to be devil's advocate here, and good,
You're
I
looking
failed.
for reasons.
I'll take it.
Reasons to give him some excuse for it, and I
love to be wrong.
appreciate that. I appreciate that, because we don't want to believe that Judge DeThomasis is, just has this like unmitigated like aggression towards one person in his courtroom, right? You want to believe
Yeah.
there's some other reason.
I want
But
to.
Sometimes it is what it looks like.
Sometimes a duck is a duck. If it walks like a duck, quacks like
Quacks
a duck,
like a
it's a
duck.
Feathers perceived, paragraph 7B, Feathers perceived misrepresentation to the court, states. So now we're back to the motion, back to the order. This is paragraph 39.
Wait, let's clarify something real quick.
Yes.
Feather, at the time this order was written, was Feather even the attorney?
He's still attorney of record. Again, if you go to, let me see. I can actually find it for you all right now. What's your question? Go ahead. I'm pulling it up as you're speaking.
Well, I just meant I was just wondering if Feather is still the attorney while he's writing this order, or if Feather is one of those attorneys that is no longer on the case, because that would be hilarious, because he has this thing with, accusing these attorneys who aren't even on the case anymore of doing bad things and wasting the court's time, because why should that matter? I'm just wondering, like, he really has a dislike for Feather for some reason.
Let me show you. So here it is. This is Levy County filings, okay? These are the Levy County filings in, where is it? So it's description, stalking. It's a domestic relations file date, September 7th, 2023. There it is. Current attorney of record for Hales is Shockett.
Randy Shockett. And so Feather must have withdrawn on 2/22.
There it is. Yes, this is what I wanted to show you. So stipulated motion. The motion was filed on Wednesday, Thursday.
So on on the same day.
Now here's the kicker. This is again from my source. Here's the kicker. The filing of the motion to withdraw as co-counsel of record is filed by Feather on Thursday. Judge DeThomasis is supposed to put the hearing like on the record and hold a hearing to determine whether or not to grant it. He doesn't waste a second. He's like, you want off the case? You're off the case. Goodbye. It signs it. Doesn't look. I don't know if he even reads it.
Yeah,
I don't
right.
know. So, and then it's assigned on Friday, literally 2 days ago. This is the latest, 2/23. Randall Shockett, Randy, assigned to Jeremy Brian Hales. He's the attorney of record now. Again, you don't see the name here but my source tells me this is Feather.
So who wrote this order that we are reading? Was it Shockett or Feather?
The motion,
not the order. I mean the motion.
Who
wrote the motion?
We are reading right now. So let's see, what page are we on? This is page 18. So we'll come back to it. Page 18 is where we are. We can look at the bottom because I don't want to. I know the answer, but I don't want to. I want you guys to see it rather than me just read it to you. Okay, this is page 34. So we're just over halfway done. Actually, we're exactly halfway done with just this portion. There's a whole lot more because there are attachments here. The who filed it, you ask? Randall M. Shockett, Doreen Ingalls, and Mark Feather. Now remember, this motion at the very beginning, do you remember the date? February 21st. So Feather was in on
the 21st.
it. And then the next day was like, you guys have fun.
Next day he dropped off.
I'm done. So although
so
he
then
is
the
listed.
order responding. So the judge, so he was on the case when the judge wrote the order.
Yes.
The order that they're okay. Got it.
Yes.
Sorry,
Yep.
that was my question because I'm
And Mark
just
Feather
wondering.
signs it to 20. Doreen Ingalls signs it on February 18th. And Randall Shockett signs it February 21st. He's the latest one. He's the last eyes on the case, on this motion, excuse me. So it's drafted by them three on behalf of Hales. Great question, by the way.
Yeah,
All
it's
right.
just trying to get, boy, there's a lot of ins and outs of this case, isn't there?
Yeah,
A
there are.
lot of ins and outs.
I'm here for it.
Me too. Complicated cases are always fun to get into because there's just so many roads you can go down.
Mm-hmm. Let's check in since I have my tabs switched. Let's check in on our homeboy Ray Bone Crusher.
Ooh,
8,000. You guys,
Nice work.
2,000 more. We can get him there. We already got him 3,000. What's 2,000 more? Don't forget to go subscribe to his channel. Do it right now. We're gonna do a moment of silence. I've never done this before. Not like this. A moment of silence. 8,000 subscribers. Go subscribe to Ray Bone Crusher. Check him out. He's a homeboy. Although I did in the interim, since I've done this, I have to share this with you guys. I believe What the Hales emailed me and they said Ray was not always on our side. And now he's on our side. So now he's a G. But
hey, that's great.
They don't endorse him, but I have to say it just so that people know. But I like him because he said good things about me. So
that's great though, because that means that, you know, he took a look at all the evidence. So it's interesting if he started out on the other side.
It's like all the people who started out, you know, Amber supporters, and then they listen to her testify and they're like, whoa, wait a minute. Amber is a liar. Johnny Depp is the right one. It's kind of, that's how I see it.
Right.
Yeah. Okay, let's get back to the motion. During the proceedings held on December 6, 2023, the court learned from co-counsel Randall Shockett and the respondent himself, meaning Jeremy Hale, on the record, that the respondent, Jeremy Hale, did not actually need to appear in Ohio on 11/30/23, and that he only needed to sign documents 2 days later with his Ohio attorney. We're going to watch this hearing live on Megan's channel Tuesday at 4 p.m. Eastern. So you'll see how this unfolded, and it's wild. As a direct result of this, it is true as alleged in the motion under review that the court did admonish counsel for lack of candor towards this tribunal, and such behavior was again addressed on 1/23/24. As the court considered the totality of the circumstances in the case when deliberating any additional motions being adjudicated. Insane. Mark Feather, however, did not appear at the January 23rd hearing, nor any hearings after November 29th, 2023. As made clear by his own order, Judge DeThomasis admonished Shockett for purported transgressions that Shockett didn't commit merely because he happened to be the attorney in the room on Hales' side of the case, and he was admonished on a particular one issue by a judge who exceeded his authority in taking up a cause that was assigned by the chief judge to the chief judge. Again, he's just pointing the finger at whatever is closest and saying, you're responsible. Crazy, just wild. Despite Feather's physical absence on January 23rd, he was certainly present in spirit. I love that. And clearly at the forefront of things considered by the judge. Quote, from the first hearing on November 29th, when respondent was represented by Mark Feather, his misrepresentations to the court, which gained his client the first of many continuances. That was at minute 6, second 43. Misrepresented why the continuance was necessary. The court relied on the misrepresentation. And then when the court asked it for the following week, Mr. Feather, who represented no objection to that date, there was no pushback. There was no judge, but I might have something. And I point that out because I want it to be addressed to both counsel that on 11/29, respondent was represented by Mark Feather. When offered an opportunity to reconvene the hearing the following morning at 9 a.m., made representations to the court which gained his client the first of many continuances, misrepresented why the continuance was necessary. The court relied on the misrepresentation and granted the continuance, and then the court scheduled it for the following week. And Mr. Feather represented no objection to the following week. The totality of the circumstances, which I'll discuss at a relevant point here this morning. We're waiting, Judge. We're waiting. Come on, get on with it. Day 1 was continued and offered to be continued the following morning, 11/29 to 11:30. Well, the record reflects that the respondent got a continuance on 11/29, the first continuance based on representations to the court. What really becomes just in a short day 1 was continued, and despite offering to reconvene the following morning, November 29th to November 30th. Well, let's talk about context. Your co-counsel, current co-counsel, this is going on for 15 minutes.
I'm so bored.
It's nothing burger. It's literally like I'm waiting for substance, and he's more interested in showing the displeasure, which, by the way, what is that? A reason to disqualify, bias, disqualification based on prejudice. Hello. Let's talk about context. Your counsel, current co-counsel to this day, Mr. Feather, represented that he could complete
the case in 15 minutes.
Sorry, I apologize. Give me 1 second. My source sent me a message as we're live. This one I have to read. 1 second. Keep going, Megan. Keep going.
Your co-counsel, in violation of the Supreme Court order and in violation of our Chief Judge's administrative order, 1.14 version 2, despite that, obtained unredacted copies of the 11/29 and 12/6 proceedings and is now answering to contempt charges from the Chief Judge. God, he just can't get over it.
He just can't. He's attacking. He's disparaging and attacking counsel and the lawyer that's not even in the room.
When we revisit your need to take the depo, your co-counsel said it could be done in 15 minutes to call 2 witnesses, possibly his own client, argue the case, and cross-examine. So that would leave, I'll be generous. And are you on notice that your co-counsel is already in violation of the Supreme Court order on prohibition against dissemination in our Chief Judge's 8th Circuit order? You know that your co-counsel is answering to the Chief Judge. That would have been concluded yesterday, but your co-counsel was afforded another continuance because he was unable to appear, and that'll happen next Monday. And just another side note of accommodation. So 3 hours were fruitful despite your co-counsel, despite the fact that your co-counsel needed 15 minutes to conclude.
My source is telling me that Doreen, the middle name that we saw, is the one who wrote this entire motion. The other 2 lawyers simply signed off as co-counsel of record. At the time, Feather dropped off, and now we have 2 lawyers. This is Doreen's work, so shout out to you, Doreen. She is
her last name
author.
is Inkless. Is that Inkless? Doreen Inkless?
Chad, help us out. How do you pronounce it?
I don't know how to pronounce it, but I think that's the one.
This is so. I wanted to give credit where credit is due. All right. Yeah. Having repeatedly castigated Feather in the litany of derogatory references. I love your colorful language, by the way. I love your colorful language, Doreen. Try saying that 10 times. Having repeatedly, it's so good, castigated Feather in the litany of derogatory references to him in a manner disguised as a totality of circumstances, the judge directed that hostility towards Shockett. There it is, misdirection, redirecting the energy, the negative energy towards a lawyer that's not responsible for the actions. For example, in discussing the many challenges that Shockett faced when taking the deposition of Preston, who was pro se at the time, the judge launched into cross-examination of Shockett as further evidenced by his tone, body language, raised voice, and inappropriate aggressive demeanor. Let me try and emulate that if I can. So we have
dramatic reading incoming.
Tone, body language, raised voice, and inappropriately aggressive demeanor.
Here we go.
Acting skills incoming. You guys ready? I'm going to make me. Here we go. And I know it's off screen, and I promise I'll bring it back, but just for the sake of emphasis, okay? So you're giving her legal advice. Is that what is happening here? Do you agree that the depo that was taken by video as opposed to just audio was proper or improper? Do you agree that it has been broadcast to your client's YouTube channel? You have to answer that. Did you tell me? Did you tell me? Have you done anything? And has it been successful? Would you agree they've been unsuccessful until today? But that being said, in the context of this rule of safeguarding in the attorney's responsibility, but now you know it is being posted on the YouTube.
And scene. Larry, you may have a second career as a Disney voice expert. Like that was fantastic.
Thank you. Thank you.
So
You may
good.
have autographs at the end of the show.
That's so good. You have the best face. You have the greatest expressions. So
feel like my
do you
heart
know
is
how
gonna explode.
memeable? Do you know how memeable that was? There are so many great screenshots there.
People are gonna clip this. They're gonna make memes out of this. I already know. I already see the writing on the wall. It was like what, 30 seconds, less than a minute. It's gonna be everywhere. What have I done?
So good.
What have I done?
Oh.
It's almost at the 3-hour mark. It's like at the 2 minute, 58, 2 hour, 58 minute mark. Oh, okay.
Well, you know what you should do is hit the.
Hmm.
Yeah, you use StreamYard. Hit the B key so you can bookmark it for yourself and turn it into a short.
Oh, I'm afraid to press anything lest I'm gonna break it unless I know what I'm pressing.
Just press the letter B while you're in StreamYard and it'll bookmark it for you on your recording.
We couldn't create a marker. Please try again.
Oh, well, I
Oh,
guess
well.
it doesn't work for you.
I don't know.
But that should be a short for sure.
Oh my God. Judge DeThomas's interrogation of Shockett was that of a zealous advocate, given that the judge has not treated attorney Shockett in such a manner at prior hearings, coupled with the fact that the judge had already recited Feather's perceived transgressions multiple times at this point. It would certainly appear that the judge's extreme bias against Feather is now transferred onto Shockett, and the trial judge's conduct crosses the line of ostensible neutrality and impartiality when he becomes overly involved in a hearing. Excessive participation by the trial judge may amount to usurping the functions of counsel. Basically, this is exactly what he's saying. You're not giving us an opportunity to do our job and defend our client. You're so focused on attacking us, you're not letting us speak. We need a judge that will listen to us. That's it. That's all they're asking for. Someone to listen and stop talking. Excessive participation by the trial judge may amount to usurping the functions of counsel and be an abuse of discretion at its least, and latitude of the court in such respects, with resultant injury to the rights of a party or parties. A trial judge's failure to remain neutral during a proceeding is also a due process violation that requires reversal. Judge DeThomas's adversarial conduct towards attorney Shockett has created and exacerbated Hale's fear, great placement of a word, of not receiving a fair trial by this judge. Judge DeThomas's comments, including towards Shockett himself, were not a mere expression of satisfaction, but a running diatribe of antipathy, hearkening back to the first day Shockett appeared in this case on December 6, 2023. Let me just say, okay, just for the record, I want you to know something. I as a litigant and a writer of legal stuff myself, this was written by Doreen on February 2024, this month presumably. It feels like I have spirited away to the 19th century as I read this beautiful language. I just want to give credit again because
it is very well written, and I haven't come across any typos.
There was literally one, and this is a very, very long motion, and it was just an extra word. There was like on, and anyway. But you're right. It's so poignant. It's so beautiful. It's so perfect. And nonetheless, so this is back the first day, hearkening back to the first day Shockett appeared in this case on December 6th. This is the court. And nonetheless, we have current counsel in the case. This is Judge DeThomasis speaking. And nonetheless, in open court, we have current counsel in the case who files a motion to continue 24 hours and 20 minutes before a case he knew he couldn't be prepared files another motion to continue, which would have been about the third motion to continue, if not the second, depending on how you look at it, when the record evidence establishes that the court accommodated current respondent's counsel when he needed a continuance, when he got into the case, knowing the case was scheduled, because he said he couldn't be prepared, and he came in as co-counsel to a lawyer who told this court on November 29th, somewhere between 4:50 p.m. and 5 p.m., Judge, I only need about 15 more minutes to conclude the entirety of my case. I found that to be incredulous understatement of the morning.
God, this guy just has a litany of complaints about that. It's just
so when the
absurd.
lawyer tells you, Judge, I just need 15 minutes to conclude my case. No, you are lying to me. This is not going to take 15 minutes. Like, I'm going to make the decisions for you. But he files something, again, another filing after hours, but insisted in relevant part as relates to today, Mr. Shockett, who is co-counsel to Mr. Feather, again, highlighting the fact that he just keeps attacking Shockett for what happened to Feather, files a notice of appearance 24 hours and 20 minutes prior to the commencement of a hearing that was scheduled to conclude these proceedings on 12/6. And so for counsel, and this is concerning to the court, for counsel to describe the efforts of an attorney who steps in with a very limited notice trying to address the issue of calendaring the event. And that's Silverman, I believe, because he just came in, he filed a limited entry of appearance stating that I am only here for purposes of continuance. That is my only role. I do not represent Lynette Preston. I'm only here to get a continuance, period, the end. Can I go home, please? It includes potential violations of oaths of attorneys or attorney, one who is answering to the chief for violation of the injunction, which implicates you, Mr. Shock. Okay, there we go. This is the grenade. This is the explosion. This is the nuclear bomb going off. Listen to this language. So this is happening in open court, on the record. Attorneys know what's happening. They know everything is being recorded. Everything that they're saying is part of this process. He's saying, what you guys are doing in my courtroom includes potential violations of oaths of attorneys. So like attorney-client confidentiality, duty of candor to the court. Which one? He doesn't specify. Attorneys or attorney who is answering to the chief, okay, for violation of the injunction. So he's talking about Mr. Feather because Feather got implicated by a chief judge. And this implicates you, Shockett.
He loves to hold third parties accountable for somebody else.
Yep.
He loves to do this. This judge thinks he can hold a third party responsible for somebody else's actions. And it's really weird. It's really weird.
Yes, absolutely.
This is kind of just it's kind of upsetting because we're seeing this happen in the judicial system where, like, we just had that Jennifer Crumbly case. They're holding parents responsible for their teen son that the state tried as an adult for, doing a school shooting, and the parents are getting charged with manslaughter, and that case is very controversial because you really do have to ask yourself, when does this stop? Do we want to become a society where you can be held criminally responsible or even civilly responsible for the actions of a third party? I think it's a question we need to answer quickly. And I don't think the answer should be yes.
I don't know if people can, that's not going to work. How do you know what I'm going to do?
I can do it. Since I can now drop links, I can get his channel in the thing.
I will also, what I'm going to do is I'm going to include his channel in the description below so people have it. By the way, I have his mug for those of you who just may be joining us. I'm drinking out of Tug's mug on a mug. I love that. That umbrella guy. So it's
here, I'll put it in the chat right now.
That umbrella guy's channel. So you also have it in the description below for those of you who may not be watching in real time and will see this video later on. It is in the description below as well. Okay.
Larry, I should
Yes.
probably tell you, I need to drop off because I've got to go and make dinner for my children.
Okay.
Because I'm single parenting it this week. My husband is out of town. So I need to go and make sure that they are fed. But thank you so much for having
Mommy
me
duties.
on.
Yes,
Yeah,
absolutely. No, thank you
have
for
mommy
3.
duties.
We've been on for 3 hours, and
I know.
which it flies by. I feel like I've been live for 2 minutes.
I know. And this
wild.
is and I'm going to listen while I make dinner. I'm going to keep listening because I want to hear the rest of this, thing. But those of you who are interested in following me, I dropped my link in the chat. Make sure you find me on meganfox.locals.com. You can follow me there for free and get all the notifications because YouTube is asshole sometimes.
Yes.
And you don't get my notifications. And so meganfox.locals.com is a great place to find me and keep track of me. Also, I have a new podcast. It's called Fox Den Daily. And you can download it for free. You can follow for free on Apple Podcasts, Spotify, Amazon, everywhere you find these. And it's basically like a 25 to 30-minute wrap-up of everything that I'm covering and my favorite YouTubers in the law community here are covering, and keeping you updated on true crime and what's live on court on television right now. And it's just basically like a truncated 25-minute daily thing. It's every single day. I'm trying it out for a while to see what happens. So check it out. But
Yes,
thanks for having
absolutely.
me, Larry.
Go
and I'll
check
see
it
you
out
on Tuesday.
Yes, thank you for joining. See you on Tuesday, and we're going to keep this thing going, you guys. So this is not over.
Right.
This is not over. This is only the beginning. Bye, Megan. Thank you for joining
Bye-bye.
us. Okay, let's get back to the main event. So this implicates you, Mr. Shockett, says Judge DeThomasis. And you saying, I need a continuance because I can't possibly be prepared, which again, the court again accommodated for Mr. Hales. And Mr. Hales, as I mentioned earlier, hired an attorney he knew could not be prepared. Now he's attacking Hales. You hired a lawyer he knew is not going to be prepared. He knew, again, Mr. Hales, that Mr. Hales had a calendar conflict, or the lawyer had a calendar conflict, or at a time conflict to be prepared. And he was accommodated. I've got no regrets about that decision. It was in conformity with the law and in conformity with the circumstances. Bending over backwards, trying to attack. It's crazy. Absolutely crazy. The fact that the judge, oh, and by the way, hashtag buckle up. We're trying to make that trending on Twitter. I think we're almost there. I think we are this close to hashtag buckle up being a trending hashtag on Twitter or X, whatever you want to call it. It doesn't matter. Let's see what the tweet that I have, 263 shares. For those of you just joining us, let me go ahead and show you real quick, just so that you know what I'm talking about. There it is. What the hell is deserved justice? Hashtag buckle up. Judge DeThomasis. This is on X. This is my handle at the DUI guy plus PLUS spelled out on X/Twitter. What the hell's deserve justice? We're trying to get hashtag buckle up trending. And the reason for that, why is buckle up trending? Because I personally, yesterday, if you're just joining us, I received a threat of a bar complaint of somebody who we suspect is related to in some fashion. I'm not saying like a relative, but knows is a friend of Judge DeThomasis based on the keywords, the key language that he used. And he basically said, tell Larry to buckle up because a bar complaint is coming. And it's like, okay, bring it on, buddy. Buckle up. So now buckle up has literally become the theme of, because I'm now involved in this, like to the point of being inextricably, people are saying I'm a witness. I'm not a witness to this case because I wasn't there. So although it may seem like it to somebody who's not maybe familiar with the legal system, I can tell you I am not a witness. I am simply the voice. I am the voice of reason. I am the voice for what the hell's. I do have a platform myself. We're approaching 500,000 subscribers. And we're just trying to build an audience. We're trying to share truth. We're here to share truth. We're here to protect the First Amendment. We're here to protect people. We're here to protect people's voices. We're here to stop the uprooting of 300 years of American jurisprudence of the First Amendment, because what is happening with the Haleses is not right. So go on X if you have an account. If you don't, that's fine. Don't worry about it. What the Hales deserve justice. Buckle up. You can create your own. Buckle up. Memes galore. There's at the 3-hour mark of this video, just a minute before, I think it's like 2:59, I go into character and I try to read Judge DeThomas's. It's crazy. Go check it out. And I'm telling you, I know it's going to be memed by the end of the day. Maybe it already has. I haven't checked, but have fun with it. It's true. Everything I'm doing here is because I care. I care about our rights. I care about our constitutionally protected right to free speech. And anyone, including you, Judge DeThomasis, I'm speaking to you directly, who tries to uproot 300 years of American jurisprudence is not okay. And the people will speak out. The people will protect their rights. That is the end. That is the end of that statement, because people will stand up for what is right. And when judges do things that are not right, the people will fight back. That is just how it works. You can't hide. You can't say, my courtroom is closed for today. You are not allowed to see what I'm doing, because that is how that begins the erosion of the American judicial system. And the whole world is watching. We got New Zealand, we got Canada. I saw Australia. I saw France, Germany. I saw Italy. I saw somebody from France. I saw Poland in the house. I think I even saw somebody from Nigeria. So shout out right now, who is watching from what country? If you're not from the United States, I want to know. We want to know, because the whole world is watching this. This is no longer an American issue. What Judge DeThomasis is doing in tiny little Levy County, Florida, could potentially uproot the entirety of our judicial system. And that's not okay. We also have Sweden in the house. I see Denmark, England, UK, Macedonia. Wow. Netherlands. I mean, look at Scotland, the country of Texas. I love that. Like Texas is its own country. Portugal, Switzerland, Finland, Great Britain. Unbelievable. The great country of Michigan. Unbelievable. Everybody's here. Everybody. The whole mishpucha. The whole mishpucha. Let's see, by the way, one last thing before we continue on with the motion. I want to see, where is Bone Crusher? How is he doing? Can we get him to 10,000 subscribers before we finish this live today? Because this would be unreal. Bone Crusher, where are you at, buddy? 8.26 thousand subscribers. We already netted him over 3,000 since this video started. Since we shouted him out and called out his channel. 8,260 plus subscribers. Go subscribe to his channel. We're trying to get him to at least 10K, you guys. We're so close. We are so close. Show him some love. He showed us love. I mean, I'm going to play the clip one more time for those of you who may just be joining us. He was allegedly, I've heard at least from one source, the Haleses, that at one point he was not on our side, on their side, and he switched camps. He learned some of the evidence. He switched camps, and Bone Crusher, there he is.
Larry Foreman just got through putting something on there, and you're going to be interested, and I really hope you go and look at it. Please go look at his channel. Larry Foreman, the DUI guy. Make it capital D, capital U, capital I, guy. He's gonna bring up, he is a lawyer. I think he lives in Kentucky. You're gonna be interested in what he has to say. One of Judge DeThomas's video, he went over it and curtailed it. This is gonna light a fire, people. If this don't go across the United States, nothing will.
If this don't go across the United States, nothing will. I mean, what a guy. He gets it. He's a guy that gets it. Let's get him to at least 10,000 before 8.3. We're so close. Just like 1,700 more of you. There's like 10,000. We have 10,000 people watching. This is insanity. This is how much the world cares about First Amendment principles, because if America goes down in its First Amendment principles, the world will follow, and we cannot allow that to happen. Okay, so let's get back to our main event, which is the motion. Let's continue the motion. The fact that the judge repeatedly reminded Shockett that he was Feather's co-counsel strongly suggests the judge's antipathy, and indeed his bias, has extended to Shockett. As shown by the video of this record, Judge DeThomasis' hostility towards counsel was not just evident in his words, but in his indignant and sometimes sarcastic tone and voice inflections, his body language, and even his finger pointing, either at Shockett or audibly down onto his papers to punctuate what he is saying. A judge should disqualify himself or herself in instances where the judge has a personal bias or prejudice concerning a party or a party's lawyer. That comes from Murphy v. Collins. In that case said, granting a writ of prohibition, which is a fancy word for the court agreed, where alleged characterization of Murphy's counsel as engaging in ploys and having a history of filing late motions and blaming court staff by itself could have rendered Murphy's fear of bias a reasonable one. And in that case, it looks like the judge was removed, disqualified, recused. And they're citing that case saying this is exactly what's happening here. Now, Judge DeThomasis' attack on the memorandum of law drafted by attorney Inkles omitted and ignored material facts to justify his condemnation of counsel. Let me read that again. Judge DeThomasis' attack on the memorandum of law drafted by attorney Inkles, that's, what's her name? Doreen. Sorry, I forgot her name first. There's a lot of names to be remembered, and there's so much. Doreen Inkles omitted and ignored material facts to justify his condemnation of counsel. Again, he's cherry picking. Judge DeThomasis is cherry picking. Although Hales' second motion for disqualification made no mention of the memorandum of law in support of respondent's motion for sanctions, including involuntary dismissal, which was presented to the court by Shockett but drafted by Inkles, whose name appears on it, Judge DeThomasis addressed the memorandum in paragraph 7F of his order. It is true, as alleged in the motion under review, that on 123-24, the court also commented upon a proffered memorandum of law that was presented to the court by attorney Randall Shockett, submitted 122-24, see docket entry 97, that in the court's view, unnecessarily, unprofessionally, and gratuitously criticized opposing counsel for filing a limited notice of appearance for the purpose of advancing argument to continue on behalf of the petitioner, as counsel averred he had a conflict and could not and would not be able to serve as counsel in the event the court did not change the next scheduling hearing date from the 1/26 date previously scheduled. He's playing favorites. He's playing favorites clearly, because he's saying all opposing counsel is doing is filing a limited notice of appearance, and we know that they're buddies, they're friends. So he's protecting his buddy who's representing Lynette. This is so unbelievable, unbelievable. I've never seen anything like it. The judge's friend is representing the opposing party, and that's not a conflict of interest. As the record, and he's protecting him. Judge DeThomasis is protecting Silverman because he's saying, well, he's my buddy, so I'm going to protect him. As the record would indicate, the court did admonish respondent's counsel for presenting such an argument and in such a manner, as the court also remarked and reminded Mr. Shockett that he, Mr. Shockett, filed his own notice of appearance 24 hours prior to an already scheduled hearing date scheduled for 12/6/23, and as a result, he advanced argument that he could not possibly be prepared and thus required a continuance, which was granted. The rhetorical and condescending language in the motion, advanced in a filing labeled memorandum of law, and which described as wholly unacceptable behavior of counsel, was in fact the same behavior previously exhibited by respondent's counsel. So again, he just cannot take no for an answer. The memorandum consisted of 11 pages, with the first 8 pages devoted to Preston's discovery misconduct. The last 3 pages addressed the conduct of Preston's newly retained attorney before he even entered an appearance of record, because he stopped properly noticed and scheduled depositions, including for a third-party witness he never intended to represent, from going forward when the trial was scheduled a week away. Now, failing to mention anything. So the judge, again, skips over all the stuff related to the motion, the substantive stuff, and attacks counsel, attacks lawyers, attack people. Forget the fact that there's a motion pending before me that it has to do with stalking. I'm going to attack Feather. I'm going to attack Shockett. I'm going to attack Ingalls. I'm going to attack all of you guys. And I'm going to protect my buddy Silverman. Good Lord. Good Lord. Failing to mention anything about either Preston's discovery misconduct or that of the attorney in obstructing discovery, and without having even appeared in this case, let alone filed a motion for protective order, wholly ignoring the predominant argument regarding obstruction of discovery, Judge DeThomasis created the appearance that Hales' counsel was upset merely because a continuance was requested by Preston's lawyer, again protecting him, once he finally filed the limited appearance in the case. The judge's omission of these material facts when making the derogatory remarks about the memorandum not only revealed his strong antipathy towards Hales' counsel, the bias and prejudice, but also his partiality towards Preston's new lawyer, who regularly appears before him. Again, he's partial towards Silverman, who is Lynette's lawyer. Although his order calmly states that he admonished the attorney for such filing, the audio-video record more accurately reflects a scathing and degrading attack. Upon reading the transmittal email to his judicial assistant, which is attached to the memorandum, the judge stated, "Attached is the case law portion to go with the motion. The fact is, what's attached does not even contain a copy of a case, so it's not case law portion. It's styled as a memo of law with no cases attached, but some cited. It is primarily an argument, and it's considered as such. It will certainly come up later regarding noncompliance with the directive regarding timing of filing documents, late filing, filing additional arguments." He just can't help himself. He just cannot stop doing it. This is crazy. This is absolutely insane. I just, part of the characterization in this argument, I've never seen anything like this. Part of the characterization in this argument, which at one time was called case law and really was not case law, and is styled as a memorandum, including extreme argument, quite frankly, that describes in part the limited appearance of an attorney on behalf of a petitioner, but accurately today here on her behalf to argue for continuance. But we've got language in this, quote, memorandum of law, unquote, and that states in relevant part the attorney for the petitioner who really is just trying to address the issue of calendaring. He can't even talk about the case. He refuses to talk about the merits of the case, attacking motions, attacking lawyers for writing motions, attacking lawyers for attacking other lawyers. Let's talk about substance. No, Judge DeThomasis says, all I want to do is talk about how much I dislike you, I dislike what you're doing in my court, and how much I like my buddy. And so for counsel, and this is concerning to the court, for counsel to describe the efforts of an attorney who steps in with a limited notice trying to address the issue of calendaring the event, we have an attorney calling that bad faith. Counsel referring to petitioner's new attorney stating, I can't be here that day, but I can be heard. We have an attorney calling that bad faith, willful disregard, abject interference. This is all the judge speaking. And let me ask you this. Why are these excerpts? I look at a filing, again, late last night, effectively the morning before this hearing, that appears to be excerpts of a depot, page 5, page 12, page 60, and it's clearly excerpts and in conformity with the rule. A copy of a deposition may be filed only under certain circumstances in conformity with the rules in general, practice in judicial administration, and in conformity with another rule, which would require good cause and with minimizing all sensitive information. In addition to remarking that the memorandum was filed late last night, when it was filed at 6:55, and that the memorandum engaged in name-calling, which when it characterized improper conduct only, Judge DeThomasis entirely neglected to mention that the factual portion of the memorandum detailing the actual misconduct was filed 2 days prior. Again, he's focusing on what helps his case and ignoring everything that hurts his case. He's cherry-picking. Again, it seems to be the theme, cherry-picking. Hashtag buckle up. Which the judge also criticized because his oral directive that was never reduced to writing was stated to be 5 p.m., although Preston's new attorney filed his document at 8:12 p.m. Yet, despite Preston's attorney having filed his motion for continuance over 3 hours late, the judge heard that motion without comment. However, when Shockett mentioned that the issue complained of was the attorney's conduct before he was even given a case, he was even in the case, Judge DeThomasis cut him off saying, you're arguing the merits of your motion. Stop arguing the merits of your motion. Let me focus on attacking you, basically, is what he's saying. You can't make this stuff up. This is insanity. Also neglected to be mentioned was that at the top of page 13 of Inkles's factual portion, styled as motion, it says case law analysis, followed by a few short paragraphs of introduction and the following language at the bottom of the page. Due to the 5 p.m. deadline, counsel did not have time to complete the case law analysis portion, although the research is essentially done, but another few hours are needed. A supplemental memo with the case law pertaining to assessment of sanctions against the party versus against the lawyer will be filed prior to the hearing, which is the 24 hours and 20 minutes that Judge DeThomasis refuses to let go, just will not let go of. The totality of the circumstances and cumulative effect of derogatory remarks from the judge, disparaging, criticizing, and finding fault, yes, with anything and everything said and done by Hales' attorney caused Hales to have a well-founded fear. There is that language again, tying it all in very nicely into the law. Good job, Ms. Inkles. Of not receiving a fair trial before this judge. Given Judge DeThomas's litany of harsh words directed at Hales' counsel and distortion of facts used to further condemn Hales' counsel, Hales' fears indeed is reasonable. Argument number 4. So that was argument number 3. Let's move on to argument number 4. Judge DeThomas's employment of a double standard in his interpretation and application of rules favoring Preston and prejudicing Hales requires disqualification. Employment of double standards, so cherry picking now who I'm going to favor and who I'm not based on my own personal bias. Employment of double standards on the part of the trial judge amounted to a violation of due process, clearly. In a manner similar to the judge in Ray Erickson, stated above, supra means above, Judge DeThomas's interpreted and applied rules and the law in an unduly rigid manner to Hales' side of the case while expanding, relaxing, or even ignoring them in the context of Preston's side of the case. The double standard, because he's not even willing to listen to Preston, who filed the motion. He's not willing to listen to Hales, who's defending himself, he's not even willing to listen to Preston, who filed the motion. I mean, he's not listening to either side. He just refuses to be a judge. He wants to be an attacker for no reason at all, other than maybe stroking his own ego. The double standard in determining legal sufficiency. For example, in addressing Preston's supplemental affidavit to her injunction petition, which caused a temporary injunction to be entered, that's back in September, Judge DeThomasis stated when the court received, she filed it in September. Actually, I take my words back. I don't know exactly when the temporary injunction was granted by the judge. Maybe Chad can fill us in. Chad, when was the temporary injunction granted? That I actually don't know off the top of my head. So fill us in, please. For example, in addressing Preston's supplemental affidavit to her injunction petition, which caused a temporary injunction to be entered, Judge DeThomasis stated, when the court receives a petition or a supplemental petition as a matter of law, this court must accept what's alleged in the petition as true, period, end of story. Why? Because the court must do so. No choice in that. December 4th, people are saying December 4th. That sounds about right, maybe. By the judge's description, one would believe he had no discretion in granting petitions involving legal sufficiency determinations. Preston's injunction petition was merely set for hearing. The judge did not grant a temporary injunction until she filed her supplemental affidavit. That's right. Okay, now it's all coming together. The supplemental affidavit, as we can see, was filed. Here we go. Was filed. I can actually see it because we were already there. Lynette Preston. I am a human. Let's see. You guys are saying December 4th, and I absolutely trust you. Come on. Okay, here we go. View selection. So that was filed. The supplemental was filed in 12/4. So the minute she filed that supplemental 300-page supplement, it was granted. And by the way, we have a copy of it, and we're going to read it probably tomorrow because I will not be able to survive another, 9-hour stream. This is already going on for 3.5 hours, but we're getting to the end of this motion, and then of course we get a chance to see the order of the judge, and there's so much more juice to be squeezed out of this filing. This is the first time. This is the first time this is being shared publicly, by the way, you guys. This is the first time anybody's laying eyes on this other than the drafters of this motion. But as far as I know, by the judge's description, one would believe he had no discretion in granting petitions involving legal sufficiency determinations. Preston's injunction petition was merely set for a hearing. The judge did not grant a temporary injunction until she filed her supplemental affidavit. It is noteworthy that in her supplemental affidavit, she specifically named Mark Feather in one of her allegations. By contrast, the judge did not accept what Hales alleged in his 2 prior motions to disqualify him as true, period, end of story. Because again, he's saying, I must accept what's alleged in the petition as true, period, end of story, just like he's supposed to do in this motion to disqualify, but he's refusing to do so. This means that, again, he's cherry picking. He did not apply the same standard to Hales' 2 prior motions to disqualify him, hoping maybe he'll change his mind and apply it to this case. And Megan will finally be able to add him to her wall of recusals, judges that she helped recuse, which are also reviewed for legal sufficiency and contain not only allegations recognized by controlling authority as meeting the standard for disqualification, but transcript excerpts of in-court proceedings. Now, the double standard for procedural rules. Judge DeThomasis also employed a hyper-technical review of Shockett's notices of video depositions that were served on Preston and a witness, John Cook, in an effort to foreclose his arguments to obtain discovery necessary to prepare his case. Shockett's notices were also so served before Preston's attorney was involved, and several hours of her deposition were taken before he got involved. Preston's attorney had only filed a limited appearance to argue for a continuance. This means that he could not permissibly file a motion for protective order, nor did he. Yet, not only did the judge permit ambush by allowing, over objection, Preston's limited appearance attorney to make unauthorized and unnoticed arguments, playing favorites, allowing his buddy to make motions he does not have a right to make, to exclude discovery items and limit the taking of further depositions. But he also allowed Preston's attorney to make unauthorized and unnoticed arguments about discovery directed to a third-party witness whom the attorney did not even represent. Shockett's notices of taking video depositions included all information required under the Florida Rule of Family Law 12.310, except that the actual name of the videographer did not appear on the notice as it was unknown. But the error was waived under the Rule 12.330D1 because Preston, a pro se litigant at the time, appeared for the deposition. And the moment you appear, you waive any and all potential defects in the filing. That's common knowledge. That's common sense. So just for those of you who may be confused, there's a rule that requires that the actual name of the videographer must appear on the notice of the deposition. They didn't know who the videographer is going to be. Why? Because sometimes we don't know who the videographer is going to be until 2 hours before they show up, 1 hour before they show up, 10 minutes before they show up, because videographers, they work in companies. They have lots of different representatives who just come in and set up the recording, set up the audio, set up the video, set up the everything. And the problem is, when you don't include it, I mean, sure, it could have been argued, but the moment she showed up to her deposition, she waived any errors. And the judge is like, I don't care. I'm going to ignore the law. Once again, playing favorites, ignoring the law. She appeared, and now she's held to the reasonable standard of a reasonably competent attorney. Number 67. Judge DeThomasis selectively overlooked that rule and gave himself leeway to seize on the technical omission, playing favorites, of the videographer's name in the notices, again, which were waived anyway, condemning petitioner's deposition as a video depo that was not in conformity with the rule. Bullshit. Which then became a mantra throughout the rest of the proceeding, as well as being mentioned in the order. The judge's critical comments below, infra, that means below, on Hales' use of Preston's video deposition make it apparent that the judge disapproves of Hales' earning income with his YouTube program. There it is. He does not like that Hales is using him and milking him for content because he needs to be called out for his misconduct, and he doesn't like to be called out. Anybody who is violating the law doesn't like to be called out when they're violating the law. That's just common sense. When Shockett wanted to show the court some excerpts from Preston's deposition to make it clear why he needed additional time for Preston's deposition, Judge DeThomasis looked at him incredulously and said, so now you want to disseminate it in court, a portion of the video? On the other hand, when applying the rules of procedure to Preston's side of the case, the judge was not at all rigid, not at all technical. After allowing Preston's, there it is, playing favorites again. after he's allowed the limited appearance attorney to make unauthorized and unnoticed arguments to exclude discovery items, he allowed that lawyer to prevent the taking of further depositions and to argue about discovery directed at a third-party witness whom the attorney did not even represent. The judge did not seem to have any transgressions. He said, no, this is all good, merely dismissed these acts, saying, yeah, he'll be remedied when he files a notice of appearance. So basically plenary in the future. He's predicting the future now. He's got a crystal ball. He's got a crystal ball that tells him what's going to happen in the case. I mean, this is, talk about minority report in Judge DeThomas's courtroom. I know a crime is going to occur in my courtroom. I already know what the crime is, and I can preface it what the crime is going to be. Wild. Absolutely wild. And I call it crime just because Minority Report they addressed crimes. If you haven't seen that movie, Tom Cruise, they basically have this system in the police where they can figure out when a crime is going to be committed before it is committed. A terrifying movie, but it is very apt here. Okay. Sorry, I have to share this with you guys. There is a Tug, that umbrella guy just shared this with me. So memes are already being created. Memes are already being created. Mr. DUI guy, your contempt of my court has drove me to drink. You guys are wild. You guys are absolutely wild. I just received this. This was literally like 5 minutes ago. Mr. DUI guy, while I'm live. This is while I'm live. Mr. DUI guy, your contempt of my court has drove me to drink. Unbelievable. I love you guys. I love you guys so much. Let's get back to the motion. Okay. On the other hand, I read this. Plenary and the court will acknowledge it. And notwithstanding that no motion for protective order had been filed on Preston's behalf to limit or terminate further taking of her deposition, the judge stated he would not permit her to be deposed further. Now, prejudgment and expressions of bias directly towards Hales, my client, right? And when I say I mean the lawyer writing this and the lawyers representing Hales. Judge DeThomasis sua sponte considered the standards set forth in the rule on protective orders, and then, on nothing more than speculation and allegation, denied Shockley the ability to conclude Preston's deposition. In doing so, prejudged the issue. Very important. When you basically, again, you make a decision before you hear all the facts and evidence. Prejudged the issue and perhaps the case on summary basis. And having it published in a case involving cyberstalking that's now gone on since September. How is that not now the consequences of disclosing that video on YouTube, not bad faith or considered in a manner that would be reasonably considered annoying or embarrassing or unreasonably oppressing the deponent, is on video broadcast for the entire world to see. Oh, you guys, I'm going to, can I zoom in? I want to zoom in on this. Is it too much? Let's see. That's too big. This, maybe one more. Look at this. Look at this. Clip this, cut it, hashtag it, buckle up. This is the judge's chief concern with what the Hales. Okay? This is the chief concern of Judge DeThomasis. He does not like that the broadcast is happening for the entire world to see. That's reasonably caused embarrassment, humiliation, potential danger, and at least there's allegations of that. Hashtag buckle up. Hashtag buckle up Judge DeThomasis, because when you act outside the boundaries of the law, you will be held accountable, because the United States public, the American public, will not sit by and stand and watch you erode First Amendment principles of what the Hales is, because that affects every single one of us. The whole world is watching, Judge. I am not kidding. This is not me. This is outside of my hands anymore. This is outside the hands of what the Hales is. We are just mouthpieces. We are mouthpieces for the First Amendment. That's all we are. We're nothing more than mouthpieces. I'm a practicing attorney. Yes. But you being embarrassed for not addressing the merits of a motion and dancing around and skirting around, attacking, cherry picking, violating the law, abusing your power, abusing your discretion, not listening to what the world is literally telling you. All you have to do is listen. Take yourself off the case. You don't belong on this case. Let someone else take over. Don't be butthurt about it. Don't take this too personally, Judge DeThomasis. This is it right here. You just finally, in like, I don't know how many hours of video we're going to have to sift through before we get to this, at the 36-minute 39 marker of one of the hearings. The video broadcast for the entire world to see, it caused embarrassment, humiliation, potential danger of what? You being removed from the bench? Good. Good. Maybe you don't belong on the bench if you don't know how to properly hold courtroom decorum and act in a proper way that a judge should act. And instead of attacking litigants ad nauseum and wasting their time and trying to milk Jeremy for every dollar he's got as he has representation, maybe focus on the merits for once. That's all we're asking. Either remove yourself or focus on the merits. I mean, at this point, you can't even focus on the merits. You've shown you have so much bias. You're going to rule in Lynette's favor no matter what. So you have only one action at this point. Remove yourself or buckle up, because the whole world is watching. And we want you off the case. Everybody wants you off this case because we don't think that you can be an unbiased person. You are biased and you're prejudicing the Haleses, and this motion should be granted on Friday. Okay, let's get back into it. I just wanted to highlight this because this is finally, maybe people are saying he's talking about Lynette. I don't think so. I think he's talking about himself on accident. He accidentally, you know what happens? It's called a Freudian slip. Maybe he was talking about Lynette, but it's a Freudian slip no matter what, because he is talking about, like, his subconscious accidentally slipped. The truth came out on accident. No matter who he was talking about, this is directly talking about himself. Directly talking about himself. Because he is embarrassed. The whole world is watching, and it's embarrassing for him on the misconduct that he has committed. He has accidentally called himself out. All right, let's keep going. As is clear, the judge impermissibly shifted the burden to the Hales' side of the case with regard to the continuation of Preston's deposition to establish why it should be allowed or continued, when the burden should have been on Preston, the petitioner. That's Lynette. Had a motion for a protective order even been filed on her behalf to show why it should not be allowed. In doing so, he prejudiced the issue based on speculative potential for a problem and elevated the omission of the videographer's name in the notice to cast generalized negative aspersions on Hales' counsel. Judge DeThomasis says, the court perceives the totality of these circumstances as increasing the potential for additional harassment and or violations of rules of court, increasing possibility of violating terms of the injunction, the redaction process. The video depo notice should have been in conformity with what appears to be a continuation of this behavior and arguably enhanced increased behavior that is troubling to this court. Again, unfounded, improper way of looking at it. He's afraid of being called out. He is just afraid of being called out. That is exactly what we call corruption. Mary France Sabai, you could not have said it better. You literally took the words out of my mouth. Most importantly, the court's prejudgment denied due process to the Hales by prohibiting the continuation of Preston's deposition when she had not yet been questioned about her supplemental affidavit, the 400-pager, which was what finally triggered a temporary injunction on December the 4th. Thank you, chat, for filling me in. By the way, don't forget to like this video, comment below, subscribe to the channel, subscribe to Megan, subscribe to That Umbrella Guy. Where are we at with Ray Bone Crusher? We're like at 8.5, I believe. We're almost there. We're almost there, like 1.4, 1,400 more. If you go subscribe to his channel, we'll show it in a minute. I just want to keep going. The following comments were made by Judge DeThomasis, reveal his bias, #buckle up. The following comments made by Judge DeThomasis reveal his bias against Hales merely because of how he earns a living. The result of that is you got a video footage for your own client to publish and to make money on. Where's the problem? His main source of income is monetizing YouTube. And your client has now monetized the posting of unredacted court proceedings. Okay. And of 1129 and 12.6. And resulting in a lot of collateral problems directly caused by them. You're the only one who is seeing them as a problem. So ignore it, move on, follow the law, and it would have been fine. Now it's too late. Now you need to remove yourself from the case. So that's another consequence of there being additional time. And now what I'm hearing this morning is that a depo has been provided on YouTube. Again, it's his depo. I already corrected myself. The Hales have a right to that depo. They're allowed to post it. They paid like over $2,000 for it. And the lawyer gave them a copy. End of story. No questions asked. Moving on. And then regarding the judge's overbroad ruling on sequestration prohibiting unsworn parties and unsworn witnesses to discuss the case, on March 1, the court will start with conducting inquiry as to who spoke to who and will issue sanctions, including exclusion of testimony. I mean, this is insane. This is absolutely insane. Never in the history of the world has this anywhere. Like, yeah, so mainstream media is allowed to make money, but we YouTubers are not allowed to make money. What the fuck is this? What kind of shit is this? I'm sorry for my language, but like, so how is that different? How is that different? How are we different from mainstream media? We're not. Actually, we're way more informed and we care about the truth more than the mainstream media does. I mean, look at the Johnny Depp trial. Hello? Nobody was speaking the truth except law tubers like myself. A judge's personal bias is a proper basis for disqualification. That comes from Leto, a case called Leto. When a judge has prejudiced the case without allowing the opposing party to present argument, denying due process, and issuing gratuitous prejudicial remarks, disqualification may be warranted. Now, of significance here, a judge should disqualify himself or herself in a proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to instances where the judge has a personal bias or prejudice concerning a party or a party's lawyer, which is exactly what's been happening here. That comes from Florida Code of Judicial Conduct, the canon, and Hayship, another case from Florida 4th Judicial District, noting it was understandable that a client would have a well-founded fear that the judge would be impartial in discovering the judge's antipathy towards his lawyer. Now, Lohman, another case from the First Judicial Circuit of Florida, holding that as an indication of bias, which may create a party's fear of not receiving an impartial hearing, there's no applicable difference between statements directed towards a petitioner or their lawyer, their counsel. Klein, another case that has been previously cited in the First Judicial District of Florida, granting writ of prohibition to a party where the judge found the party's attorney to not be credible. If anybody says to you, I don't believe your lawyer because they're not credible, find a new judge. Don't find a new lawyer. That lawyer is probably the best lawyer. Probably, not always. There are some shit lawyers out there. Noting another case, Mikaud Berger, noting party moving to disqualify is entitled to enter the courtroom with confidence that she will receive a fair trial. Everyone is entitled to fair trial. I mean, look at the Murdaugh situation. Those of you who have not followed the Murdaugh case in South Carolina, I am telling you guys, it's a shit show. It's an absolute shit show. But at the end of the day, as much as I hate the guy and he's a piece of shit and he deserves to rot in hell and he's a lying, scheming, conniving, thieving, bottom feeder, even he deserves a fair trial. Because the minute we start to cherry pick who gets a fair trial or not, that is when the system begins to erode. So everyone who enters the courtroom has confidence that they will receive a fair trial. Once we lose that, if we ever lose that, the court system will collapse in the world, not United States, the world. In light of the foregoing, there should be no question that Judge DeThomasis should disqualify himself from this case. Now, wherefore, Jeremy Hales, having met all the requirements for bringing this motion, respectfully requests Judge Craig DeThomasis disqualify himself from proceeding further in this case. This is the conclusion of the motion, and that another judge be assigned to this case, together with any further relief to the court may seem just and equitable. There's a certificate of good faith attached, a special request from all co-counsel for blanket disqualification of Judge DeThomasis from all cases in which attorneys Mark Feather, Esquire, Randall Shockett, Esquire, and Doreen Ingalls, Esquire, appear. Now, they're also asking not just this case, but any further case ever that they will appear in front of. They certify that the instant motion and the statements set forth herein are made in good faith when a judge reasonably concludes that his impartiality might reasonably be questioned because of a personal bias or prejudice concerning a specific lawyer. The Florida Code of Judicial Conduct compels, mandates, must get off the judge to disqualify himself. This logically requires blanket recusals, even though there are no published rules to implement this provision of the code. There's really, like, it never really happened before. This is a first one. Insane. Holt. That's the case. Judicial Circuit of Florida, 2nd. Furthermore, given that the judge's extreme personal bias against Mark Feather has now clearly extended to attorneys Randall Shockett as well as Doreen Ingalls through the case, blanket disqualification from all cases in which the three lawyers, Mark Feather, Randall Shockett, and Doreen Ingalls, will ever appear before him as of today and going forward without limitation and in the future is likewise requested and appropriate. Basically, you have fucked up so hard, Judge. You need to get off all cases we will ever appear in front of you because you will never be fair and impartial as long as we live. Signed, Randall Shockett, Doreen Ingalls, and Mark Feather. And of course, Doreen is the one who drafted this beauty, this baby. This is your baby, and I love you for it. This is an incredible piece of work. This is one of the finest motions I have ever read in my entire career as an attorney, as a litigant. It's just absolutely crazy. Let's see. Megan Fox Ryder, by the way, people are saying she is almost at, she is at 28.6 thousand subscribers, and people are trying to get her to 50,000. Go, go, go. Let's do it. Megan Fox Ryder, this is her channel, so you can search for it. I'm going to highlight it. This is her channel, Megan Fox Ryder. Go right now. Right now, we're going to take a moment of silence for you guys to go subscribe to her channel. Oh, I see somebody in the chat saying, Jeremy Hales paid me for this? No, Jeremy Hales did not pay me for this. I'm doing this because I care about First Amendment principles. What the fuck, man? Again, it's when you're in the wrong, you besmirch. It's called an ad hominem attack. Ad hominem is Latin for attacking the person. Ad hominem. It's like your argument is bad because your face is ugly, you know, and they're doing that. They're saying, he's supporting Jeremy because Jeremy paid him to do this. No, that's not what happened. So shut up and sit down. And also don't forget to like this video, comment below, subscribe to the channel. All right, let's keep going. So this is the certificate. Now, affidavit of Jeremy Hales is attached here. Now let's see what this is about. I have read the foregoing third sworn motion of disqualification of Craig DeThomasis. So this is Jeremy Hales himself saying, I have read it. I understand it. I swear and affirm all statements contained are true and correct. Dated February 16th, 2024. And signed by the clerk. Notary, and filed with the clerk. Now, sworn statement of Doreen Ingalls in support of respondent's third motion to disqualify Judge DeThomasis. So now Doreen writes from herself, and she is speaking to the judge as to why Judge DeThomasis should disqualify himself. My name is Doreen Ingalls. I'm over the age of 18, and I have personal knowledge of the facts in this sworn statement. I've been licensed to practice law in the state of Florida since 1992. So she's been practicing for 32 years. And I've been a board certified in marital and family law since 2006, so almost 20 years. I'm a partner with Shockett at such and such address and been employed there for at least a year and a half. On behalf of the Shockett Law Group, Attorney Randall Shockett filed a notice of appearance as co-counsel in the above captioned case. Prior to that date, Attorney Mark Feather was only representing Mr. Hales in the above captioned case. Attorney Randall Shockett is lead counsel for Mr. Hales in this matter and attended the hearing on January 23rd, 2024. I have provided assistance on Mr. Hales' case. However, I have not appeared in court or attended any proceedings in that matter as of this date. Attorney Shockett is the only attorney who had made court appearances in this case since December 6, 2023. She drafted, she says, the memorandum of law, the 5-page order, disqualification on February 14th, which was denied. Also drafted another motion for sanctions, which memorandum of law supported. She also drafted the respondent's third motion, which is this one. There it is. So that's a fact. Now, in drafting respondent's third motion, I reviewed the redacted video recording, which included recording of the time the judge made specific statements made at the hearing as accurately as possible. I perceived paragraph 9 of Judge DeThomasis' February 14th order, particularly the language stating, and if they are then called upon to account for such behaviors and or to answer or explain such behaviors and or admonished for doing so, they should be allowed a fresh start with a successor judge, as indicative of Judge DeThomasis' intention to report all 3 attorneys working on this case to the Florida bar. So again, it seems to be a pattern. Anytime you do something these people don't like, they're like running to the man. I mean, it's like a Karen. Sorry. It seems Megan is at 29,000, you guys, 29,000 subscribers. Go subscribe to her. This is crazy. This is awesome. Anytime you do something these people don't like, they're like Karens. They run to the manager. They literally run to the manager and say, fix it. Get him off. Like, I don't like this lawyer. Get him disbarred. I don't like what he's saying. Take away his license. I don't like what she is doing. Take away her license. This is unbelievable. This is just completely unbelievable. The memorandum of law referenced in that paragraph is an 11-page. So we're not going to read through this. You're welcome to read it. I'm just going to have it on screen because this is just an affidavit that everything I wrote is true. Everything you're reading is, I can factually stipulate that, because we read all of this already. This is just an affirmation that, yes, everything is true. I reviewed all this stuff and everything is good. So if you want to go read it, please, by all means. But we're not going to get anything new, and I don't want to waste your time. Okay. As an attorney, I can tell you, under the penalty of perjury, I declare the following facts from the sworn statement are true, correct, and complete. Signed, Doreen Ingalls. Okay. Now we get to the exhibits. Here we go. Now we get to Exhibit 1. What is Exhibit 1? Exhibit 1 is the second sworn motion to disqualify. So we may do this on another day, but because a lot of it is probably going to be repeated. But this one was filed February 11th, so 10 days before the one we just read. Again, it's going to address bias, the basis of this motion, and why it's being filed. So we will happily read this at some other point. If you guys really, really want to do it, I'm happy to do it because it's referenced. Again, it's got an affidavit. Exhibit 2, I imagine, is going to be the first. No. Oh, here it is. No, this we want to read. Oh, here we go. Here we go. This we cannot let go of. Buckle up. Buckle up, Buttercup, because this is about to go down. This is the order. This is Judge DeThomas's order that he entered on February 14th, that he filed February 14th at 4:56 p.m. This is the single-spaced 5-page, 2,600-word order. Here we go. Order on respondent's second sworn motion to disqualify. So this is the one he ruled on. This cause, having come before this court upon respondent's second sworn motion to disqualify, filed at 9:47 p.m. on February 11th, so 3 days prior, pursuant to this rule and statute, and this court having limited its review to the legal sufficiency, and we're about to find out this is completely untrue, of said motion without passing judgment on the truth of the facts alleged, and in consideration of said motion, applicable law finds as follows. The above styled case involves a petition for injunction for protection, because this is all weird. It's a stalking case. This is a stalking case. They're making it sound like it's a multiple homicide. Oh, it's a stalking case. Initially filed on 9/7/23. This is after Lynette ran to court after Jeremy wanted to file a stalking and filed a stalking and protective order against her. She said, no, I'm going to get my own. Okay, fine, whatever. Upon review of and by the way, Jeremy's has been granted in Ohio and transferred to Florida without any problems, but she can't even, I mean, I don't feel bad for Lynette, but she's not even getting judicial process. She's getting a rogue judge that's like, I'm on your side, but I'm not going to rule on your motion because I have other things I want to talk about. Like, WTF. A hearing was held 11/1, 11/29. At the hearing at 11/29, testimony and presentation of evidence was not concluded by 5 p.m. As a result, we continued it to 12/6. The court offered to convene the following morning, but we made it on 12/6. The relevance of said proceedings is implicated in the allegations contained in the motion under review. Although a temporary injunction was not initially entered, there was a supplemental filing on December 4th, and that resulted in the issuance of a temporary injunctive relief. The relevance of such a development and the continuance granted by the court at a hearing on 12/6 is also implicated in the allegations of the motion under review, in addition to a hearing held on January 4th and then January 23rd. A prior order denying disqualification of this case was entered on December 26th, addressing matters raised through that date. By the way, don't forget to like this video, comment below, subscribe to the channel if you haven't already, and join on as a member if so inclined. I have 137 super chats and new members that I have to address. So let's keep going, and I'll do that in a little bit. Florida Rules of General Practice and Judicial Administration sets forth the requirements in reviewing a motion to disqualify as follows. If any motion is legally insufficient, an order denying the motion shall immediately be entered. Subsection C sets forth the requirements of a proper motion. The motion under review is legally insufficient as follows. While the facts alleged in a disqualification motion must be accepted as true and the legal sufficiency of said motion is a question of law, legal sufficiency involves more than mere averment. See Bodden. The motion must state a factual foundation for the party's fear of prejudice, and the duty of the reviewing court is to ascertain whether the facts as alleged in the motion would cause a reasonably prudent person to fear not receiving a fair trial. So he's just stating the law. A motion to disqualify will be dismissed as legal insufficient if it fails to establish well-grounded fear on the part of the movement that they will not receive a fair hearing. See Coral. Further, the party seeking disqualification bears the burden to show well-founded fear of not receiving a fair trial. That's forehand. A verified motion for disqualification must contain an actual foundation for the alleged fear of prejudice. That's Fisher. A mere subjective fear of bias will not be legally sufficient. Rather, the fear must be objectively reasonable. That's Wall and Adkins. Further, adverse legal rulings are not legally sufficient grounds for disqualification. So that's the law, right? Coral, Jackson, Alt, Department of Agriculture and Human Consumer Services versus Broward County, JJN FLB LLC, and Clark, citing Clark. Now, although the judge writes, the basis of the motion under review is alleged by the respondent to be limited to the events that transpired in the court on January 23rd, 2024, see paragraph 10 of the motion under review, for which there is a complete record. The comments made by the court and the relevant inquiry conducted by the court on that date also references prior court proceedings held on November 29th and December 6th and January 4th. And the intervening behavior of the respondent and his counsel. To the extent any reviewing court deems the totality and context of the actual language delivered on each of these dates to be relevant and material, a recording and/or official transcript would be available as the nature of the proceedings below required the court to maintain such a record. All right, let's go through some of these because I know you guys have questions. Like, what is going on here? Because I also have questions. So let's review. Freeman says, the person that called your office is known in the Hales community. Ask Jeremy about the dude sharing his family info. Thank you, Freeman. That is good information to know. Matt Bond says, hey, spiffy, legal mumbo jumbo, talking no boozing while cruising, dude. I was going to send you this a year or so ago. It's nuts. Yeah, absolutely. Thank you. Thank you, Kyokook, for your generous donation. Welcome, Hans Itel, for joining on as a member. Welcome, welcome. Shirley Dern, thank you so much for your generous donation. Kathy McClure, buckle up, people. This is just getting started. Hashtag buckle up. Thank you, Kathy. Michael Dean, Larry, did you see the Hale post this morning? Yes, I did. Thank you for reminding me. Mickey, welcome to the YouTube channel. And once again, Muck Duck, you are a god, sir and or madam. The judge seems to be like the character from Ghostbusters when they're in court and he loses his shit and suffers the consequences. That's funny. Bonnie Fleming says, Larry, Megan, do you think the What the Hales fans have a lawsuit due to the judge taking away our First Amendment right as well? Maybe. This is a can of worms we don't want to open yet. We want to resolve this first. Sherry Seaver, thank you for standing up for First Amendment rights, Larry. Absolutely. This is all we have. If we lose that, what else do we have? We love you, Megan. I will be sure to tell her you said that. Espresso. Welcome, Craig Wolf. Thank you for becoming a new member. And also Debbie Childers. Sorry if I'm mispronouncing that. Beverly, please look at Lynette's text that Jeremy posted today. The woman is threatening unaliving herself. Wow. We don't even know if it's her. It could be anybody. So I don't trust anything. I don't trust anything I see on the internet until I have proof. That is terrifying. Brandon M says, been watching What the Hales for years, been following the story. I found Ray Bonecrusher almost a week ago, been watching his videos and just found your channel. A new sub to you. Thank you. Let's check it out. Bonecrusher is almost at 10,000. We are so close. We are so close to 10,000, you guys, for Bonecrusher. Go and subscribe to his channel. I'm going to keep this up on the screen. Because I want to see him grow. That's what I want for him. I want to see him get to 10,000, maybe even 15,000, depending on what we can do. At least 10,000. And we can't end this stream without Bonecrusher getting to 10,000. I refuse. I simply refuse. He deserves it. He's a stand-up guy, and he will have doubled in subscribers overnight, and he deserves every bit of it. He supports the Hales as far as I can see. I don't know if he held a different position before. There's nothing wrong with changing your position as long as you stick to your guns and you're not going back and forth and flipping, yes, I support him. No, I don't. Yes, I support him. No, I don't. Like, as long as you're not one of those guys, and Ray Bonecrusher does not seem to be in that camp so far as he has proven. He's got a track record up until now. Things may change in the future. I don't know. I don't really care. We'll keep watching. It's really, literally evolving in real time. The planet is watching this case, says Shane Cook from Wales. Thank you, Shane Cook. C. Douglas says, WTH follower, What the Hales follower, love your channel. Thank you very much. Jay Selman, Jays, again, thank you so much. You two should check out Christmas in the Creek Vide and What the Hales buys out a toy store to see how Jeremy and George are the sweetest people. So you guys go check it out, and I will check it out in my free time. Pebs W says, Ray is very passionate about the Hales case. He's probably watching right now, which he was. He was in the chat. This was incredible. We had the whole family here. He is a sweetheart. He seems like it. Ashley Lawson says, love it when good people come together to help others see good people. Yes, Feather was accused by Lynette of bribery. She's beyond pathetic. DeThomasis thinks he's interviewing for the Supreme Court. He's so narcissistic. Oh, he's trying to get a position. It's possible. And we got a bunch of members: Sue Taylor, Christy Newland, Abby 63, Shane Cook, and oh my God, you guys, I love you guys. Muck Duck Incorporated again gifted 20 to DUI Guy memberships. Shout out if you got a membership from him. This is wild. You guys are just unbelievable. The support for the Hales is for the channel, for me. I will take it. I will take all the credit for this stream. And I love you guys. I truly do. You're just incredible. Mickelson 1972. Thank you for 169 DKK. What is DKK? DKK currency. Oh, the Danish krone. That's right, the Danish krone. Very cool. You're from Denmark? Danish is Denmark. Yeah. Valerian Thorson, thank you for the 25 Knox. Hello there from the land of the fjords. I love it. Mary Franklin says, just subbed for Megan and had previously subbed for Bonecrusher a couple days ago. Thank you so much. Let's keep it going strong. This I'm for the UK, and I've been with What the Hales way before the lockdown. Thank you for helping my family. Wow, Juliet Morgan, thank you for the kind words, and I'm glad that they were able to help you so much. The Fluffy Cat, watching from Scotland, love legitimate legal commentary that upholds the law, unlike the sovereign citizens. $5 from Sue Taylor. Thank you, $5. Thank you, Sue. Helen Gall, super sticker from New Zealand. Thank you so much. Chris M. Ray Bone Crusher is in the chat. Yes, we did see him. We said hello and we highlighted his comment. Kathy Martinez, thank you for the $20 super chat. Jill Mitchell, the judge would say the planet is watching. Yeah, absolutely. 100%. Wrinkly's Carnage Crew. Lynette is so-called 501c3. Therefore, no redactions necessary, null and void. Maybe. I mean, that you're saying she's a corporation. Maybe. Not a corporation. What is it called? 501c3, nonprofit organization. Texas Katie did. Your phone carrier can tell you who made the block call. The block just stops caller ID from showing you. Ask a judge for a subpoena. Interesting. Oh, I might look into that. Terry, American woman, thrifter, Ray Brooncrusher is here. Yep. Following from Denmark, a Hale fan for years. Thank you, Mickelson, 1972. For the Danish Crones. Mike D with some pounds. Hi from Scotland. It is great to see other channels pick up this crazy story where great guys do great work. Just Shelly, thank you for the 5 gifted subs. Again, shout out if you got a free sub from our friends. I love you guys. Hashtag buckle up. Hashtag buckle up. That's right, Tracy Crum. Hashtag buckle up. This is evolving in real time. Now, next, where are we with Bone Crusher? 8.72, so close, like 1,200 left. 1,200 people to subscribe to him, and we hit our mark. And we're going to continue reading the judge's order in a minute. Yep, Bone Crusher is here. Everyone was calling that out. Bone Crusher is in the house. Yep, that's exactly Kathy. Support and love to you, Jeremy and George. Harriet Williams, thank you so much. Wyatt Cox, corruption abounds in small towns across America. YouTube and independent local media, like my local radio stream, Kelly, are the cure. Wyatt Cox, hey, corruption abounds in small towns. That rhymes. I feel like that was intentional. YouTube and independent local media, like my radio station, KELY. Go check him out. Seems like a legit dude. Plugging himself in, but hey, I'm not here to judge. Respect the hustle. Nikalina777. Hey, HBD. Happy birthday? I don't know. I exposed these types of cases via lawsuits in Michigan. Pete, my attorney, Philip Ellison. We sued under OMA and ARPA, founding misappropriation. Thank you, Joan Sclafani, for your generous super sticker. Project Constitution. What the Hales? Stay away from delete laws. I can send you the video where he doxed all my personal info for me and my family and threatened my life this week. Constitutional freedom fighter. Travis Hines needs your help in McCracken County. Yes, I'm aware. Yes, we're in touch. Yes, we're working on it. Diana Bullock, welcome to the channel. Kathy Cav, welcome to the channel. Ms. Krim, one way to support Jeremy and show the judge that the public is watching. For those that can attend the public hearings on this case, perhaps then this judge may wake up. Hey, showing up. It's a public courtroom. Babs Massiere, $99. Thank you very much for the super sticker. Boru says, thanks for helping and bringing Umbrella Guy. Absolutely. Absolutely. Mary Burchett, justice for What the Hales. Sassy in the UK, welcome as a member. Limo Man 412, welcome as well. Jacqueline Weaver, member for 14 months. Welcome back. Sassy J in the UK gives us 10 gifted memberships. Wow. Thank you. John Tyree, welcome as a member as well. Also, I'm trying to find all the new members. Carol Smith, welcome to the channel. Who else do we have here? Sweetie Turner, Sergeant Mom, also welcome to the both of you. Charlie Lynn gifted 5 memberships. Shout out if you got a membership from Charlie. Ty Powers, welcome to the channel. Rose Chapman, new member. Buckle up, Rose. It's going to be a wild ride. Hashtag buckle up. Stickley, welcome to the channel as well. Kermit McCown, welcome to the channel, and thank you for the super sticker. We need People USA. Well, sorry. Yeah, We the People USA. Welcome to the channel. What a great name. Lisa Trimmel, also welcome to the channel. Annette Kalimudin. I'm sorry if I'm mispronouncing that. Welcome to the channel. Same with Zeniba Garcia. Welcome to the channel. Sue Chat. Welcome to the channel. Amrisa Loftus. I've been afraid of the justice system due to being a part of the LGBT community, and see you guys is helping to not making it so scary. Thank you. You are welcome. This is what we do. We speak. We're the voice of the American people. You guys are the voice of the American people. What is Ray at now? 8.84. So close. So close. We're almost there. Espresso, I hope you all could shut the crap down because it is ignorance. I wish. Terry. Terry, thank you very much for your generous donation. Jack's mom, would a petition to help get rid of the judge? Well, that's what they're doing. This is literally you're talking about like a petition outside. I mean, I don't know. Maybe not yet. We'll see. Gitologist channel said in live chat they are reaching out to Lynette to get her side of the story. Wanted to let you know that's fine. I know who the gitologist is. He's a good dude. He just wants both sides. He just wants to hear both sides. Gina Hampton Duke says crazy. Yes. Insane. No. Candace Bingham, I need to talk to you about Lynette's adopted daughter, the 4-year-old. If we can talk, please let me know, and they'll send you my phone number. I've heard stories. Yes. Kim Sims, the judge, also took the Hales' Second Amendment right to bear arms. Yep. While the temporary injunction that's been in place since December 4th. I mean, we're coming up on the January, February, March, 3-month anniversary. 3-month anniversary of he can't hold a gun, Jeremy Hales. This is stupid. Deborah Roth, thank you very much for the donation. Connie Smeltzer, as a Canadian, I'm thankful to you for defending the planet's rights, right? This is not just the American rights. This is the rights of everybody on the planet. Jack's mom says Otter Creek had no police force. The county shows up if something happens. The judge took away his protective guns. He can't even hire protection. Tiffany H, super sticker. Thank you very much. Gil Montano, can Judge Dumb Talkative's actions trigger reviews of past hearings with others and familiar unconstitutional actions and Iraqi rulings? Sure. Yes, absolutely. Somebody needs to look into this guy. He's insane. Mary Burchett says perhaps What the Hell fans should donate to cover their fees. That's one idea. Absolutely. Ugh. Hashtag ugh. What the Hell's family understand why. Big P says this is either JC or LP Town Network. Liz Bird, I'm UK. You need to fight for your amendment rights. The reason America is called the land of the freedom. Lily Smith, Megan, if you posted info, I missed it. Chat too fast. Can you please do a video? Do I need to contact Kat Kamarack, the representative in Levy County, or all legislatures? So we're going to be live on Megan's channel. Excuse me. We're going to be live on That Umbrella Guy's channel tomorrow at 7 p.m. Eastern. Link is in the description of his channel. Also, we're going to be live with Megan on Tuesday, February 27th on her channel at 4 p.m. Eastern time. And both of those are going to be streamed on their respective channels, not here. We got to share the love. I do not want to hog this. I want to share the love. And so Megan and I, and What the Hells are going to be on both videos, I believe. We already had them on our channel. If you want to go into the lives, you'll see we had a live where they told their story on my channel. And that happened last Thursday, the 22nd. Doesn't she have like 30 aliases, says Graham Ellis? It seems like it. I don't know, but this is what I keep hearing. This is what people do when they are in the wrong. They hide behind facades and veiled accounts rather than speaking the truth, because they know if they speak the truth, they're going to lose. It's just life. Welcome to life. Watch her testimony before you invite her. Fair enough. That's a very interesting, because people said she has like a very screeching voice, and it's a very annoying voice. And based on everything I'm seeing, I mean, there's always 3 sides to every story. You know, their side, her side, and the truth. If she is going to be like incessantly annoying and loud and obnoxious, I'm not going to tolerate it. I have a right as my own channel. I'm going to heed your warnings. Oh, what a beautiful number. 888 subscribers, 8,880. You guys are amazing. We already netted him almost 4,000 subscribers just today alone. This is wild. This is absolutely wild. You guys are awesome. So before because I said, you know, there are two sides to every story, three sides with the truth. I mean, if she is going to be a very, because Jeremy and George seem to be cool people, and we like cool people. If we're going to have a person, she removed. I have full control over my channel. This is my channel. I can do, you know, I'm like Cartman from South Park. You know, whatever, I do what I want. I do what I want with my channel. This is my channel. So if Lynette wants to come on to tell her side of the story, I'm more than happy to entertain that. Absolutely. But if it's going to go sideways and south, I will remove her. That's just a fact. I am entitled to do that. I'm allowed to do that. And I will watch her testimony to make sure if I even want this person on my channel. You know what I mean? I may not want her at all. I don't have a fiduciary duty to disclose both sides of the story. I am covering what I believe in, and I believe this judge is violating the law. It's no longer about Jeremy anymore. It is about the First Amendment right. And Lynette has no bearing on that at all. Lynette has absolutely no bearing on it. And if she's going to be talking over me, she will be removed, and it will be a 5-minute video, you know, and maybe less. I think right now we need to focus on the main event, and the main event is the fact that Lynette and Jeremy, no offense to them, and they get it. They get it. This is beyond Lynette and Jeremy at this point. This is about our First Amendment rights being eroded by a rogue judge with black robe syndrome. And that's what it's all about. That's what that's all about. I've watched What the Hales for a long time, says Matt Bond, before this, and I can say that he has got the law, I'm guessing Judge DeThomasis got the law wrong at times, but what is going on with the judge and Preston is batshit crazy. With spoken with emojis. Alan Walker says new levels of corruption and good old boy networks are exposed every week down in Florida. Not surprising at all. Muck Duck Incorporated says Megan hit the nail right on the head. This judge is experiencing his 15 minutes of fame because Jeremy is a celebrity. He's also up for re-election this spring. Everyone vote him out. I mean, that's terrifying that he's using Jeremy's platform to try and like win his election or re-win his election. And that is disgusting. I hope he loses. Based on everything I've seen, Judge DeThomasis does not belong on the bench. That's my personal opinion. Judges grudge fudge on sale now. Thank you for that, Dan Low Fat. Kimberly, thank you so much for the super chat. Big Ray's ball cards. Lynette is her legal name. Michelle is her daughter's. Okay. Tracy T, thank you for the super sticker. Damo says, keep up the good work. I'm in the UK and I love all things US, whether it's politics, law, most importantly, actual justice to any and all injustices. See, that's what it's all about. I hate bullies regarding what form it comes in. And at this point, it's no longer about Jeremy or Lynette. It's about the First Amendment right. Cynthia Barnes, thank you for the super chat. Sapphire Sky, it is against Ohio Child Protective Order. CPO for Lynette to speak on this matter. Okay, well, maybe she even can't. Maybe she can't. If I don't want to have her on and violate the law. Craig of Scotland says, at the start of all, judges threw out 300 of non-hearsay evidence by Lynette. Then he changed and went after Feather. Liner lied about it. Feather saying he went and offered Lynette money to go away. Okay. Thank you for that very much. Big Race, again, Lynette just texted Jeremy threatening to unalive herself. Again, we don't know if it's her, but even if it is, it may just be a scare because she sees the writing on the wall. See, when a person is pinned down against the wall, you know what happens? They get defensive and they start getting upset. They start getting sad. And this is another way to just seek attention. It's just another way to seek attention. And that is not okay. This is not civil protection order. Thank you very much, Susan York. CPO, civil protection order. This is not okay. It's not okay. You cannot use the pain that you have, helped create and then say, well, I am threatening, because that's what she wants. She wants attention. I mean, that's obvious. That's clear. That is completely and unadulteratedly, I may have just created a word. Obvious. And this is what they're talking about. We don't even know if it's her. Recent text messages that Lynette sent, yes, they're real, according to Jeremy. Again, this is now all hearsay, double hearsay, triple hearsay. It's Jeremy saying it's a message from her. I don't know. I don't want to look into it because it's not relevant to our analysis here. We're reading, the judge's order. We finished reading the motion. We're now going to resume reading the order in just a moment. I'm trying to catch up on super chats because this super chat came like 2 hours ago. And I've just been trying to focus on, and I don't want to leave you guys hanging. I've just been trying to focus on, getting you guys the full facts. It's good stuff. It's really good stuff. Megan Fox is almost at 30,000 subscribers, you guys. Let's get Megan Fox to 30,000, excuse me. Bone Crusher, look at that. Bone Crusher is almost at 9,000. We're going to get him to 10,000 here. And this is Megan's. We're going to get her to 30,000. This is unbelievable. You guys are amazing. Unbelievable. I'm going to leave her up now for a little bit while I continue reading super chats. And then we'll get back to the judge's order. Kathleen Sanchez, thank you so much. Been watching What the Hales for a while now. Thank you so much for getting involved in this. They need all the help they can get. We all need all the help we can get. This is, again, like I said, this is beyond them now. This is beyond them. Tina Childs, thank you very much for the generous super sticker. Terry Haddock, same goes to you. Thank you so much. Buckle up bees. Hashtag buckle up, Tracy T. Exactly. There we go. Michelle Natali, you will need massive pain meds. If you talk to Lynette, she'll give you the worst headache ever. It's possible. Maybe. Expand the docket, says Lisa Jewett. Akoshe entered his appearance on 12/6 or 12/7. Okay. The judge also acted like Lynette's lawyer in the beginning. He gave her a ton of advice. That's completely improper. Feather had to drop in December. Okay. Thank you very much, MS Crime. Charlie Lynn, thank you for highlighting this miscarriage of justice. Would you possibly do a little video on Tara Reid? I did. I have videos on Tara Reid where I actually have Turtle Boy, what's his name? Aiden. Aiden was on my channel a couple of times, and I did videos in September and October of last year. Check out the lives. They're in the playlist, and you can just go to the live tab, and you will find all of my Tara Reid videos. That's another insane case that I can't wait to see unfolding. What's his name? Aiden was arrested. Turtle Boy. His nickname is Turtle Boy. Turtle Boy was arrested for sharing the truth, it seems like. So that's going to be another one to watch, another corruption situation. So go check that out. Megan it's always a pleasure, Foxy Lady. I'll tell her you said that. You are Hollywood material. Oh, man, Boyan, I love you, bro. I effing love you, bro. I'm making a YouTube short from this for tomorrow, says Boyan. You are a mensch. Here's my shorts makers. Thank you for the super sticker, Grace Washburn. That's one. Hails of emotion, says Darlene Probus. Yes, I agree completely. Thank you for your generosity, Jan Marie Harmony. Bus stop person number 27. I looked so far. There is not a Judge DeThomasis Reddit page that I could find. I keep wondering if he'll ever get a fan page. I don't know. He may never. And so we name you paragraph 42, says Liz Bird. Paragraph 42. Is that the answer to the universe? 42 is the answer to the universe, right? Hitchhiker's Guide to the Galaxy. Stickly, thank you for the sticker. Stickly, thank you for another sticker. Harriet Williams, hashtag buckle up. I support George and Jeremy. Feather could no longer be his attorney since Lynette accused him of trying to bribe her, so he's now a witness. Dart B1, possibly, maybe. Damo, keep up the good work. I'm in the UK and love all things US, whether it's politics, law, support. Okay, so I hate bullies. Thank you again. Unless I double tapped on this, maybe you shared it twice thinking I didn't see it, but thank you twice if you donated twice. Samantha Wilson, thank you for your generosity. Valerian Thorson with Knox, Norway is always watching. Yes, they are. Peter Tragos, lawyer you know, is only 2 hours from Otter Creek. Would be fun seeing him get a jump on it. Hey, everybody's jumping in on this, and nor do I blame them. This is the hottest thing since the Murdaws last year. I believe EXE, the reasons Feather said he could finish in 15 minutes was because Australians, he wanted the case dismissed based on the fact that Lynette did not file her motion properly. Maybe. There you go. See, so the judge is prejudging the case. Again, Nathan C., Governor DeSantis needs to be more aware of this. There you go. Mostly the legislature. Remember what Megan said. Follow the money. Follow the trail of crumbs. What do we want? We want justice. How do we get it? Remove Judge... my brain just froze. Judge... I swear, my brain just forgot his name for a second. Why can't my brain literally? It's been 4.5 hours, you guys. You'll have to excuse me. DeThomasis, thank you. Oh my God, I completely blanked on his name for a second. Judge DeThomasis, to remove Judge DeThomasis, the only way to do that, the only way to properly do that is to go through the legislature. Thank you, guys. Thank you so much. What would I do without you guys? I would be just talking to a mirror, literally. Using Jeremy's words here, just do the right thing. I love you all. You guys are the best. It amazes me that 4 hearings in, and Jeremy has not even been able to speak. All court time has been eaten up by the judge, chastising him a little. Exactly, Michelle. This is exactly what we're talking about. He just can't focus. Maybe he needs his ADD medication. Maybe he's got the black robe syndrome. I mean, annoying. Brian Watkins says, Larry, make sure to say hi to Lynette and her judge, DeThomasis. You know they're watching and taking notes. Oh, sure. Fine. Absolutely. Hi, Lynette. Hi, Judge DeThomasis. Sarah Marie, at the end of the first day in court, DeThomasis told Feather and Lynette to get together via phone to see if they could find some common ground. The next hearing, she claimed he tried to pay her off. So you can't even try to reason with these people. They just maybe lie. I don't know. Ellie Fant. That's a cool name. Ellie Fant. Like elephant. This case sounds like something that Viva and Barnes would be interested in. There you go. Some more publicity. Pepper, North Carolina, thank you for the super sticker. And thank you for another super sticker. There's 2 of them. Thank you for both. Nicole Rogers, Levy County residents, remember, hashtag grudge judges up for re-election this year. Vote him out. There you go. That's another way you can help the judicial process stay clean. What the hell is going live at 7 or 8? Somebody said 7. Somebody said 8. Maybe they, let's see. Maybe they are going live in an hour. I'm sure they're probably waiting for my live. Yeah, they're waiting for my live to end. So they're going live in 20 minutes. So let's wrap this up, you all. Let's wrap this up so that you guys can go over there and enjoy the show, because I'm sure they have a lot to share. Bone Crusher is at 9,000 almost, like 10 short of 9,000. We got this, you guys. So they're going live at 8. They probably keep pushing it because I can't get this thing wrapped up. I mean, it's a lot to cover, and we're still not done. We're definitely gonna have to do this again. And I already said we're going live with Tug, with Megan Fox, and we're gonna continue this train going. Kenneth D. Green, welcome to the channel. Same goes for Katrina Kerr, Paul LLB UK, and Karen Kilpatrick, and Michelle Lavoie, and Mr. Risky, and Roy Massey, and Janine B. Magic, and Dennis Copard. So everybody, welcome to the channel. Thank you for joining, and let's continue through the super chats. We only have a handful left before I get back to the motion. Love what the Hells and their mission are in life. Yes, Sergeant Mom, that is Lasonia's Couture. Thank you so much. Sergeant Mom 2 says, what happens if the Thomases refuse to step down after this motion? You will see. It's probably going to be they are going to appeal to the Supremes. Remove him. We need your help. Coming from the Yorkshire Dales, England, can I please just wish this judge all the best in his next job, because surely he cannot get reelected. So I hope he buckle up, because I predict a bumpy ride. So I hope he hashtag buckle up. Hashtag buckle up. Is it trending on Twitter yet, by the way? On X, Twitter, whatever it is. Do we have it trending? Let's see. How do you home? What's happening? Hashtag buckle up. If not today, it's definitely going to be trending by tomorrow. I'm telling you. There's no way it's not. Trending. Suarez. I don't see it yet, but it's probably on the cusp. It's got to be on the cusp. There's a lot of football games happening today, so they're probably dominating hardcore. Kenneth Hedegaarden, thank you so much for the Danish Crones. Great job, Larry and Hi from the UK, says Paul LLB UK. Thank you so much. We're almost caught up. Jeremy's going live at 8. There we go. John Kohler, so he's going to be live in 20 minutes. Karen Whiting, YouTubers, you want to grow your channel? Get on the WTH train. Like, what the hell? What the Hales? Love it, love it, love it. Hi there from the Netherlands. 8-It Fricks. Thank you so much. Kelly Brightenbaugh. Like she was paralyzed to her home, yet she wants to run for council. She will say whatever she wants to get her way. I think you're talking about Lynette. All this judge has to do is dismiss the case, and he is out of it. I mean, yes, that's one way to do that, but he has to listen to the merits first. New York half-ass prepper. I see you're living up to your name. You're half-ass prepping. I'm just joking, but truly, the judge needs to listen to the merits. Justice for everybody. Even Lynette deserves to be heard. That's the bottom line. Dan Davis, I sure am glad Jeremy is fighting for our rights. Some of us don't have the resources to fight City Hall. Exactly. Absolutely. Liz Bird, paragraph 42 of the motion, whether you did where I did a voiceover with facial expression, but I like the Guide to the Galaxy better. 42, you can't make this stuff up. You can't make this stuff up. The universe has its own little jokes. Thanks for your support for all. Thank you, Cynthia Cantor, for your support for the channel. I think Judge Craig C. DeThomasis is Russian. He act like that, and maybe he's friend with Putin. Hey, I am Russian, so don't hate on the Russians. I was born in Russia, but I live in the United States of America, and I'm an American citizen. But yes, I was born in Russia. And I mean, hey, people have a lot of bad things to say about Russia these days, and I do not agree with their policies. So justice and peace in the Ukraine. Kathy Mowry, thank you for joining on as a member. And I think we are now finally caught up. Let's see where we're at. Bone Crusher. So Megan Fox is at 29.5. We're almost there. 500 more, and Bone Crusher is at 9,000. Oh my God. At least we got him to 9,000, you guys. I'm happy. He doubled in subscribers thanks to this stream. I will take it all the way to the bank because we are responsible. I am responsible. You guys helped. You guys are awesome. I love all of you. Okay, let's get back to the main event. That is the motion. Wrap this up so you guys can go check out of what the Hales have to say about what's going on. It is true, continues the judge, that on January 23rd, 2024, this court did make oral pronouncements that were adverse to positions being advanced. So he admits that he made adverse statements, pronouncements, which he calls them, being advanced by the proponent through his counsel, talking about Jeremy Hales, regarding the posture of the case and the intervening developments, some contrary to law, that again precipitated another request for continuance. These included, but were not limited to, the following on the record proceeding. On 11/29/23, in response to the court inquiring whether he, the respondent, would be available to reconvene the following date at 9 a.m. to complete the hearing, co-counsel for the respondent, Mark Feather, represented to the court the following. No, Your Honor, Mr. Hales is having to address matters in Ohio court related to the situation. He has to be there tomorrow morning. Based on such representation, the court continued the matter, which at the time did not have any temporary injunctive relief in place, to reconvene on 12/6. Now, during the proceedings held on 12/6, this court learned from co-counsel Randall Shockett and the respondent himself, Mr. Hales, on the record. And the respondent did not actually need to appear in Ohio on 11/30, and that he only needed to sign documents 2 days later with his Ohio attorney. And this is where the judge, I guess, confused what actually was happening. As a direct result, it is true as alleged in the motion under review that the court did admonish counsel for a lack of candor. So you're accusing counsel of lying. He accused Shockett of lying to his face. He is accusing Shockett of lying to his face. Did admonish counsel for lack of candor towards this tribunal, and such behavior was again addressed in 123, and the court considered the totality of the circumstances in the case when deliberating on additional motions being adjudicated. This guy cannot be on this case. He needs to be off. He needs to be removed. He needs to be off this case. Further, despite the clear dictates of the Florida Supreme Court and the administrative order such and such and the 8th Judicial Circuit administrative order such and such, there was undisputed evidence that confirmed attorney for the respondent, Mark Feather, despite having previously signed an attestation that he was aware of the admonition regarding the prohibition against dissemination of unredacted copies of court proceedings, did disseminate the unredacted copy of the 1129 court proceedings, as he was the only person to have requested an unredacted copy on his client, the respondent, and then did broadcast the unredacted copy on his social media platform, YouTube. It is true, as alleged in the motion under review, that counsel was admonished on January 23rd for such behavior, as it was contrary to the dictates of the Florida Supreme Court and the Chief Judge of the 8th Judicial Circuit. Again, he's trying to impugn what the Chief Judge of the 8th Judicial Circuit is doing and saying, I admonished him as well, which is not his job. He's doing other people's jobs. The Florida Supreme Court issued this order on July 20th, 2011. Said order attached and incorporated revised standards of operation and the best practices in part to standardize court operations, while continuing to protect from inappropriate release any confidential information that may be captured on electronic recordings. The Florida Supreme Court further directed each judicial circuit to codify protocols for producing copies of audio-video recordings. Again, this has all been debunked. We already said is the same copy, redacted, unredacted, unchanged, exact minute, second, and he's just running with it. It states the following: copies of audio recordings may be made available, seller can get it unless confidential information may be contained, and they just have to make sure to protect it from being disseminated. Obviously, in accord with the Florida Supreme Court directives regarding the release of it, there are some protocols for it. Again, as follows: copies of electronically recorded court proceedings shall be provided upon request, and the requesting party shall be required to complete and sign a written transcript. Okay. It is true that on January 23rd, the court did express dissatisfaction and admonished counsel, again, wrongfully so, and the respondent for broadcasting the unredacted audio-video recordings of court proceedings. Again, not his job. Despite the clear dictates of the Chief Justice, again, he already addressed it. Why are you readdressing it? Of the Florida Supreme Court and the Chief Judge of the 8th Judicial Circuit. Further, on that same date, January 23rd, the court also learned that Attorney Randall Shockett conducted a video deposition of petitioner without complying with the Florida rules. Again, this has been debunked because it was just, they didn't have the name of the videographer. And when Lynette showed up to the deposition, that was already cured because she was representing herself and she ended up doing the deposition anyway. Despite having conducted said deposition in contravention of the applicable rule, the respondent had published and publicly broadcast, again, no rules against that, said deposition on his social media site. It is true that the court expressed dissatisfaction with such a violation and denied counsel's ability to play the video deposition, which was taken in non-compliance with the rules of civil procedure. Again, all debunked at this point. It is true, as alleged in the motion under review, that on January 23rd, the court also commented upon a proffered memorandum of law that was presented by the court by Attorney Randall Shockett, submitted on January 22nd. See docket entry 97. That, in the court's view, unnecessarily, unprofessionally, and gratuitously criticized opposing counsel for filing a limited notice of a practice. So again, ignoring all the stuff about discovery violations by Lynette, focusing on the one thing he cares about, his buddy, and you're attacking my buddy and I'm not okay with it. For the purpose of advancing argument, to continue on behalf of the petitioner's counsel, averred he had a conflict and could not and would not be able to serve as counsel in the event the court did not change the next scheduled hearing date from the January 26, 2024 date previously scheduled. As the record would indicate, the court did admonish respondent's counsel for presenting such an argument and in such a manner, as the court also remarked and reminded Mr. Shockett that he, Mr. Shockett, filed his own notice of appearance 24 hours prior to and already scheduled hearing date scheduled for December 6th, and as a result, he advanced arguments he could not possibly be prepared and thus required a continuance, which was granted. The rhetorical and condescending language advanced in a filing labeled memorandum of law, which again has already been debunked because the judge is himself refusing to address the merits of the issues of discovery by Lynette, and he's focusing on attacking Mr. Shockett instead of focusing on the merits, and which was why he should be removed, disqualified, recused, etc., and which described as wholly unacceptable behavior opposing counsel was, in fact, the same behavior previously exhibited by respondent's counsel. As stated above, adverse rulings and or even series of adverse rulings are legally insufficient grounds for disqualification. Further, as the case proceeds in the trial court, it is the court's responsibility to assure the orderly administration of justice, the fair application of law, and that's a loaded statement. Orderly administration of justice, fair application of the law. You have not been doing that for a single second here, Judge. I'm sorry. It's fact now. And to assure counsel's adherence to regulations of the bar, as well as code of professional conduct in their dealings with the court personnel, and opposing counsel. It is necessarily an obligation of the court to question counsel regarding behaviors affecting the administration of justice. So I have to do this, maybe on a limited basis, but you've spent 4 hearings on this now, at least 3, and to place on the record the specific critical concerns of the court, and was done in each of the prior hearings. And he admits it. It was done in each of the prior hearings. And to allow response of counsel, if any, concerning any and all transgressions and or violations of law and or standards of conduct that directly affect the legal process of the case to be adjudicated by the court. Any objective review of the proceedings held on January 23rd, 2024 would not cause a reasonably prudent person to fear not receiving a fair trial. Bullshit! That's a lie. I don't believe you. To grant disqualification on the basis of the matter averred in the motion under review, which consists of confronting counsel with their unacceptable behaviors and actions contrary to law. Sorry for the outburst, but that is like the most biggest misstatement of fact that I could possibly find ever. Would be tantamount to allowing attorneys and or litigants to violate the rules of the Florida Supreme Court, orders sent by these, and these guys, and to surrender and abandon all precepts of the regulated practice of law. And if they're then called upon to account for such behaviors and to answer and explain such behaviors and be admonished for doing so, they should be allowed a fresh start with a successor judge. Good Lord. Good Lord. Regarding the avertments, again, the reason for the outburst, an objective review of the proceedings on January 23rd would not cause a reasonably prudent person to be fear of not receiving a fair trial. I watched it, and we're going to watch it together with Megan on Tuesday. That is why my outburst. You guys don't know this yet if you haven't seen the hearing. We're going to watch it on Megan's channel on Tuesday at 4 p.m. Eastern. Go check it out on Tuesday. And tomorrow we're going to be on That Umbrella Guy's channel. Holy cannoli, what is going on in this state? Regarding the avertments contained in paragraphs 11 and 12, and without addressing the truth of such, it is illogical, irrelevant, and inconsequential to accept competing hypotheses as avertments that can be attested to by the affiant. Claiming competing hypotheses are both concurrently true represents pure subjective conjecture. Again, he has to bend over backwards so far to say, I don't need to remove myself. When you have to bend over this much backwards to try and justify why you shouldn't recuse yourself or remove yourself or disqualify yourself from a case, you know you're in the wrong. That's basic common sense at this point. But we already know it's beyond that. Claiming competing hypotheses. Additionally, as to paragraph 14, the affiant cannot attest to the truth and veracity of an event that he was not privy to, as he correctly avers that he was not in attendance and thus has no personal knowledge. These additional matters are likewise legally insufficient to grant the relief requested. Basically, I'm not removing myself. Given the nature of the underlying allegations involving cyber, finally, look at this. He spent 9 paragraphs, single-spaced. I mean, it's really hard to read when it's not double-spaced. I don't know if it's intentional or he's trying to save on paper. Does the state not have money? I don't know. He went for 9 paragraphs, again, going on and on and on and on and on. And finally, one paragraph, paragraph 10 is finally looks like it's going to talk about something related to the case, actually related to the merits. Let's see. Given the nature of the underlying allegations involving cyberstalking under Florida statute, 784.0485, it is also true the court addressed terms of the temporary injunctive relief with due consideration of narrowly tailoring the restrictive that's subsequent to the statutory change in October 2021 and the holding in Strober addressing the pre-October 2021 statutory language that footnote 1 of said opinion commented upon the broadening of the definition of cyberstalking. As a result, this court included an addendum to the standard form injunction issued by the court on 12/6. As of that date, there were no other reported appellate opinions. So he's not even talking, he's just so hyper-focused about everything other than the merits. He's like, I'm not removing myself. I am good. Leave me alone. This case continues with me as the judge. This court again modified the language of the addendum in conformity with such rulings and more narrowly tailored the restrictions in consideration of the protections of the First Amendment. Again, these rulings adverse to the respondent are legally insufficient to grant the relief being sought, removing me from the case. Therefore, it is ordered on a judge whether the respondent's second sworn motion to disqualify hereby is denied. February 14th, Judge DeThomasis. Certificate of service sent to Shockett, Silverman, and Feather. That's it. Wow. So if you guys want to read the second motion at some point, I'm more than happy to review it. Again, I think it's going to repeat a lot of the stuff that was said in the third motion. That's why I kind of skipped over it. It was like 20 pages or something. I just did not want to waste your time. This has been a 5-hour live. 5 hours we've been together. And look at that. We're making perfect time. What the hells are going to be live in literally 4 minutes. Can I like bounce you guys to their channel? How do I know there's a way to do this because I've done it before. I want them to get, I want to share the love. I want to share the love because they deserve everything right now. They deserve absolutely everything. Where is it? I know it's somewhere here. At a fundraiser, shorts remixing type education. Is it under customization? Redirects you to keep viewers engaged across multiple events at a live. Here we go. Perfect. Search videos from other channels. Here we go. Upcoming. Save. So as soon as I end this, you guys are going to be literally shifted over into the live that is going to be happening in 2 minutes. 2 minutes. So thank you all for joining. I hope you all learned something. I hope you all enjoyed this. Thank you, Megan Fox Ryder, for joining me. Don't forget to subscribe to her channel as well. Ray Bone Crusher, I'm sorry, bud. We couldn't get you to 10K subscribers. I think they call it the bronze play button, even though it doesn't really exist. There's only a silver. There used to be a bronze when YouTube was much, much smaller. But as soon as I end this live in about 60 seconds or so, all of you who are still here are going to be automatically transferred over to What the Hales if I did things right. Again, I've done it before, so I know it works. It's a redirect. Yeah, I checked it. I double checked it. I triple checked it. I'm going to refresh just to make sure it's still there. Customization. It's on there. It's on there. It's on there. So I'm going to bump you guys. Thank you all. I love every single one of you. Bone Crusher, we're going to get you to 10,000 next time. Megan Fox, we're going to get you to 30,000 probably today. And of course, definitely by Tuesday. And Dead Umbrella Guy tomorrow. I'm going to do a couple more videos. I'm going to do a video on Judge DeThomasis separately. And I'm also going to be doing a video on Lynette's injunction. She filed the injunction. Let's read the original. We want to read what her allegations are. Oh, from the horse's mouth, you guys. We have the original. We have the original. On your way out, don't forget to like this video, comment below, subscribe to the channel. I love every single one of you. Thank you, Paul. As a retired lawyer in the UK, I'm disgusted by the judge's actions. Susan Paisley, thank you for becoming a member. Noah Meeman, thank you for your donation from Australia. Full support. What the hell is hashtag buckle up, bitches? Debbie Childers, Larry DeSantis appointment, Judge DeThomasis. Aha. Okay, there we go. Thank you, guys. Love you all. I will see you all tomorrow. And Godspeed, everybody. I'll see you soon. We're going to keep this going. Bye-bye. Go to What the Hales and go.